Well, consumers are complaining about a surge in prices for essential foods. The looting spree in South Africa has led to many people panic buying, worried that essentials such as bread and fuel will run out.
Following the onset of the COVID-19 pandemic and the state of disaster in March 2020, there were media reports and complaints around price increases for essential food products after we saw some panic buying by consumers. Considering the importance of food, the Commission immediately started monitoring the food markets to check on the prices. The need to look into food markets also followed from low-income households bearing the brunt of the resulting economic crisis, with essential food items making up a significant portion of expenditure in poorer households. The Commission's main findings from looking into the food markets include, firstly, the abnormal food price inflation we saw at the start of the lockdown resulted from the rand depreciation at the time and initial panic buying, which we saw disrupted normal demand patterns. Secondly, during this time, the price monitoring showed that retailers benefited the most, as we saw increases in the wholesale to retail price spreads, and the financial performance reflected higher overall profitability, mainly at the retail level. Another finding was that in July 2021, the riots and food supply chain disruptions in South Africa showed that the more longer industrialized food chains are then more exposed to volatility. This then raises the potential need for some reform to the industrial market structure if we are to achieve more sustainable and inclusive agriculture. Another finding, our food research also showed that the global trend of the increasingly traded nature of food is also seen in South Africa, as we see the trade of food products increasing in terms of both import and export value. Finally, another finding from the report is that as global food inflation remains a concern, the latest monitoring report shows from August this year, it highlights the main drivers of food inflation, being aspects that are interlinked, such as the Eastern European conflict and its effect on global wheat and maize supply, rising fertilizer prices, surging energy prices, and the current high levels of concentration we're seeing in value chains, as well as the asymmetric transmission of food prices, where we generally see that prices are quick to rise but slow to fall. For the Commission, I feel the team's food market research has shown that food prices can often be linked to local or global supply changes, generally from adverse weather events. Another aspect to monitor for the team is the impact of volatility in South Africa's food markets, especially on poorer consumers. The latest food price monitoring report highlights that price increases in imported products should not be unduly exploited by intermediaries or processors who could impose larger price increases than warranted. Looking ahead, the Commission will also continue to monitor food prices and probe essential food price increases that appear to be abnormal or excessive. The team will also monitor and assess the transmission of cost reductions to the local market, where these are due or anticipated in relation to an easing of global food supply constraints. For consumers, the food research would hopefully empower them to become more aware of significant or abnormal food price increases and report these to the Commission. And hopefully these reports can also assist consumers to better understand the country's food markets.
In a vote of confidence about South Africa's long-term prospects, New York-based food and beverages giant PepsiCo has made an offer to buy Pioneer Food Group, which makes Sasco breads and Ceres juices, in a deal worth over 25 billion rand.
The Competition Amendment Act came into force in July 2019. Barely 2 months later, Simba Pioneer merger was notified to the Commission. So this was really the first time we had to, as the Commission, consider the implications of the new amendments, particularly to Section 12A3C and Section 12A3E of the Act. So this was really the first time we're looking at this case through the prism of the amended Act, and it turned out to be a seminal case in respect of those amendments. This case provided us with an opportunity to learn a lot about how to give effect to the promotion of a greater spread of ownership. So there was a fund created which ensured that there was skills transferred to youth, small businesses and firms owned by HDPs, teaching them farming and other general business skills. There was also funds set aside to ensure that small farmers can access markets. Insofar as workers were concerned, we had to consider how they can meaningfully participate in the economy. And again, here we eventually reached consensus with the parties whereby they set up a certain percentage of the shareholding in the target firm, which was to be held in a workers' trust on behalf of the workers. And this actually equated to a value of 1.6 billion, and dividends would flow to workers from day one. So this set the template for later cases, whereby when we involve workers and worker participation, we expect that there must be no encumbrances to that shareholding and dividends must flow from day one. This case really provided a template from which we could take these amendments forward. And there were a lot of learnings. For example, we learned how to craft meaningful employee share ownership schemes that are truly transformative in the sense that they provide workers with board representation. They are unencumbered in the sense that workers can start enjoying the fruit of those dividends from day one. Some questions remain unanswered, such as, in which entity should workers participate in? Should it be an entity that is domiciled in South Africa? Can it be elsewhere? And these will obviously be further crystallized through the development of the jurisprudence. And I think we're looking forward to the conference where maybe some other views can be heard from labor, business, the legal fraternity, as to what their thinking is about how we can give meaning to these amendments.
Just to inform you, we're just waiting for some further commission officials to arrive.
Welcome.
And then we'll start shortly. Thank you for your patience.
Welcome to the Competition Commission. The Competition Commission is an investigative and prosecutorial body set up in terms of the Competition Act of 1998. We have three main functions: to investigate anti-competitive conduct, to evaluate mergers and acquisitions, and finally, to assess exemption applications. We investigate many cases in these areas, but today we'll focus on just a few exciting cases that have had a big impact on the market over the years. For instance, Musi, an analyst in the Mergers and Acquisitions Division, will tell us all about the Cashbuild and Buco merger. Analytical, the Commission's first in-house financial expert, will take us behind the scenes of the all-important PCR case that saw COVID testing prices come down. Besides investigations, we'll hear about other market interventions, like the work the Commission has done in the school uniforms industry and the guidelines the Commission facilitated in the Automotive Aftermarket. So, let me not waste any more time. Over to the analysts.
As mentioned, we're just waiting for a couple of Commission officials to arrive. Their bus unfortunately left Pretoria a little bit after they had planned, and there was a bit of traffic, but we should be starting shortly. Thank you for your patience. Oh, are they changing the wheel?
Service providers they can use to repair their motor vehicles, and also for the products that they can buy in the automotive aftermarket. With the implementation of the guidelines, consumers can choose to have their motor vehicles repaired by a service provider of their choice. whether an approved service provider or an independent service provider, such as a panel beater, service center, or approved dealer. They can also choose to fit original or non-original spare parts in their vehicles without voiding their warranty. They can also choose to purchase service plans, maintenance plans, and other value-added products at the point of sale when they buy a motor vehicle, or they can choose not to do so. With our engagements with industry stakeholders in the sector, we pay particular attention to introducing measures that would increase participation by small businesses and disadvantaged groups. With the implementation of the guidelines, it can increase more opportunities for small businesses to service, maintain, and repair motor vehicles that are covered by a warranty. It also increases their access to original spare parts that are sold by car manufacturers, and also allows them more opportunity to become approved dealers and approved repairers on the panels of car manufacturers and insurance companies, as well as increasing their access to training by car manufacturers and also the technical information that they need in order to repair in warranty vehicles. There is still more work to be done. The Commission is currently monitoring the steps that are being taken by the industry in order to implement the guidelines. We are also engaging with industry bodies and associations that have supported the guidelines and are promoting compliance. And towards the end of the year, we intend to introduce a survey for the industry stakeholders to answer, which will allow us to assess the level of compliance with the guidelines by the industry.
The Commission's advocacy work relating to service provider panels in the banking industry actually began with the engagements between the Commission and the banking sector in 2018 and 2020, where the Commission had identified competition concerns with the bank's conveyancing practices. And those engagements led to the country's largest banks offering undertakings or commitments to revise their practices. And that enabled competition in the procurement of legal services by the banks, and the banks gave undertakings which meant that they would refrain from locking in law firms on their panels and open up opportunities for smaller and HDI law firms. The Commission has recently issued a practice note in February 2022. The practice note sets out key principles for promoting competition and inclusivity in supplier panels of banks and insurers. And this came after the Commission consulted the industry in a closed workshop. With the practice note, the Commission intends to encourage reforms of practices and adoption of key competition principles by banks and insurers, which would ensure that when they appoint service providers for all of their panels, they adhere to these principles. And it's important to note that the banking industry and insurers actually procure these services not only for their consumption, but also on behalf of their customers. So these interventions came about due to complaints received and investigated by the Commission, which first revealed there was a prevalence of exclusionary conveyancing practices in the banking sector. For example, the terms agreed between banks and law firms for conveyancing work prevented law firms from taking on instructions against the banks in instances where they have concluded service level agreements with the banks. But also the Commission had received complaints which had revealed that there are concerns relating to the unfair appointment of work to service providers, and that the allocation of work was actually not fair and inclusive. So from these complaints, the Commission then found that certain aspects of these supplier panels raised competition concerns to the detriment of consumers, and these issues related to long-term exclusive agreements, as well as barriers which prevented the entry and participation of SMEs and companies owned by historically disadvantaged individuals. The
Good morning. Mr. Majenge, are you well today? And not feeling the effects of yesterday? There was so much heartfelt love, outpouring. Hey, Mr. Paladi, advocate Paladi. I see our colleagues coming in from the back. We hope not to start without them. Good morning, good morning, good morning. Good morning, good morning, good morning. Good morning, good morning, good morning. Thank you. Oh, there's an old friend. Hello. I'd invite you all to take your seats. Good morning. Good morning. Hi. Just going to let the love flow over. You know, this is a good problem. It's that we love each other so much. We haven't seen each other for so long. We just can't stop. It's a good problem to have. It's a good problem to have. Advocate Paladi. I know he's getting work, maybe. All right, I'm going to get started. Thank you all for your patience. That's the first thing I'll start with, because I know we haven't started on time this morning. We wanted to make sure that we had as many people from the Commission here as possible, as they are the co-hosts today. For those of you who don't know me, my name is Mpumelelo Chabalala. For the Ngunis in the room, yes, I do have a man's name. That was intentional by my parents. They gender bent us all. And for those who struggle with Mpumelelo, to our Russians in the room, you can call me Mpumi. I'm happy with that. Thank you. Songezo introduced me yesterday, and he was so generous. And he said, everything that he's done, I've done better, which, you know, maybe I have. But what he left out was where we met. He and I met at the Constitutional Court of South Africa, and I arrived, and Songezo was part of the team of clerks who were there receiving the new team of clerks. And in addition to that experience and all the other experiences he mentioned as part of our accolades yesterday, one thing he didn't say is that he went first. He led. And though I may be doing it better, I do it better because I had someone to follow. And similarly today, there's so much symbolism about that. Yesterday, we've got this beautiful symmetry. I think it was planned that way. Yesterday, we had a male MC. And today, you have a woman MC. Yes, yes, yes. Yesterday, you had a male commissioner. Today, you have a woman commissioner. Yes. 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 And following in the theme of symbolism, I'm wearing green for the first of spring. I'm wearing green for new growth, just like I promised Doris. That, you know, it's like a sprout coming from the ground. And in addition, I will just hype up some South African small businesses from which I got my outfits. Please feel free to ask me where I got them so we can advertise those businesses, because that is also so much a part of what we love about what we do here. So Songezo and I go back quite a while, and we've had many disagreements. But what I love about him is we have a sort of brotherly, sisterly, familial love. And what I like is that kind of container means that you can argue and fight with passion and with your principles and with vigor, but you always return back to the mutual respect and the fact that you come from the same roots. The roots of kind of having the same vision and really ultimately the same goal. though we may disagree about how to get there. And it's in keeping with that spirit that I hope the handover happens at the Commission. I'm very different to Songezo. I'm not as stickly about time, but perhaps, we can encourage and think about this transition at the Commission in the same spirit. That we want to encourage a new wave of thought that's not about rejecting the past or hating the past, but rather vigorously engaging with it and saying, this is my stamp on where we're going to go for the future. And we do that because we do that from the same place of love. Why? I mean, Tamara said it best last night. She said, the thing is, we love our people. We do this work because we love this country and we love our people. And that is the foundation with which this handover is taking place. So a couple of administrative things. If you want some Wi-Fi, the Wi-Fi is called @Santon. There's no password. You can just jump onto that. The toilets, I hope you found them. Some are on the right this side and at the back on the right. And we have a YouTube live stream. So if any of you have colleagues who couldn't join us today, they can just jump onto the YouTube live stream and be able to see what's happening in real time. So I can see there are some new faces in the room, some people who didn't experience what we went through yesterday, and I'll take you quickly through a couple of themes that were highlighted. So first and foremost, we heard from the Minister and Thembi Nkosi. I think Thembi will be continuing on some of the themes that he brought up in his first address to us yesterday. One of them being institutions matter. And that is the first plenary we'll be having today, thinking about how to build strong institutions. We'll hear more from the former commissioner on that. The minister gave us amazing updates, one of which was that he's publishing regulations on ministerial involvement in merger control, which I think is very welcome to business. We've been criticized for perhaps executive overreach, and I think that this is a welcome development to be able to assure the international community that, involvement need not mean overreach necessarily. And I think that I hope the regulations will provide some guidance on that. We heard on concentration in the South African society, and as Songezo pointed out yesterday, it was about 4 hours before we heard from our first brilliant woman yesterday in the form of Pam Mondliwa, as well as the remaining members of the panel. I certainly know that Pam has many a fan in my colleagues sitting on the corner. We also heard about regional integration and the African free trade, the African Continental Free Trade Agreement. Thinking about ideas around, how do we meld, and I think the rubber really hit the road on this project when there come those moments where there's national interests that may or may not conflict with international ones. I think as South Africans, we may need to think quite deeply about whether we're going to be short-term in our thinking on that or long-term, and what would be most beneficial for us in either scenario. We also spoke a lot about the global food crisis. And, this is the benefit of these kinds of conferences. Because, I was at the tribunal when we did the price gouging implementation and the COVID consents and complaints. But it was only while listening to the panel on the food crisis and climate change that I was like, price gouging is going to be pretty important when we're thinking about climate change and food shortages. So there's so much ambit for our work to be able to serve people. And finally, we heard from those who wrote a book. Unfortunately, we only had one copy of the book because of the global value chains that they were discussing right on the stage. And thereafter, we had a beautiful gala dinner where again, I think one of my highlights of last night was being able to see grown men express admiration for other grown men. And that made me think, you know what? Masculinity is growing. They're joining us. Let's love, you know? Okay, so jumping into the program, we are starting where I'm sure you all have been dying to start, which is, who is the new commissioner? But not just what's her name or what's her accolades. Who is she? We really want to know. And so that is what is first on the agenda today. So fitting. It is her first day in office. It is the first day of spring. She is the first woman commissioner. And on that note, I invite you and former judge, retired judge, sometimes an office judge, Dennis Davis, to the stage. Thank you. Please join me in welcoming them.
Let me start, firstly, by saying, as I indicated you, Commissioner, which is what your name is now, that this is not a judge for yourself program, and it's not my job to cross-examine you. But it is my job, it seems to me, firstly, to congratulate you. I think the explosion of enthusiasm indicates the most remarkable feature, which is, and the minister made a point last night, which I think is absolutely right. It's easy to appoint people, but very difficult to appoint really great people. And to have had Tembi and now you, that's an achievement of the minister. I have to give it to him. So let me start by saying, you and I go back a very long way. You think it goes back further than Carefan, which was in the 1990s.
Good morning, Judge Davis.
Yeah. You've been very polite.
We had a debate whether I have always called Judge Davis Dennis, and whether today I call him Judge or I say Dennis, but I'm sure I'll use it interchangeably. But firstly, I just want to say good morning to everyone and thank everyone for coming around. And thank everyone for the welcome. It has been quite overwhelming, and I really appreciate it and look forward to working with each and every one of you. Dennis, I did meet you as a candidate attorney at Cheadle, Thompson and Haysom in 1997. It was quite remarkable for me as a candidate attorney because we were doing an important matter. It was the certification of the Western Cape Constitution. It was a matter that had to go before the Constitutional Court.
That's right, yeah.
Yes, and in that matter, for some of you who would not know, at the time, Dennis was still practicing as an advocate at the bar. And you were led by Gilbert Marcus in that matter, and I was the candidate attorney in the matter, and it was quite fascinating for me, yes.
But the one that I do want to talk to you about, because it seems to me, mention was made last night by David Lewis about Tembi taking, I think, one of these merger cases, and why I want to go to the Carefan case, because a lot of people won't know, and they need to know this. So Carefan, Advocate Ngotoibi, who practices in this area, will know this well, was a leading case dealing with the question of the review of the CCMA, etc. And I got a phone call when I was on sabbatical in London from your senior partner, Cheadle, to say, would I take the case? I discovered I was the 27th person that they'd approached. But so that wasn't the point. Point was, I said yes. And then in typical style, Cheadle disappeared. And you were a candidate attorney. But if I remember correctly, you actually conceived of the argument. It was you who kind of fixed up the heads and the papers. I am right about that, I'm sure.
Actually, it first happened in the Western Cape Constitution, the certification of the Western Cape Constitution, because one of the arguments we had to talk about was the definition of structure. And I remember working the whole night in typical fashion with Halton Cheadle, was Nikki Howard, who was an associate at the time working with me, and Halton had to work the whole night to work up the arguments. And we did that, and in the morning, Nikki said to me to tell Professor Halton Cheadle what the argument was, and he said, "Oh, where did you get that? You are a candidate attorney, you could not have come up with that argument." And needless to say, he had to buy me a cappuccino because it turned out that I had. But I think what is important, Dennis, is to talk about you and Carephone and how you found out that you were like the 21st senior counsel we had looked for in that matter, because our papers were late and we had to do a condonation application. And in the application, which you had to argue, you found that we had looked for all advocates who we thought were appropriate advocates at the time, and we couldn't find them. And you were our last resort.
Yes, correct.
At the time, yes.
That was why I depended on you. So I want to just talk about Cheadle Thompson, if I may, because there's a curiosity here. Your predecessor, Nkosi, was a Cheadle Thompson. You're a Cheadle Thompson. What is it about Cheadle Thompson and Haytham that essentially, which was, to the best of my knowledge, and he's one of my closest and dearest friends, well, in fact, they all were, Cheadle, Thompson, and Haytham. I don't think one of them would know the first thing about competition law. So how on earth did it happen that we've landed up with two commissioners who, and particularly yourself, how did your career come about that you worked in a firm which was ultimately a labor law firm? And now, in a sense, like your predecessor, you become a leading figure in the competition world. I mean, what was it about that firm? The experience? Was it the way they litigated? What was it about the firm that you took with you through your career?
So the firm is a very interesting place for anyone who's worked there, and it's not just Tim.
Well, you ended up being the senior part, the chair or the senior partner.
Indeed. Yeah. So there are many trailblazers in the competition law field who came from Cheadle's. Justice Norman Manoyem, who was together with Dave Lewis responsible for the Competition Act we have now, together with tribunal member Yasmin Karim, who happened to be my supervisor at Cheadle's. And I just wanted to let case managers at the tribunal, don't worry, what she's doing to you, she did to us at the firm. Yes, it is so typical of a tribunal member, Karim. I did warn her that I was going to tell people about her behavior. And of course, you had the chairperson, the current chairperson of the tribunal. Most people do not know that Mondo Mazwai was a candidate attorney at Cheadle, Thompson and Haytham, and an associate, in fact, at the firm. She was a year, in fact, ahead of me, having been a year ahead of me at university. So she was a sister and a leader in the firm. The thing about the firm is this, Dennis, is that the firm throughout its existence sought to use the law to achieve social justice. That was at the heart of what the firm was. So to the extent that we practiced labor law, it was in order to achieve social justice. And it was befitting that you would have people like Norman Manoyem, due to the human rights work that he was doing at the firm, that they would write the law. And so because we were privy to the to the drafting of the competition law and competition policy, we were privy to some of the workshops that happened and how we wanted to use competition law as another tool to achieve equality, inclusion in the economy of South Africa. So it is not surprising, in my view.
Yeah, I mean, when I listen, of course, you're quite right. All of these people treat Thomas as a real case of abusive dominance. But let me ask you this. I mean, there are two questions that flow. The first is this. Both you and Thembi strike me as incredibly organized people. When you were... Thank God for you. Brilliant. I kind of knew then that you were going to go places. But how is it the two of you who kind of really worked in this chaotic firm? Because although Cheadle is probably, in my view, the most strategically brilliant lawyer of my generation by a country mile, organization isn't his forte, right? And so how is it that you guys were so, you're so organized and so kind of systematically, I mean, it couldn't have been through the firm, for goodness sake.
It was, actually. Hudson was an amazing brain. Yeah, sure. He really was. And one of the things I learned when I was managing the firm was that, in fact, as a leader, you need to look at the best skills and assets that your people have, and to the extent that there are flaws, how do you help them to get the best out of them and give them the support they need? And that's what someone like Nikki Howard would have been, someone like me would have been, to provide that support so we could get the best out of the mind of someone like Hudson Cheadle. And it was an honor to work with him.
No, it's a great point. And I should say, apropos the Carefund case, because I want to move on, is that what was amazing to me about that case, and you may not remember, was you and I sat there for hours on end and we cobbled together the argument. And then Cheadle reappeared, as he would, right at the end, to tell us that we were completely wrong and that it was complete rubbish that we'd written and that he wanted to do it. And you stood your ground and said no. And we actually stayed with the argument that you did. And in fact, to be perfectly frank, if the court had accepted your argument, not mine, the law would have been a lot more coherent than it had become, thanks to Cameron and Meyerberg's rather incoherent effort. But that's another matter. I want to just ask you this, though, from your strategic point, Doris. Not only do I take the point, I think it's an incredibly important point that you've made, and I want to capture, if I may. This point that that firm and all of you who were part of it were part of a strategic operation. You kind of understood incremental change in labor law. You started with the basis that if you could get, and I see Tony Enrach that would know this well, if you could get, for example, union people into the factory, you could then get other rights, the rights to consult with workers, rights to have meetings, and eventually you get to the right to strike, and eventually you get the full panoply. I'm struck, you talk about competition law in the same way, but would I be right in saying we haven't quite seen that same sort of strategic exploitation of competition law in the way that you guys did labor law? That kind of incremental thing where you've got a vision as to where you want to go and you do it in baby steps, if I could put it that way.
I don't know if you are right, Dennis. I do think that maybe it's not at the speed we want to. And I think Dr. Simon Roberts raised that issue yesterday, the urgency with which we need to be moving in getting to an ideal situation. But I think there have been baby steps towards what would be an ideal economy where we have participation, where we have inclusion in the market. But I think we are working towards that, and I think there's been a lot of jurisprudence over time, which you have been part of, and the work of the Commission, I think, has been quite incredible in that way. And I think we will get there. I was remarking to James Hodge earlier to say, you know, someone is right. We are not going to, we don't have 10 years to set precedents on the new amendments. For example, there is an agency, we are in a crisis, our economy is in a crisis, and in order to make sure that the outcomes you're talking about are realized, we're going to have to move a little bit faster. And I think what the Commission did, together with with the Tribunal and the CAC during this COVID crisis, was to show that there is capacity to try and deal with matters as efficiently as possible, to try and deal with the problems we have. And I think if we could learn and use those lessons that were learned in this period to try and implement the amendments, we could deal with the issue that Dr. Simon Roberts raised yesterday of agency, which I think is quite true.
No, I think that's absolutely right. And just to make a comment on, just to enforce your point, I've been struck by the fact that what all of you who in that law firm did was so revolutionary. If you take, for example, constitutional law, I don't see the same strategy. I don't see people having worked with the Constitution to kind of expand the rights to get there, in the sense of it's much more higgledy-piggledy. But I take your point in relation to competition law, and it's encouraging. I don't want to ask you on your very first day in office where you actually think the trajectory is going to go. If you want to answer, that's fine with me, but you don't have to. But I do want to ask you this. You are quite unique in the sense that, I mean, Tembi might, if I can't, he'll correct me if I'm wrong, but you are somebody who's actually litigated competition cases on both sides. So that puts you in a kind of unique position. I mean, I don't think anybody else has had that. And I'm just interested, what do you take from that, from your own experience? And we can come to some of the cases that your favorite cases. But what is it that, I mean, you've seen both sides. So I mean, you bring to the Competition Commission that kind of set of insight. And I'm just interested as to what you take from that experience of being both sides of the fence.
Tembi spoke a bit about some of the cases we did when I was at the firm. In fact, it's the introduction to competition law for me personally was from my experience as a constitutional lawyer. In fact, I think Mondo Mazwai got us to get involved in one of the first challenges to the Competition Act, constitutional challenges in Federal Mogul. You'll recall Federal Mogul was charged with resale price maintenance.
I do remember that very well.
And the tribunal found that they had contravened Section 5.2 and imposed a measly fine of, I think at the time, 9 million or 3 million rand. And what Federal Mogul did was to come to the Competition Appeal Court to say that Section 59 was unconstitutional in that imposing penalty which were criminal in nature and not administrative. And so that was my introduction, in fact, into competition law at the time, was to deal with the constitutionality of Section 59. So it was quite an interesting way to get into competition law through that. But the other way was through the trade union movement in major proceedings, as you would know. And I'm quite grateful to the trade union movement for actually pushing me to get involved in that. So what that did for me, Dennis, is that it allowed me to see the operations of the Commission on how they run their own cases, but it also helped me to see myself on the other side when I'm litigating against the Commission. And I have to say that, I mean, the Walmart merger is one case where there was opposite views with the Commission, particularly with Commissioner Bonakele at the time. We literally came and were quite vociferous in saying that there should have been conditions and conditions relating to employment, particularly for the trade union movement, and I think that was a very important.
So, what did you? I mean, I want to talk a little about the Walmart case because, you know, we learned last night. The Minister talks about all these cases that were settled, but frankly, not one of those cases could have gone the way they did without the Walmart jurisprudence. That is the underpinning of all of these cases, whether we like. And you were central to that because you were the instructing attorney for the unions, if I'm correct.
It is correct.
So what did you take out of that case? Now that, I mean, what do you think was, what were you happy about, what were you disappointed about in that particular case?
So I think before that measure, Dennis, there was the Metropolitan Momentum Measure.
Yes.
And I think in that measure, the tribunal almost clarified the sort of steps you needed to take when you dealt with Section 12A, and that you had the competition inquiry, but you still had to go to the public interest inquiry. When they implemented the Walmart measure, and you rightly in your judgment in Walmart were deviating a bit from the momentum test, but you then got it right in Walmart. And I think for me, there are a couple of things that I will say about Walmart measure was participation in that measure was very interesting to see the unions participating in what would be regarded generally as a business transaction, and that in having workers as part of discussion about the economy because they are participants in the economy, and that what we got out of it was the implementation of public interest provisions of the Competition Act, and I think that got clarified. And in fact, if you look at the measures that have subsequently come, often merging parties will in fact provide you with those conditions and the guarantees that were in fact solidified in the Walmart measure.
But I'm just interested because instructing attorneys, contrary to the conventional wisdom, are often the crucial player in this. In fact, my own experience of 20 years on the bench in competition law is often the attorneys know a hell of a lot more than some of those counsel argue in front of us. And no disrespect to certain people in the room, right? Perfectly competent, I'm not talking about them. I have a category of people I have in mind. But the point I'm making, which is important, is there was a very sophisticated argument that you people developed, and to great credit to James Hodge, who was your economist, but it was your side that tried to give us some evidence about balancing, as it were, price decreases that Walmart could give against the loss of jobs and small, medium-sized businesses. I mean, it does seem to me that issue is not gone away. It's still there.
Yeah. Firstly, to your point about attorneys, I think what had happened, and this is credit to Chido Thompson and Haysom, is that the lawyers at Chido Thompson and Haysom know that you are not a passive participant in litigation. You are at the heart of litigation, and that the support we get from counsel is quite useful, but you need to know what you want to do for client. And I think it is a lesson we learned, and in fact is part of why Tembi would have stood up in the Sasol engine measure and would have argued the matter. We'll come to Tembi a little while later. But I just wanted to say this, Dennis, is that we were the trade union movement, and I need to give this credit to the trade unionists who were involved in the matter. We could all take the glory as lawyers, but they knew what they also wanted. They are the people on the ground, and if there's anything I learned in my time as an attorney doing labor law, was that it is the shop factory workers who know the operations, who know how the business are run, and who are at the forefront of this. And it was, in fact, them who explained the evidence you are talking about that came, that is what we were weighing up in the Walmart measure. Just point of correction, Dennis, I know you don't believe me, but James Hodge actually was the economist for the minister. We used the evidence he led at the tribunal as the trade union movement, but actually he was the economist for the minister in that matter.
I thought Stiglitz was, but I can't remember now. I'm going. Anyway, doesn't matter. But he did make that argument, and that argument was presented, yes, and it was a very important argument.
It was a very good argument.
I'm told I've got a little time, so let me move on to another topic. You were part of the ministerial team which advised Minister Patel with regard to the amendments. There is a sort of irony about this all, isn't there? Because this is a whole range. I mean, the proposals of your group were influential. Now you're going to have to implement them. I bet you didn't realize that at the time.
I didn't, and I will. I nearly said regret, but I won't. But just to say, Dennis, it was an interesting time. The work that we did under the leadership of Michel Leroux was quite helpful in getting us to be here. And I think it was at an appropriate moment. We have had so many years of the implementation of the Act since its inception. And so we needed to look back and see, have we achieved what we needed to achieve? Are there gaps in the legislation to help us achieve what we want to achieve? And it was appropriate that at that time we would have these significant amendments. It is ironic that I now have to come and implement them, but I guess it's also a good moment for someone to come in. And so for me, what the amendment represent is a mandate, a clear mandate on what my role should be at the Commission when I arrive.
But can I just ask you one question on that? It does mean that you kind of almost uniquely placed this extent, that I'm assuming that when your team that dealt with these would have debated something which was absolutely profound, is where does competition law begin and end? Norman Manoia made a point in Walmart, which I think is well worth re-articulating, that competition law can make a significant effect, but it can't change the world alone. And he's right. So you must have had to debate and consider the boundaries of the subject that you are now going to be the crucial administrator of.
Dennis, you are right, but I think as the minister said yesterday of Tembi, we need to push boundaries, and it is an important thing to do, because we could, in effect, have left competition law or major regulation just within the bounds of consumer welfare, but we didn't. We chose a transformative agenda as a country on how we implement competition law, and so in that way, while the law is your parameters, the approach, which should be based on constitutional values, remain. And I think we, as practitioners and as adjudicators, we need to bear that in mind, that we are, and you said it in Walmart, we are using competition law to deal with some of the impact of the past that we've had.
I have one final question, because I'm told I've got to finish. There are many other things I wanted to ask you, but this question is not necessarily applicable to the Competition Commission, but it is relevant to the community. It's a point that I've banged on about for many, many years, are briefing patterns. Now, why that's important is because unless you give people exposure, you don't get specialist judges and the whole thing collapses, and tribunal members, frankly. And I know the Commission's done well on that, but does it give you some anxiety that we're so untransformed in the broader competition community? The Commission is far ahead of the game. But I'm not talking about the Commission, but you do represent the communities, and you have been on both sides. So I am interested in your view.
Yeah, so Dennis, I think that's a debate not just in competition law. As you know,
agree.
I serve on the Judicial Service Commission, and it's so interesting every time we get either black advocates or black attorneys. The constant complaint is briefing patterns, and it is a complaint that has been there for a while, and I think it's people like Tembi, Mondo, Yasmin, who show that opportunities presented to the broader community can benefit us all, and all that is required is to provide people with those opportunities. And it should concern us all, not just the Commission, but
I couldn't
all.
agree more. We have two senior counsel here.
Yes. I'm trying to avoid that conversation.
No. But I mean, it's an
yes.
important point. I mean, we've got two senior counsel here who basically totally evidence, compelling evidence for the point. By the way, just finally, do you have to resign from the Judicial Service Commission now?
It is not relevant. It's a conversation I'm having with the Minister of Justice and the Minister of
No, many of us would like you to continue on that, I assure you. There are not that many voices of sanity there, and you are one. But
I am not speaking for the Judicial Services Commission for purposes of this discussion, Dennis,
but I
will not comment.
But I think what this issue has illustrated, right, the whole discussion that we've had, and I'm getting beyond time, is just, if I go through, I mean, from labor law, and by the way, just why did you do tax?
Dennis, that is such an important matter. I actually I was wanting to do a master's, and I was debating with Judge Manoem at the time whether I do a master's in labor law, and the point was all the professors who could teach me all the best labor law were at the firm, so I needed to look at another area. But it was very interesting because my dissertation, when I was doing my master's, was on employee share ownership schemes and the tax implications of that. So there was still a societal justice issue, even in my master's in tax law, or the interest I had at the time at least. Thank you.
So let me conclude, because otherwise the chair here will start screaming at me. I just want to say this. Last night it was a very invigorating celebration of Tembi. I have no doubt that in 5 or 10 years' time, hopefully I'll be around, there'll be a dinner for you, and the same level of accolade will come your way. In fact, it's probably true to say, just listening to Doris's, the vast level of experience from labor law to tax law to competition law to constitution law is just wonderful. Because the one thing I think we always forget is you can't compartmentalize law. The best lawyers are ones who are able to have a large vision and can lift their gaze. And that's what I think our discussion has shown the audience that you have. I cannot tell you what joy I have in saying on your very first day, congratulations, it's a wonderful, wonderful thing for the country that we have somebody like you to actually lead this commission. It's an extraordinary statement for gender and racial equality in our country, and more than that, it shows this. If you only look We've got talent in this country that sadly we so often ignore at our peril. Congratulations. I look forward to watching you perform miracles in the competition space, just as your predecessor had done beforehand.
Thank you, Dennis.
In all honesty, I'm having feelings. I've got goosebumps, feeling a bit emotional. Oh, man. I am so excited. What we are going to do with our act. We are going to make it live. We're going to make it thrive. We're going to make it breathe. Okay, on to the next topic. We've got plenary 4 happening now. And the topic is building state institutions, looking back over the past 9 years and lessons for Africa. I think, yesterday we were talking a lot about the implementation of the African Free Trade Agreement, and one of the things that came out of that discussion was a strong emphasis on the importance of having good enforcers in the various domestic areas in which the Regional Competition Act would have force. So in that spirit, I'm going to invite my panel members for panel 4. We have as our kind of chair of panel 4, or plenary 4, Ms. Mondo Mazwai, the chairperson of the Competition Tribunal. We're ready for you now, Mondo. Please do join us. Thank you. And as our panelists, we've got the former Commissioner, Thembinkosi Bonagele. We've got Francis Kariuki, the head of the Competition Authority of Kenya. I am so glad to be hearing from our neighbors. Or not quite our Makelwanes exactly, but like jump a couple states. We've got Derek Schwartz, a professor at NMU, who'll be joining us as well as a panel member. And I understand virtually we've got Bill Kovacic, who I'm sure you're all very familiar with, a professor at GWU. So yes, he will be joining online. And I hand over to you, Ms. Mazwai.
Good morning, everybody, and welcome to this first plenary for the day, which is building state institutions. And I think it's apposite that we jump straight into it after the conversation that was had towards the end of the discussion between Dennis and Doris about capacity and building institutions, the legacy that Thembi has left, and the legacy that we hope Doris is going to leave, and I'm sure and have no doubt that that will happen. Congratulations, Doris. I'll take the opportunity while I'm on the podium to say 1st of September, new beginnings, first female, monumental. Welcome, Doris, to the competition authorities. So the topic of discussion is building state institutions, and in particular, we're looking back at the last 9 years, which Thembi has been at the helm as the Competition Commissioner. So we're going to look at lessons learned from that. And we have a panel that needs no introduction, and I'll come to that in a moment. So the purpose of this discussion is really to review the Commission's work. I won't test your memories. Last year we had a similar topic, but it was about building state institutions for inclusive markets. And so today the focus is really mainly on the achievements of the Commission and what we can learn from other counterparts in other jurisdictions. So we're going to start then with introducing the panel, which I don't think needs introduction. Those of you who were at the gala dinner last night will know that Thembi is a rock star, has been described as a rock star, and I echo that description as well. And so Thembi is joined by two iconic figures in competition law. And the first one is Francis Kariuki, who is the first Director General of the Competition Authority of Kenya since 2013. And then the second is Bill Kovacic, who is a doyen of competition law in the US and is well known to many. He is a professor at the George Washington University of Law and has held many different titles at the Federal Trade Commission and more recently as a non-executive director of the Competition and Markets Authority in the UK. So we have the right people to be talking about this topic. And the reason the choice is that way is because each one of them in their own way are coming to the end of their tenure. Thembi's came to an end yesterday, and Francis's comes to an end at the end of January, and Bill's term came to an end in March this year. So they have a lot of insights they can provide as to what their views are on building state institutions. So without further ado, I'm going to open with a very broad question to each of the panelists and ask them to just tell us about what the successes and challenges are of building a high-performing institution. And then we will break it down from there. I'm going to start with Bill. I must say that and send Bill's apologies. Up until last Thursday, he was going to be joining us physically, and unfortunately, the storms in the US and in Washington, D.C., where he is, made it impossible for him to get his flight on Tuesday. So as we speak, Bill has had to be up early. I think it's about 4 a.m. where he is. And so, Bill, thank you for still making it possible to connect with us, and thanks to technology as well for making that possible. So I'll start with you, Bill. If you could then answer that question, what are the successes and challenges of building high-performing institutions?
Thank you very much, Mondo, and congratulations to Thembi and Francis for running the race with such distinction and carrying the baton to a new generation of leadership so brilliantly represented in the presence of Doris, as we saw in the previous session. My apologies again for the distant participation, and were it not for thunderstorms. Of course, we've had meteorological thunderstorms and political thunderstorms in Washington. The meteorological thunderstorms kept me here, but I'm dearly wishing that I was there with you in person. Mondo, let me mention 4 features of the experience in South Africa and in other jurisdictions that stand out for me in building successful, productive institutions. The first has been a theme of the conference and our session earlier today, and that's the crucial role of leadership. It's simply impossible for a jurisdiction's competition system to prosper without a commitment of the political leadership to put the best possible people in the senior leadership positions. Without that, the system can't survive. If it were Formula One racing, you can have the best car on the road, but if you don't have a good driver, you will not achieve the greatest success. And I think it is a testament, not simply to South Africa, a powerful example to the rest of the world, to see how the nation has placed its very best and very brightest and most capable in the senior leadership positions of each of the major institutions responsible for enforcement. Tembi and Francis, in the case of Kenya, would not say this themselves. They're too humble. But as an outsider, I would say it has been a powerful demonstration to the rest of the world to see what superior leadership is able to accomplish. So a vital foundation for success is the selection of good leadership. And I would say when you look at the experience of 140 jurisdictions with competition laws, you see a very uneven commitment among governments across the world to put people of such capability and distinction at the head of their agencies. So that's an enormous advantage for South Africa. Second, a system only prospers with periodic upgrades. The entire area of policymaking, as is the case with so many other areas of economic policy, is inherently a process of experimentation. Testing different approaches, seeing how they work, assessing the quality of performance at any one moment, and deciding what to do better. I would say that if a system is not achieving upgrades roughly every 4 or 5 years, it's falling behind. And that's especially true as it tries to deal with highly dynamic commercial markets. In other words, if agencies cannot be as innovative and progressive in developing new capabilities and achieving upgrades as their private sector counterparts are in introducing new products or services, they will inevitably and irretrievably fall behind. So a second powerful lesson from the South African experience, echoed in many other jurisdictions, is that the process of achieving upgrades is indispensable to the effectiveness of the institution over time. And the only way that you get grades is to go through a process of introspection, self-assessment, that asks yourself in a very unsentimental and honest way, how could we be better? Where do we have deficiencies? Where do we have strengths to be reinforced? But only through a careful process of self-assessment and honest evaluation are the areas for improvement identified. And that culture of exposing oneself to improvement and to rigorous self-assessment is an indispensable part of good agency culture. The third ingredient is building the resources and the team necessary to do the job. The chair of the institution can't do it alone. The senior leadership suite can't do it alone. No agency can be successful without a deep team in the administrative and professional capacities to do the work. I would say it has been the experience of South Africa to gradually improve the team. I think a threat to the performance of the regime in South Africa, and perhaps in Kenya, and most certainly in any country, is the ability to maintain a professional staff that has the capacity to work effectively in the many challenging areas that the Commission seeks to work. And that is especially true as it pursues more ambitious measures. The more ambitious the program you undertake, the indispensability of building the team in order to go with it, and this requires a commitment of government once again to provide the resources to do the job. It is a hollow and ultimately cynical act by political leadership to demand the highest performance of a competition agency, but not provide the means to do the job. So a continuing test for any system is, are you willing to pay for it? And to put the very best people on the field. The The last item I would mention is the long view. A difficulty, I think, in public administration everywhere is to focus the attention on today's leadership in the future and to pose the question, what investments are you making today to make your successor's life better 5 or 10 years from now? And I think one element of the South African and Kenyan experience as well that stands out for me is that in working Francis and Kenby, you have had an evident eye on the future. Do not have a short-term mercenary perspective that simply says, what's in it for me? And how can I build a better landing place for myself when my mandate ends? Instead, I think a continuing question and attitude in the minds of these leaders and good leaders elsewhere is, what about the future? And that focus on the future induces you to keep asking questions about improvements, about getting necessary resources, to realize that the decisions you take today have a pivotal impact on the future, and some of those decisions must of necessity in investment whose benefits will not be immediately observable, but they will be observable in the future to those who follow. And I'd say with respect to all 4 of those characteristics, what is so heartening about the experience in South Africa and Kenya, I think, see positive developments on all of those fronts. And in that respect, it's not simply important for Africans, for Kenyans, for South Africans. It's an important example for the rest of the world. Thank you.
Thank you, Bill. There is quite a lot that you said there, and we'll come back to unpack that. But first, let's go to Francis, just to have him give us a view of what he thinks the successes and challenges are of building a highly performing institution, and perhaps also just speak about your experience in Kenya and what the challenges and successes were in that context.
Thank you, Mondo. That's a problem of resources, but sometimes we have that. But I stand here, and your question is very difficult in terms that you're telling me to blow my own trumpet. But on retrospect, is that I think I'm the only one who knows how to blow it. So you'll excuse me, I'll blow it. And my case here, I can say we are the youngest agency when I compare to what Bill has done in US. Tembi yesterday, he said he's leaving a young adult. And me, in January, I'll be leaving a 10-year-old. And so is that I was given the mandate to form an institution. So as a Director General, is that I was given a mandate by the owners of the law, and that is the Kenyan people and Parliament. And when I look at what the government wanted to do, they wanted to form an institution, and an institution which is credible and which has the capacity and the visibility to enforce the law. Number 2 is that they wanted me to enforce that law to achieve and to improve the welfare of the Kenyans. So I can say I was the Neil Armstrong, the first person in Kenya now to deal with competition law. And then I asked myself, there are 2 options, and Bill has indicated it, that you can decide just to push your own self-aggrandizement, or you build an institution for the future posterity. And I talked to one of my colleagues, and unfortunately, that colleague of mine told me, you are taken to court when you do something. And therefore, you have the option of not doing something. If you enforce, you can be taken to court. And if you don't enforce, you can be taken to court. So as Bill has indicated, out of 144 agents across the world, there are some people who choose the right, or rather what they think is right, you don't enforce so that you can be taken to court. And at the end of the day, you are earning your salary. But I ask myself, what is the success of Francis when he leaves the authority? Will I just be remembered as the first Director General who just earned payslip for 10 years and he just left nothing for posterity? And therefore I decided I need to take risks. And these risks I have to take is that it's for future generations to be learning about when they mention competition authority, they'll be mentioning like the first landing in the moon by Neil Armstrong, that Francis is the guy who did this. And that's the option I did. But the challenge now I encountered is that I had only 3 staff members the first few days. So what do? Is that I had to approach development partners who supported me. And I brought in somebody I saw here today, Professor Simon Roberts, supported by the World Bank, and he came to Kenya. And that's how we started building the institution. And then also I had my big brother, South Africa, that I could learn from them. Before we started forming the organizational structure, we came to South Africa. We went to the United States. We went to Australia because of consumer protection, learning from the big brothers and big brothers with benefits. And this is what has always been pushing us, that even when we are attending meetings, is that you don't just go there for those meetings, is that you are going to learn. And Tembi, by the way, that's why I always come to South Africa. I come to learn from you. Not that I like you a lot, but it's what you have done. And Doris will continue doing that. So the key thing is that that's the vision I had. But also there is the other issue, is that there was scarcity of resources. And I realized that when you don't prioritize, you behave like a drunk driver. You're all over the road. So you need to be focused and keep on your lane. You prioritize areas which have the greatest impact to the common citizenry. In Kenya, we don't have the BEE in our law. But at least is that each and every year, the government comes up with a policy statement in regard to what it's focusing on during that particular year. And every enforcement we do is that we try to align it with the government. And that is not lack of independence. That is helping the government in power to, because you're a part and parcel of that government policy, but they are not telling you to achieve, not to take a certain decision. So you align your priorities within the government priorities. Then, of course, Francis is just the driver. And I'm not a very competent driver. So I have to get some co-pilots who have to come on board and tell me, Francis, you need to take that corner. I'm a reckless one. You have to take that corner at 120. Don't take it at 140. So I needed to bring in team. After I had prioritized my policies with the government, it increased my budget by 200% within the first 2 years. I brought in on board 25 staff members within the first 2 years. And we had a very elaborate recruitment and placement policy. But I would say that there was a challenge in the sense that when we were recruiting, is that we were thinking that, we have to recruit people who have knowledge on competition policy and law. But I realized these people are not many as such. And then even if they have, you can have the knowledge that you have done 2 units, 3 units, but you don't have the experience. And then you come being, having some ego that you're expensive. When I realized that I'm making this mistake, I started recruiting directly from the university. I made some savings in terms of the salaries, and also in terms of responsiveness to the needs of the institution. And when you come to the Competition Authority of Kenya, you realize that 70% of people, they're about 36 years old. And that is the kind of responsiveness we have. The other issue I realized is that, yes, you're in a competition agency, but you need networks, not only within the government, but also with the National Assembly. And having networks, it's not losing your independence. It's having networks to know what is happening in Parliament. And also when you want to push, or to what Bill has indicated, upgrading, is that you have contacts in each and every part of the government. And that is how do you get a seat on that table? Nobody will ever invite you to that table. Is that you have to push yourself to that table. And then when you're on that table, is that you have to maintain yourself. So, advocacy initiatives. Look at what the government is doing to curtail competition in the economy. Give opinions unsolicited, and support it with research. And the moment they hear the Competition Authority of Kenya has taught, they always salute and say, yes, we've heard, and we are going to implement, or they just ignore. There's a saying in Kenya, a hyena talked to the stone, and the stone did not respond. The hyena said, I know you've heard, even if you haven't responded. So that is the attitude. Talk to the stone, even if the stone does not listen, you have talked to the stone. So we always give opinion, whether it's solicited or unsolicited. And with that, you gain credibility. And also internationally, when, if at all you are not listened at in your own home, but you can be listened outside, then the voice can come from outside. What did we do? With my friend here, is that we formed the African Competition Forum. And the African Competition Forum is that it was looking at the whole continent, doing research, learning what South Africa is doing, learning what Tanzania is doing, learning what Nigeria is doing. So that also is that we can get that kind of information and bring it to our policymakers. And I can give an example, is that we do the research in sugar. And I approached my government in terms of import duties on sugar. Tanzania had a better import rates, and the sugar levels, the sugar prices were lower than in Kenya. And take into account that 25% of the disposable income of the poor people in Kenya is used buying sugar. If you reduce if you reduce the price of sugar, we could reduce the level of poverty in Kenya by 2.8%. And when you go with such statistics to the stone, obviously the stone will listen and it will invite you on the table. That's how I approach the whole issue. Has there been challenges? Of course, there has been challenges. We are operating in a political economy. We all operate in political economy. Is that nobody will lie to you that we never receive calls, that we need you to do 1, 2, 3, 4. But as a leader, is that you should not be arrogant, but you should be a stickler of law, and also is that you should be accountable and transparent and predictable. That any decision you take, publicize it, so that people can be sure when we go to the Competition Authority of Kenya, is that this is what they did to A and this is what they will do to us. So that you can be accountable. Independence does not mean we are not accountable. We are accountable to the Kenyan people. Then there is the other challenge. So we receive calls, but due to our predictability and publication of our decision making, is that we publicize that. Then there's the other issue of finance. Resources will never be enough. And that is why I talked about prioritization. We have been prioritizing. And in the first years is that we prioritized on removing obstacles in government regulations. Now we are prioritizing, then the second round was prioritizing, focusing on the drivers of the economy, focusing on ways of reducing poverty. That what tickles with the policy makers. Then the other issue is that we live in a region where there are always issues of governance. As Francis, is that I wanted to build an institution which will never have any case of governance, will never have any audit query, and I leave an institution which has never been mentioned with such cases or any audit query outstanding. That's the legacy I've always wanted to leave. Come January, I've put the plane on the cruising speed. The board is in the process of getting my successor, and within 2 years, I'll know whether I was able to build an institution which may withstand Bill Kovacic storms and turbulence, which he couldn't make. Thank you for now.
So thank you, Francis. Some common themes there, which we'll come back to after Tembi's opening remarks. Tembi, the Commission has been a resounding success under your leadership. And if you could also just share with us, to remind us where you started and what has been successful and what has been a challenge.
Thank you, Mondo. Just firstly to also officially hand over to Doris and to tell the staff that when there are glitches in running the conference, please approach Doris. First, we didn't establish the institutions, we found them there. They were working. So I would want to first acknowledge that we had that gift of a legal framework that establishes independent institutions. And they were there when I got there. And I'm going to tell you what we did to improve them very briefly. I don't have all the time. But without repeating what my fellow panelists have said, I also subscribe to the notion that of everything that's required institution, there is none more important than leadership. Leadership can make things happen or not happen. With respect, people are very important, but people, you can find them when you have leadership. Skills, you may not have them, but you can buy skills when you have leadership. So but what you can't buy, what you can't insource, unfortunately, it is leadership. Leadership has to be inside. And I think, taking from the topic that we must draw lessons for our countries as well. I think here in South Africa, what I see is the lack of authenticity in leadership is a big problem. The gap between the kind of public persona and what people in reality believe in. And the wider that gap we must mind. The wider is the gap between what people say they believe and what they actually do And I have complained in the past also that meritocracy matters. Here, what we have seen, and it's something we need to reflect on a lot, especially here in South Africa. The best students coming out of university want to be employed in the private sector. Blue chip companies, this and that. There was a time when you could also go to SOEs, but I can tell you now, with their reputation, nobody wants to go there. So the best go to the private sector. The second best go to government as officials and so on. And the West become politicians in that order. And there's a real problem there. There's something that's not working. And then there is culture. Culture also is something that's born of leadership. It's about knowing we are here for a purpose and defining that purpose and getting everybody to buy into it. So enough maybe about leadership because we don't have time. Then there is strategy. There is strategy. Deciding what's important, what will really move the pendulum. When we got to the commission, I remember we had this discussion. I was an official at the legal department, and we raised this issue about prioritization. Can we actually prioritize? Can we say we don't want to do this case and we want that one? And I remember the advice of the chief legal counsel at the time was that no, you have to treat all complaints equally. The law says when you receive a complaint, you must investigate it. And after you investigate, you must take a decision based on evidence on whether you prosecute or not. In other words, do everything. That is the first thing we changed. We said, no, we don't have the time nor resources to be able to do everything. We will hear if this is a problem. We always get a response from the market. The market is called lawyers. We would get the best response, we'll get it from them. We said, no, we will prioritize sectors. We will prioritize cases. And actually, Dennis was talking about incrementalism. I want to talk a little bit about this because I think when you are in the judiciary, you don't know how cases start. You decide that there are cases that are going to go through court and there is a constraint there and you will know the constraints. But there are also low-hanging fruits that you can do on your own, and in fact, the courts are less of a constraint. You also decide between incrementalism and big bang, because you also do need big bang. So you have to constantly balance that. So what we did, we kept everybody busy with cartels. We were very aggressive on cartels. Because, why? It was low-hanging fruit. We realized that there were a lot of cartels and we could get evidence. When we did a raid in one of the firms in Cape Town, we go there, guns blazing. We start ransacking the place, as you do in a dawn raid. The secretary, there was this white secretary, sort of says, irritated. What are you guys doing here? Of course, using swear words. I will not repeat. We said, no, we are officials of the commission. We are raiding the firm. Says, what are you looking for? I think she wanted us to get out of the place. We said, well, we are looking for information about collusion, cover pricing, and so on and so on. The moment we mentioned the word cover pricing, she pulled out a file and asked to leave a file, and it was written, cover prices. This is where we come from. She pulled it out, and we said to the guys, it looks like the raid is done. We usually take a day and a bit in the office. So we kept everybody busy with cartels because they were low-hanging fruit, they were easy. In fact, what Dennis doesn't realize, we've achieved more outside of courts in cartels than inside courts. I think Doris mentioned the early fines, right? We've achieved R1 billion fine through settlements of cartel cases. And of course, we debated this yesterday. Often a cartel will be reinforcing a dominant position of a particular player and so on. So it's not a linear thing. But the point I'm making is that big bang is also important. Whilst incrementalism, your term will end whilst you are still wanting to develop a jurisprudence and you actually raise the awareness of courts without them being aware that there are in fact cartels in this market, and in fact cartelists can absorb big fines and skies will not fall. And so instead of the courts leading us, you lead the courts. Of course, you can't tell them that you are leading them. They have to see that there is a problem and the problem can be fixed. The incrementalism comes in many respects in the judiciary accepting of the standard. And often this happens in technical ways. So it starts by saying, how do you initiate a complaint, for an example? Do you write a piece of paper? How do you do the investigation? Do you tell the respondents that I'm now investigating you? I tell you, the courts don't understand this. There are people who thought that respondents had rights to be informed. You say, well, how are you going to do a dawn raid? You know, how are you going to do to have the degree of comfort that you can be able to effectively investigate using an element of surprise? How are you going to achieve that? So, but the courts had to start from there. How do you initiate a case? Up to a point of saying, when you refer the case, how wide or narrow can this be? That is the incrementalism, and I accept that that process is slow and painful, but necessary. So it's not about either or. It's about choosing what will achieve results now versus what is needed to develop and sustain the system over a period of time. I don't have time, I realize. Obviously, building institutions is also quite important. I'll just end, Mondo, by one example, because I think it's important. Part of the confidence you get is also learning from what others are doing. With cartels, because it's one of the success stories, we went here to the OECD the other year. I think, I'm sure I was with Simon Roberts. We took a train from Paris to Amsterdam, to The Hague, to meet the competition authority of the Netherlands. It was called CMA at the time. We said, we are thinking about prioritization. They said, no, we've done that. And they were our age. We were established the same year. They said, no, we've been doing that for years. It's been hugely successful. The private sector has accepted. We lay out the agenda every year. We go public. We say, we are going to go for these sectors. So we were more confident when we came back about prioritization. They also told us something. They said, in the construction of the Schiphol airport, the airport in the Netherlands, main airports in the Netherlands, we found that it is in the nature of the construction industry to collude. So we suspect that this is happening all over the world. We came back to South Africa. We found a construction cartel within months. But we were also told something else as we were talking to the Dutch and the UK Competition Authority. They say that competition authorities, possibly with the exception of the US, don't know how to investigate cartels. You don't know because you are doing your kind of competition analysis using all the competition tools that are needed to do this, in your abuse of dominance, defining markets, bringing economists to tell you the theory of harm. Irrelevant for cartels. Cartels, you are investigating a quasi-criminal conduct. And people who come from that system tell you that you need special people who can think like criminals. Thank you very much.
Well, thanks. Thanks, Temi. It boils down to resourcing and being able to stay ahead of the curve in terms of being able to enforce competition law, because businesses adapt and change all the time. I think Bill spoke to that issue to say you need to be reviewing the institution every so often to see that you are still relevant. So I want to come to two issues very quickly. One is the one of independence. And I ask the question because, yes, we want to do these great things. And there's, independence is an important element that has come through from the conversation so far. The institutions and how you set them up are varied. Francis, you mentioned that your institution is still a young agency. And the commissioner, you mentioned that you found an institution that was already in existence. So I want to touch on the model for what you would consider to be the best model, bearing in mind that independence is a theme that you have all mentioned. There is the Kenyan authority, for instance. It does not have three-tier systems such as South Africa. And I want to just hear from you, Francis, about the maintenance of independence and how important that is and how it works within that structure.
Thank you, Mondo. Let me start by indicating is that I don't think there's any perfect structure for an institution. But there's what I may call the basic doctrine of architecture of an institution, in terms that an institution should respect the constitution of that country in terms of investigations, prosecution, and decision-making. At least an institution should respect that. Number two is that, from where I sit, is that structure also goes beyond the internal structure of the institution. What is the nexus between your organization and the main government? For example, in Kenya, I'll give an example, is that when we were forming the Competition Authority of Kenya, we strategically placed it under the National Treasury. Why? Because one, it cuts across all the economic sectors, and therefore the Competition Authority of Kenya was among the first among the equals in terms of the regulation. And therefore is that this issue of that the authority has primary jurisdiction in terms of the of competition regulation, it was even implied in law. Number two, why it was placed there is that all the agencies under the National Treasury, they are graded highly, and therefore their pay structure is usually higher than the other state agencies. And therefore, for retention purposes, is that we are able to attract and retain staff than the other agencies. Then the other number three is that, in Kenya, if you realize, is that we amend law very easily, because we usually approach the Minister for Finance, that is the National Treasury, when he is presenting the budget policy, is that the amendment of the law is made to be part and parcel of the money bill. And therefore, it's usually through the budget making process. And therefore, we amend the law within 3-4 months. And so we had envisaged that when we were forming the structure. But even having that kind of umbilical cord with the ministry, in terms of functions, the minister has no role in terms of the day-to-day operations of the agency or implementation of the competition authority's decisions. The competition authority has a board in terms of policy, and that board is constituted of 9 persons. 5 persons are appointed by the minister but vetted by parliament, and 4 are from the government, key government departments. And this board is the one which appoints the Director General and pushes the name to the Parliament, which vets the Director General. So you can see there's no relationship between the Competition Authority and the Minister. Now it's the board direct to Parliament. And then the Director General is the one who does the day-to-day activities who runs the day-to-day activities of the Competition Authority of Kenya. That is in terms of the administration. But in terms of the budget, I can indicate is that we are not we don't have that independence, because we get 85% of our money from the national treasury. And there's always a question, should we be retaining our fines? And the question has always been, in terms of retaining the fines, are the agencies in the business of collecting fines, or they're in the businesses of correcting market distortions? Because we might be motivated just to collect fines without, focusing on other problem-solving solutions. Then also is that on a rational and selfish point of view, if you depend a lot on fines, and those fines you don't collect them, the National Treasury will never increase your budget. They'll always be telling you go and collect from the fines. So it's a balancing act, and that is why it requires a lot of leadership skills. And in terms of enforcement, I'll not dwell much on it. I know many Kenyan lawyers are listening. The Supreme Court of Kenya has already pronounced itself in regard to the structure of all the regulators in Kenya due to a case which had been filed by one party against the Capital Markets Authority of Kenya, and the Supreme Court pronounced itself, and we seem to be offending that Supreme Court pronouncement. I'll not elaborate on it, but we are in the process of respecting that pronouncement, and it's in regard to separating the investigations, enforcement of our processes. So that's how we have approached the whole structure issue.
All right, let me just then turn to Bill on this issue of independence. Bill, you have served on the CMA as a non-executive board member. You've served at the FTC, and you've experienced different models. And can you just share your experiences of independence and what model you would say works? And I'm going to link that to funding, because independence and funding sometimes can get conflated. To what extent are you reliant on the funds of the body that you report to, and to what extent do you maintain independence in your decision making and the best structure to achieve that?
I always made exactly the right decisions. I want that to be clear to begin with. But I think the lesson that you learn in looking at individual authorities is that in every jurisdiction, there's a tension between the notion that certain decisions must be taken autonomously on the one hand, but on the other hand, the agency must be accountable to the larger public and has to be effective in its ability to persuade political leadership to give it the tools it needs to do the job. I think we tend to forget in thinking about independence, and maybe independence isn't the right word. It suggests autonomy, even isolation. You can't imagine in any system that a government would give a public institution a lot of money and a lot of power and not at least occasionally ask, what do you do with my money? What are you doing with the power I gave you? We have to be accountable for that. And as Francis, I think, was very skillfully pointing out, you have to have a conversation with the political leadership of the country in order to get resources and to get powers. Very few agencies around the world are independently funded. That is, through fees or other mechanisms. They have to go through a ritual, at least 1 year, of going to political leadership and saying, please pay my budget. And you can ask, ultimately, how independent is any institution that has to go begging once a year for the budget? I'd say there's a limit to that independence. I was always aware in dealing with political that I had to make a request. So I did have to listen to them. And I guess that the listening is important because, again, as Francis was saying, Tenby mentioned this as well, you do ask them for resources. You do have to ask them for more power. The upgrades I referred to before, you need to ask for more powers in order to repair deficiencies. You'll only learn about the deficiencies in the system or its limitations in the course of applying them. You have to go back to government and say, I need a better vehicle in order to do the job well. And you have to be able to speak with them so that they have realistic expectations about what you can accomplish. I think that as new institutions are built and as they operate, political leadership begins to assume immediately that they can do everything. They expect you to cover the universe when you discover it's simply pretty hard to simply get to Durban. So managing expectations is part of having that conversation, and you can't have the conversation unless you are part of a process through which you engage with political leadership. So that element of accountability and effectiveness, I think, is very important for leadership to keep in mind. And by the way, it tells you something about who you want to have as the head of an agency. You want to have an agency head who in some sense is a political scientist, who has a broad understanding of the economy, of the structure of governance, of the locations of power in the country. This person is the equivalent of a great midfielder in the global sport of football who understands the entire pitch, sees everything, almost has eyes in the back of their head in order to see everything going on. In a way, that's who you need to head the agency, because they need this broad awareness. I'll simply close by emphasizing one area where I think the agency must fight to maintain autonomy, and that's in the decision to prosecute. To do things that hurt by applying the enforcement tools that the agency has. That's where it's crucial that the agency build a reputation for exercising independent judgment. And the reason that is so important is that ultimately, you do have to go through the courts. Ultimately, you do have to go through the courts. Ultimately, in South Africa, Jasmine, Dennis, Norman have to have confidence that the agency is exercising independent professional judgment. Because notice one of the arguments that an agency makes when it goes through the courts is, why should you listen to us? We're the experts. We have deep expertise. So in making certain judgment calls and decisions, you should at least implicitly defer to our judgment. Give us a margin of discretion, because we are a repository of superior expertise, and the superior expertise guides our decisions. The court will not do that if it has the view that you simply are responding to the specific demands of political leadership in the country to take one path or another. If the court believes you are simply an extension of the political process, it will not listen to those arguments about expertise. It will have the listening ability of the stone that Francis mentioned in his example in the proverb. If the court does not think that you are acting on the basis of your strong political judgment, not your political judgment, your professional judgment in technical policy expertise, indeed, in a context in which you're aware of the larger social needs of the country. But if the court disbelieves that you are acting with your professional judgment and your technical expertise, it won't give you any difference. It'll simply say, you're making the same judgment as a legislator, a minister. Why should I listen to you? So I would say, in the engagement with political leadership, it is crucial to have that engagement. Otherwise, you don't get money, you don't get needed powers, but you have to signal to political leadership that when it comes to deciding to prosecute, bringing cases, doing things that hurt, we must act and must be seen as acting on the basis of our professional judgment. Because if that perception is eroded, the courts that ultimately have to uphold our choices and share our vision about where the law ought to go will simply shut us out. And in that respect, autonomy is crucial. So autonomy with respect to the decision to prosecute, vital. There are a variety, as Francis was saying, of institutional designs that allow us to do that. And I'm afraid in the answer to Mondo's very important question, is there a framework that operates better than others as a method of governance for the agency? I'd say our larger community around the world is still trying to figure that out, at least we're asking that question. So independence in the sense of isolation and detachment completely from the political process, it's not possible, it's not feasible, it's not desirable. But autonomy, making the decision to prosecute in each cases, that's vital if you're ultimately going to succeed in persuading experts like Jasmine, experts like David, experts like Norman, that the agency should be given the benefit of the doubt and its judgment respected.
Thanks, Bill. I want to turn to the last question, which is the question that's been touched on, and that's the one of resources. I think competition agencies in general do have a resource problem, and I want to ask the question to you, Thembi. Over the years, the Commission has grown in leaps and bounds. We've just touched on the issue of budget. How have you managed to attract staff, to retain the staff, and to be able to pay the staff, because funding is usually a challenge?
Sorry, I have an independent mic. Firstly, you have to be prepared to fight with National Treasury quite a lot because they'll tell you how much you must pay your staff. And so, again, in the context of independence, I think you have some scope there to put up a fight. I'm not saying you must fight to death, but you have to push back a little bit to be able to do this, I think, to be frank. The second thing is and by the way, it's the entire government system. The entire government system doesn't like autonomous institutions. You know, they want to compare salaries of the experts you pay in an agency to a sort of normal civil servant salary. So that battle is always going to be there. It's a little bit of a tension. The second thing is, which has helped us quite a lot, is it's really the credibility matters. Credibility matters to be able to be responsive. So the cases you do kind of respond to the needs of your stakeholders, society in general, but also policymakers. I think in South Africa, we've been lucky that at a time when everybody was facing budget cuts, we are probably one of the few agencies that were able to get an increased allocation. And I think that has everything to do with the value that is attached to the work we do. And lastly, obviously, you have to manage the resources properly. You know, it matters that you must have sort of credible financial systems, because you're not going to get money if you're not looking after it.
Can I just ask one last question related to that? I mean, how far ahead does one have to plan? I mean, you mentioned prioritization as one of the issues, and there has been quite a lot that has been happening in the world, in markets, in the economy. We know that things have changed. There's the digital economy, and it forces a different way of planning your resources as the Commission. There's food inflation that also hits you as you're thinking you are looking at digital markets, and so many others. So how does prioritization then work in that instance, and what would you say is a manner of attracting sufficient skills to deal with all those, and when do you acquire those skills? Because you don't know when you are going to need them. How far ahead do you need to be planning, and how did you achieve that?
Yeah, no, that's a really great question after COVID, because we had to throw away all the plans during COVID to refocus on other things. Fighting inflation is one of those things that tend to be urgent, because you can't wait. You know, consumers won't wait for prices to come down. So I think that you must still keep the long-term overall vision. So if you want inclusive markets, that's going to remain. You know, that's a long-term vision. But the things you do day to day towards that will change over time. I mean, what we did, for example, on abuse of dominance, which tends to be cases that take very long, and I think credit goes also to Liberty for this. We realized we were losing cases, and we were making a lot of investments. Even though these cases were towards the vision that we had outlined, we said, well, we need cases we can win, and we can win them without investing too much money. So we started taking cases people didn't think were important to establish precedent. So that's how you saw these cases about number plates, a simple contractual issue that's tying the market. It's not very difficult to persuade adjudicators about it, but it's got a huge impact on opening up markets. Rather than running a complex excessive pricing case with the possibility that you are going to be second-guessed by, especially, let me not mention names. But the point is, I think you have to balance how much you invest versus what you can get. And I think it's not always about the big and most popular cases. Sometimes it is small, but with a potentially huge impact. I mean, we did number plates, we did compute tickets. I mean, compute tickets, a fantastic case, also a contractual arrangement to lock in the market. And you get a positive judgment within 2 years that unlocks all of that, and you change the entire market. So it's also about how you deploy these resources, because you can have this excessive pricing case. It will tie all your resources, and it will take 8 years to resolve, and there will still be a debate, a big debate at conference with people emotional about whether you should intervene with prices or not.
I think we are running out of time. I'm going to ask Francis if you have a closing remark, and then we'll turn to Bill just to give a final comment before we close.
Thank you, Mondo. As my closing remark, and we are leaving with Tembi soon, to me is that I'm looking at it as an opportunity to bring in new leadership who will be able to respond quickly with the new emerging areas. We have seen that we are having data platforms, digital economy, and we are this kind of people who have been focusing on traditional sectors of regulating. We have seen even we may start breaking up institutional dispensations and bringing in consumer protection and bringing in data protection in big agencies. I think this is not our forte. You can see we are still talking about independence. As we move forward, is that there's going to be a combination and maybe bigger agencies. And I think new blood, new visionaries need to come on board and start this new era of enforcement, which requires a lot of cooperation, collaboration, and engagement with the regulated. That's the opportunity I'm seeing. Thank you.
Thanks, Francis. And Bill?
My colleagues, I think, have identified a vital frontier for work in competition authorities around the world. In the field of public administration, generally, I think there is still an epidemic failure to bring the process of strategic planning and project selection to bear upon the application of agency power and resources. I think in far too many instances, agencies operate like a fire department where the bell rings, you take the trucks out, and you put out the fire, you come back to the firehouse, and then the bell rings again, and you go out. You have no time to think about why there's so many fires, how you can engage in fire prevention. Do you have the right equipment? Do you have the right approach to dealing with fire suppression and fire prevention? And the comments that both Tembi and Francis have made about focusing more attention on how priorities are set and how projects selected, to think more as an enterprise would or an investor would about where the rate of return is most appealing. I would say that the most heartening thing I saw at the Competition Markets Authority is how much progress they have made in building a better methodology inside the House to select projects to carry out broad priorities. To realize, as Tembi said, that a small case can make big law, and you might want a small case in your portfolio. To have a process of asking, how much is the big case we're going to bring? How much is it going to cost? And what is the relative benefit of bringing that case compared to other things that we could be doing? CMA has gone a long way to building a framework in which individual decisions are taken in the context of a larger portfolio of matters already underway, and comparisons are made among alternative projects. So I think one thing that the panelists, my colleagues have done so well is to highlight the benefit there would be to, not just for Kenya, for South Africa, but for agencies more broadly, to bring comparative study and detailed examination to precisely the process that's used to decide, what am I going to do? How much will it cost? What's the anticipated return from carrying out the project? To think about a way of improvement of our entire system in the future, that is an issue worth wrestling with in a far more aggressive way. Thank you.
Thank you, Bill. Thank you, Bill, for those final remarks. We have come to the end of the session. I'm sure it will continue outside on the corridors as we learn from each other. Enjoy the rest of the afternoon. Thank you, Mpumi.
Thank you, panel. Testing. You can hear me? Okay. I was instructed not to give you tea. But I'm a lawyer, so that means I aspirate coffee. I can't do it. I personally am a little pressed, so here's the compromise. In 5 minutes from now, I would like my panel members on the stage. And if you need, I know some of us, we're seeing like people we've idolized for our entire career just in front of us, and we really want to have that conversation, and you just want to hold them down and say, please, I love your work. You may do that, but here's the condition. While you're outside, it's actually quite noisy every time somebody opens the door, and it's very disruptive to the panel. So if you are going to go beyond the bounds of time, please do so quietly. So while you're outside, just have a, whisper session with your idols. And we will start with the next session. I'm going to give it 1:45, so that's 7 minutes. Go. Thank you.
In a vote of confidence about South Africa's long-term prospects, New York-based food and beverages giant PepsiCo has made an offer to buy Pioneer Food Group, which makes Sasco breads and Ceres juices, in a deal worth over 25 billion rand.
The Competition Amendment Act came into force in July 2019. Barely 2 months later, a Simba Pioneer merger was notified to the Commission. So this was really the first time we had to, as the Commission, consider the implications of the new amendments, particularly to Section 12A3C and Section 12A3E of the Act. So this was really the first time we're looking at this case through the prism of the amended Act, and it turned out to be a seminal case in respect of those amendments. This case provided us with an opportunity to learn a lot about how to give effect to the promotion of a greater spread of ownership. So there was a fund created which ensured that there was skills transferred to youth, small businesses and firms owned by HDPs, teaching them farming and other general business skills. There was also funds set aside to ensure that small farmers can access markets. Insofar as workers were concerned, we had to consider how they can meaningfully participate in the economy. And again, here we eventually reached consensus with the parties whereby they set up a certain percentage of the shareholding in the target firm, which was to be held in a workers' trust on behalf of the workers. And this actually equated to a value of 1.6 billion, and dividends would flow to workers from day one. So this set the template for later cases, whereby when we involve workers and worker participation, we expect that there must be no encumbrances to that shareholding, and dividends must flow from day one. This case really provided a template from which we could take these amendments forward. And there were a lot of learnings. For example, we learned how to craft meaningful employee share ownership schemes that are truly transformative in the sense that they provide workers with board representation. They are unencumbered in the sense that workers can start enjoying the fruit of those dividends from day one. Some questions remain unanswered, such as, in which entity should workers participate in? Should it be an entity that is domiciled in South Africa? Can it be elsewhere? And these will obviously be further crystallized through the development of the jurisprudence. And I think we're looking forward to the conference where maybe some other views can be heard from labor, business, the legal fraternity, as to what their thinking is about how we can give meaning to these amendments.
When I joined the Commission in August 2021, 2 months later, the complaint in relation to the Pcr test case was made in October, and I was brought into the case at the end of November 2021. The Pcr test case related to the price charged by private pathology firms to conduct PCR tests, which is the gold standard for COVID testing. The Omicron virus had just been discovered in South Africa, so quite a lot of people had to perform COVID tests. At the time the complaint was made, it cost 850 rands per person per test. So the complaint received from the Council of Medical Schemes was that the price of 850 was excessive when regard is had to the cost of conducting the test. So our brief was to investigate whether a price of 850 was excessive and to come up with a remedy that is either referring the case to the tribunal for prosecution for excessive pricing, or to try and find a settlement with the private pathology firms. My role in the case was just to do a deep dive into the numbers provided to the Commission by the pathology firms. That is, to understand the revenues that they made, the costs to the labs of conducting a PCR test, to do a reasonable analysis between the price charged of 850 and the cost incurred.
Hi, can you hear me?
And
it's
also
Romaine.
what we had to do was just to do a comparison of the various cost items for the pathology firms to compare against each other. After we had established that the cost of 850 appeared to be excessive, we had to do a calculation of a minimum price that the pathology firms could charge for the PCR test and still remain profitable. The outcome of the the settlement
because
between
it's
the
a little bit
Commission
far
and
away.
the pathology labs, just in simple numbers, was a reduction in the price from 850 to 500 rand.
Can you hear me clearer?
But just at a personal level, a week after the settlement was signed between the Commission and the pathology labs for the decrease in price, I myself had to undergo a COVID PCR test, and it cost me 500 rand. And had I gone for the same test just a week earlier, I would have paid 350 rands more. It is also important just to note that at the time, if anyone wanted to do international travel, they would be compelled to present a negative PCR test result. Also, at the time, if you wanted to be admitted to hospital for any procedure, you were compelled to do a PCR test to determine which ward you would be admitted to in hospital. So the reduction of the test price from 850 rands to 500 would have had quite a telling impact on society.
So in September 2016, the Commission received notice of a large merger in which Mediclinic South Africa intended to purchase an independent hospital group called Matlosana Medical Health Services, or MMHS. Mediclinic SA owns around 50 or so hospitals in South Africa, one of which is located in Potchefstroom. Now, both of these towns are in the Northwest Province. MMH operates 2 multidisciplinary hospitals in Klerksdorp, Wilmed Park Hospital and Sunningdale Hospital. There are, in total, in that region, about 3 municipalities next to each other. There are about 5 hospitals in the 3 adjacent municipalities. And so, post-merger, Mediclinic South Africa would own 3 of the 5 hospitals in those 3 municipalities. In light of this, the Commission recommended that the merger be prohibited, as it was more likely than not to lead to a substantial lessening of competition in the relevant market, resulting in a significant increase in the tariffs for acute hospital care for both insured and uninsured patients. I think when we first got the merger filing, I think it became apparent quite quickly that there was more to this merger than met the eye. I think we suspected that it was likely to be harmful for competition, given, the extensive body of research that was conducted in relation to the industry. But there was this pressure to almost evaluate it through a more narrow lens without consideration of the broader context of a healthcare market as a whole and the right to healthcare as enshrined in the Constitution. The healthcare market inquiry, as well as other research pieces and investigations in the healthcare market, have consistently found high levels of concentration and concomitant adverse competition outcomes in hospital markets. The CAC's decision to overturn the tribunal's ruling prohibiting the merger can be viewed as a sort of an offshoot of this approach, traditional approach to competition policy, which is why the Commission sought clarity from the Constitutional Court by seeking leave to appeal the CAC's decision. Indeed, the broader context of the healthcare market and the right to healthcare was a key feature of the Commission's application for leave to appeal. At the start of this process, a key consideration for the team in understanding the effects of the merger was the broader context of the healthcare market and the economy and the provision of health services. However, the primacy of this approach would not have been ratified by the Constitutional Court if the CAC had not overturned the tribunal's decision to prohibit the merger. The decision by the Court has provided much needed clarity on the
Testing,
correct approach
testing,
to establishing
testing.
the overall impact of
Testing,
mergers
testing,
and
testing. 1, 2, 3, 4. 1, 2, 3, 4. Oh, we just have good problems. The good problems are we love talking to each other and we love the content. We want the content to keep going. We want to carry on socializing with one another. Good problems, good problems. I'm going to welcome people in, and then I'm going to, hopefully, I hope they can hear me outside, because we did have a promise that those who are outside are going to try and keep it down so that every time the door opens, we don't hear the cacophony of noise and the cacophony of socializing and the cacophony of catching up and the cacophony of networking. All right. So this session, yeah, I can still hear quite a bit of noise outside. I think our team is going to ask people to come on in and remind them of their promise. We were all bore witness to the promise. Those outside need to just keep it down a little bit. They need to keep it down because this is the main stuff. This is the main stuff. All right, I'm going to jump in. Do I have those in the room with me? I don't know if I'm sure. Do I have those in the room at least with me? Okay, just checking one more time. Do I have those who are in the room with me? Thank you so much. Thank you. You can see I wanted to be an actress as a child. So this session is kind of the bitter pill we've had to swallow, right? It started in ANSAC, and I heard people say, oh, no man, the wrong judges and the SCA, they don't know what they took. They took the international law and they put it in our law. Is it part of our law? And I remember attending conferences even 2-3 years ago where the question was, is characterization part of South African law? Is it avoidable in any circumstance? But if you've been watching the CAC press, we know, Aranda, ouch, bitter pill to swallow, ouch, for those who've read that, ouch. I was the case manager on that, ouch. I swear, being appealed and having your thoughts over, it's quite painful. So there was Aranda. We had Tour Vest, a little bit of an ouchie, a different tone, but a little bit of an ouchie. And then we had I&J, which was nice because it was like, yes, we scored a goal. As the tribunal, we scored a goal. So here before you, you have kind of a panel of litigators who I love hearing from. And first, I'm going to introduce the erudite, Mr. Majenge, who's going to be leading the panel today and facilitating the panel. Also on the panel, as you can quite visibly see, we have the well-esteemed Mr. Ngugiai Toby. Nice to see you. And nice to see your hair too, because dreads on dreads, we connect. Isabella Kentridge, so lovely to have you, a young voice in the room, who is an advocate from the Thulamela Chambers. We also have, I mean, if you don't know this sir, if you haven't been on the other side of his dawn raid, then I don't know what you're doing, actually. We have Mr. Mohlale Mohlale, and then we also have Ms. LaRue, who we'll be hearing from, and it's good to have you all on stage. I hand over to you, Mr. Majenge.
Yeah, thank you very much, Mpumi. Let's not forget William Kovacic, I hope you are still with us, Bill, who is a professor of law and policy at George Washington University. Are you still with us, Bill? Thank you. Cartel law is now at an inflection point, to borrow from an expression used by the minister yesterday. Now, if we take inventory and look at and retrace the evolution of cartel law, I think we can draw a distinction between old generation cartel cases as well as the new generation cartel cases. The old generation cartel cases will be cases such as McNeil, Videx, RMS, the bicycle case, which coincidentally was prosecuted on our behalf by Michelle. Now, what characterizes this old generation cartel cases is an accommodative stance jurisprudentially from the CAC, and that accommodative stance was acknowledged by the CAC itself in the NPC judgment. Now we also see new generation cartel cases. These are cases that Mpumi has mentioned, such as D-Africa Pest, Tovest, and more recently, INJ. Now, what characterizes this new generation cartel cases? We see a clear shift in the pendulum. And that shift seems to be driven largely by this issue of characterization, which interestingly is a derivative of US trust law. So I think it is very much clear from this new generation cartel cases that cartel law is now in a state of confusion, and we need to make sense of it. So we have assembled a panel of sense makers to really help us to put Humpty Dumpty together again insofar as cartel law is concerned. Perhaps let's start with you, Bill, in terms of how do we draw a clear line of demarcation between per se as well as rule of reason contravention. And allied to that question is the question whether characterization itself is not softening that presumption of illegality in relation to cartels. Bill?
Thank you, Mr. Chair. And again, my great pleasure in participating in this conversation, which has universal application. This is a debate that's going on globally in many jurisdictions, including the oldest. Anytime you have a bright line rule, which is the rule of prohibition that we call per se illegality, including the specific prohibitions included in the South African law, there will always be the question of whether the observed behavior fits within the rule. We can declare, for example, that an agreement among rivals to allocate customers or territories is always forbidden. It's forbidden based on a policy conclusion that such behavior far more often than not is harmful, and that it's not worth devoting effort to evaluate the effects of the rare instance in which it might be benign. So countries forbid horizontal market allocations. The question will arise in a number of instances about whether the behavior we have observed fits within the rule. Is this a market allocation? If characterization means that at the threshold of any case or any inquiry, we have to ask whether the behavior in question is properly labeled with the per se prohibition, that's unremarkable. That would be a first step in any inquiry where we have to ask, is this a market allocation within the terms of the specific statutory prohibition or within the meaning of a judge-made rule of the sort that is developed in the United States? So in that sense, characterization is unremarkable. It happens frequently. Perhaps it's inevitable. I think the concern is that it becomes a backdoor through which a broad assessment of the rationality of the per se prohibition is brought into question. And this is where the application of characterization can begin to fall apart. And I'm a great fan of comparative study. I welcome efforts by individual jurisdictions and their courts to assess the application of the law within their own jurisdictions in light of what others have done. It's a way of learning. It's a way of building on the benefits of analysis and experience in other jurisdictions. I'll simply say, as an introductory comment, I am somewhat concerned about the way in which the U.S. experience is portrayed in recent opinions. I think it misses a good deal of nuance about the way in which characterization has taken place. And a number of the conditions that courts in the U.S. have applied in deciding how to label specific conduct, I think, missing in some of the judicial treatments. And I applaud the determined effort on the part of judges to understand this body of law and to apply it. I simply think that some very important qualifications that have emerged in the U.S. application of the concept have been missing. In short, is characterization unusual or alien? Anytime we have a bright line rule, we're going to have to decide whether the behavior that we're examining fits within the rule. That's unremarkable. The question is, what kinds of arguments get taken into account in deciding whether or not the observed behavior fits within the meaning of the rule? I think I would the concern just expressed that the process of characterization in the modern South African jurisprudence is being expanded in a way that not only, I would say, outruns what has been taking place in other jurisdictions, but calls it into question whether or not the legislative judgments embodied in the per se prohibitions are themselves wise.
Thank you, Bill. So Bill, in short, is telling us that there's a mischaracterization of characterization.
Well put, yes.
Advocate Ngoitobi, how should we draw this demarcation between rule of reason and per se?
Yeah, I mean, I'm very concerned that this doctrine, I call it a doctrine of characterization, is emerging as an untethered doctrine, primarily driven by the jurisprudence of the Competition Appeal Court, which again has no beginning and no end, and provides substantive defenses when the legislature has decreed that for certain infractions, when they are established on the facts, there should be no justifications or defenses. I'm also concerned about a second facet to it. Not only is it untethered in relation to the law, it is also compelling competition authorities in every case to bring in economic expertise. And that happens frequently, and in fact, it's been inscribed into the jurisprudence by the Competition Appeal Court. Now, where this thing has happened is, so where it began, everybody knows it was in ANZAC. The claim in ANZAC was that characterization was a necessary preliminary step in US law. But for what purpose? In order to establish whether or not a particular conduct fits within the per se rule, or whether it should be characterized under rule of reason. In this country, we don't have that problem because we have a legislative enactment in Section 41B, which has been a deliberate choice for horizontal agreement made by the statute. And before ANZAC, in fact, the criticism in ANZAC was that the tribunal had taken the terms of the statute and applied them. And then they said that was wrong because there is some other step that you must impose in addition to an analysis of the requirements and look at the facts. In Dawn, the CAC cites characterization in one paragraph from US law, but it doesn't apply it because in the immediate following paragraph, it applies European style, Article 101, which distinguishes between restrictions by effect and restrictions by object. And then it uses the guidelines on restrictions by object to determine whether or not a particular restrictive agreement is restrictive of competition by object. And it departs, and that is why it's untethered. It departs without any explanation from its origin in US law. Most recently, I know someone said, cases you are arguing. Yes, I'm arguing the case. Most recently, in INJ, and we've lodged an application for leave to appeal because we lost at the Competition Appeal Court. Most recently in INJ, we took the debate directly to the judges to say this doctrine has no foundation in our statute and it is not part of our law. How the CAC has responded is actually also interesting because no longer is it now saying it's necessary because it's borrowed from US law or it's necessary because it's borrowed from EU law. Now it says it's also necessary because it's part and parcel of the steps in contractual analysis and interpretation that come from cases like Endumen. But there is, of course, a vast distinction between applying a statute to an agreement and applying the text, context, and purpose of the agreement. That has never been a debate at all. So there are two problems with it. One is its untethered origins and the fact that it can be used to describe any conduct, it can be used to describe any relationship between the parties, and it can also be used to provide substantive justifications, trying to find redeeming features in each and every agreement. The second problem is the fact that it compels the application of economic analysis to each and every agreement, and there is no reason why in each and every agreement economic experts ought to be called. So I'm afraid, I think that it is blunting the ability of competition authorities to effectively prosecute cartels. And this is a worrisome development for me. I was listening yesterday, the minister was sitting here, and then he was going on about how concentration, in fact, has gone up, right? So there is an urgency which does not seem to be appreciated at the Competition Appeal Court in using the instruments we have to dismantle cartel activity. Now, they will say it's because the Commission is not doing a good enough job. There is just no evidence of that at all. The problem we have is there is something happening jurisprudentially at the Competition Appeal Court. Look at the two cases most recently. One is Tovest. Hamilton, that's your case. But anyway, Doris is the commissioner. So I think I'll be forgiven. Anyway, welcome, Doris, to this position you are taking. So I'm not asking to be briefed by the commission, but I'm not leaving this brief on characterization. I mean, look at, this is the last thing I'm going to say, Max. Look at the characterization deployment in Tovest. There, it's not used to characterize the agreement. It's used to characterize the relationship between the parties, right? And then you look at INJ. There, it's deployed to characterize the agreement. And you look at Dawn, where it's used there to find out if the agreement has redeeming features, any redeeming features. So it's the untethered nature of this doctrine and the fact that it's blunting the effectiveness of what the statute actually had in mind. And that is why the justifications for characterization have been shifting. And most recently, it is now said to come from Endumeni. So hopefully, very soon, the Constitutional Court would set down a case on characterization and clarify whether or not the doctrine is part of our law, and if it is part of our law, where does it begin and where does it end? There are promising signs on that score, because the most recent case we lost at the Concord, which was Aranda. Unfortunately, I didn't argue that at the CAC. I think Hamilton argued that. So fortunately, with that most recent case, the Constitutional Court sort of departed from its usual one-liner that says no prospects of success, blah, blah, blah. It now said the reason we are not taking the case is because the CAC did not find that you must prove effects. So that's already beginning to show that they will probably be gearing themselves to take a characterization case very soon.
Yeah, so Tebeka is essentially telling us, because I have to translate these things for myself. He's essentially telling us that characterization is a sort of a jurisprudential amoeba. And what is happening is that the courts are in fact characterizing away from the law. Isabella, it's your turn.
Thank you. Well, yeah, when you're trying to find where the line is between a per se and a rule of reason contravention, I think the most help the jurisprudence gives us is it's between ambiguous and unambiguous, which is maybe not so helpful, because definitely what the Commission would see as unambiguous would differ from what a firm might, and in some of the cases, the tribunal has definitely differed from the CAC in what they would consider to have been an unambiguous conduct. But beyond the question of where the line is drawn, which hopefully we will end up with some guidance from the Constitutional Court to tell us where that is. But another question, I guess, is when is the line drawn in a practical sense? Because as we've been hearing earlier, a lot of competition prosecution is dependent on resources and prioritization, and I think it will definitely affect which cases are brought to the tribunal, whether they're going to require more investigation, what happens if the tribunal determines that in fact it requires a rule of reason, but the investigation has closed and the referral's taken place. How do you go back and remedy that? And also, yes, as Tembeka was saying, what do you do in situations where you're going to need to expend a lot of resources in the economic effects of a conduct and in doing sort of counterfactual effects analysis, which ordinarily you would assume you wouldn't be doing in terms of per se contraventions. So that's where that's where I feel like a lot of practical attention is going to have to arise wherever the line is drawn.
Yeah, thank you. Yes, certainly. It seems then that the incorporation, from what you are saying, Isabel, the incorporation of the rule of reason in the per se framework will unravel cartel conduct. Mahale?
Maybe, Chair, I'm not usurping your powers. Maybe Michelle must speak first. Do you want to go first?
I'm the moderator, Mahale.
I know, Chair. So, yeah. So, let me start by saying this characterization thing, it's a problem. It's the biggest problem of our time, and I think we've got to resolve it if we were to sustain prosecutions of cartels. because at where we are now, it has made us weak in terms of enforcement. You go, you do don't raids, you get evidence, you come back, you refer a case, they tell you that properly characterized, this is not a cartel. There's never been a point when on these cases, especially from the CAC, that they are properly characterized, they are a cartel. It doesn't exist, it's not there. It's always properly characterized, it's not a cartel. So you have a situation where you have a commission that is tasked to enforce the law in the public interest, for the benefit of the public. So the work we do that to benefit the public, majority of which are poor people. They can't defend themselves on their own. They need agencies of state to defend them. And then you, as the agency tasked to enforce on behalf of the public, you take cases, you prosecute them, you get competent tribunal, the specialists, court, competent tribunal, agreeing with you that you have a case. These firms are guilty of contravening Section 41B. And then you get the appeal to the Competition Appeal Court. When you get to the Competition Appeal Court says, properly characterized, this is not a contravention of the law. They let them off the hook. So what is this? What is this that firms can't be found guilty? They can't be found guilty. So you tell me, what is this? Because they are never guilty. And we know what they do. We've got evidence. They collude. Customers are suffering. Majority are poor. It's an old lady sitting in a village somewhere, just seeing prices going up. She doesn't know what is going on. We know. We take the case. We try to protect them as mandated by the law. And then we have a court that never says, yes, we agree with you. So what is this? Do we have to do this thing, or should we leave it? Because it can't be that all the cases we are bringing there. I mean, Temberger argues this case. Listen to him. The sense he's making when he argues them. When the judgment comes, he doesn't even talk to what he was saying. At some point, it's also just introducing things that the parties have never argued. So you ask yourself then, who is this? Which counsel have argued this point? That is in the judgment. That is the basis for the ruling. Who argued it? No one. So what is this? You tell me. You have ANSEC. ANSEC says nature, purpose, and effect. ANSEC is correct. They still say no defense for Section 41B. Correct. SAP comes, it says these distributors, they are existing because of SAP, therefore you can't say they are colluding. We accept that. Then the problem started with Dawn. Dawn says, no, the agreement is necessary to protect sensitive commercial information. Therefore, it's not a cartel. So it's a basis of saying this collusive agreement is not a cartel. Then you have Pest Africa, a council manager argued it. You know what it says? It says no. The person who completed the bid, see, these are two firms accused of colluding because they submitted bids that are the same in terms of price. It says the person who completed the bid is the same person. Therefore, these firms cannot collude between each other because one person completed the tender. So what it does, it then conflates, the legal status of a company with that of a natural person. We are accusing the companies of colluding. Then they say, no, the natural person completed the bids alone for the two companies. Therefore, this is a single economic entity. I mean, what is that? How we are being, I don't know, we are being uneducated here. So, you know that a human being and a company, they enjoy separate legal entity. They are separate. You can't conflate a human being and a company. They have their legal status. But you have a judgment that says, no, actually that thing doesn't matter. These things are the same. It's characterization. This is how it works. Of course, I agree fully. It's an amoeba. We don't know. They will not. The next judgment will say something that you have never even anticipated. Any of us here. So then you have Aranda. Aranda says no, because this one is a manufacturer, this one is a distributor. We properly characterize this is a vertical agreement, despite the fact that they submitted the same bid. They were competing for the bid. They says no, they are in a vertical relationship. You leave it. Then you get the Tuavest. Tuavest says properly characterize. These firms cannot be held to be competitors because they were not competing prior to the tender. So when you were not competing prior to the tender, you can never held to be competitors, even if you were bidding for the same bid. And our argument is simple. You are bidding for the same bid, tender, therefore you are competing for that tender. For that tender, you are competitors. CAC says, if you have never competed before, you can never be held to be competitors and therefore not in a horizontal relationship. And there's problems there. Anybody who doesn't compete now, they can collude on a tender, they will never be found guilty of collusion because they were not competitors prior to the bid. Then West, you get ING. ING, West. It goes further. You look, you say, okay, fine. I understand this one, I understand it. Now you have ING. Do you really understand ING? That you can collude and post facto say to a court that no, this agreement of collusion, actually, I was not saying I want to fix price. This wedding misses not. So it's supposed to be, we agree not to fix price. It's written, we agree to fix price. And they said, no, we are missing a note there. We must put the thing and put note. Our intention was that we don't want to collude. That's why a note is missing there. With your permission, court, can we include the note? And then the court says, yes, you can. So what is that? I mean, you tell me. What is that? It's characterization. This thing, we've got to find a way of getting rid of it. Otherwise, then we must just close shops. Because, you see, what that court doesn't realize is that when it weakens the competition authorities unnecessarily with these obviously clearing things that we can see, what then will happen is that the consumers of this country are going to be exposed to the abuse of business. And that abuse, unfortunately, the majority of these people cannot fend for themselves. These authorities are created to defend them. So you weaken them, and then you are saying you are building democracy. What is that? I don't get it. Thank you.
Yeah. Yeah, Mahale has brought a dimension which I didn't appreciate, which is that characterization is now being used to pierce the corporate veil. I'm picking up some form of collusion so far in the panelists. Michelle, let's break this cartel.
Happily. When Bake greeted me this morning, he said, you look like an angel in this white jacket. Clearly, my brief today, though, is to be devil's advocate to the Commission's approach to characterization. So let me seize my brief with some relish. And I want to make 3 points. The first is, it's not surprising to me that we're having this debate. So when Bake introduces the panel and says, first generation cases, hardcore cartel, successfully prosecuted by the Commission, including the characterization principle, and then describes a second generation of cases where the Commission is losing. The Commission is facing headwinds. So let's try to unpack, the first point I want to make is try to unpack why that might be, and it's not because of characterization. So the Act's been around for 25 years. The hardcore cartels that were high-profile, successful prosecutions, Bread, I think, was probably the first one that was really front-page news and went all the way up to the Con Court. The construction cartel and the Commission's fantastic fast-track settlement process, showing the extent of collusion that happened leading up to the 2010 World Cup. Criminalization then comes in. So any business person paying attention and reading the newspaper now knows there's this thing called cartel conduct. You pay enormous penalties, as we saw in the construction cartels and in Bread. And now I face criminal prosecution if I'm involved in this. We know that the Commission, and again, it's not a case of we're never winning as the Commission when we're always losing, because the Commission also routinely successfully settles Section 4 cases. So we know that there is still a successful track record for the Commission in cartels. But at this stage of our competition jurisprudence, at this level of awareness and consciousness and sophistication of the advisors to business, the type of advocacy that the Commission has done around cartel conduct. I mean, last week's Dawn Raid is making people go to their attorneys and say, am I guilty of a cartel in their industry, right? It's back on people's agenda. So it's not surprising to me that the Commission, without leniency applicants, isn't successfully prosecuting cases. There might be a different explanation for what's going on here than characterization being the problem. So the Commission's framing on this panel so far has struck me as one of the, that classic example of selection bias. You've probably all seen this thing. It's the diagram of the airplane that comes back from World War II sorties. And it's got the red dots where, the plane came back from flying in World War II. And they analyzed where all the bullet holes were, and they reinforced that part of the plane. The problem is, what they should have done is worked out that it's the opposite. The plane was getting hit in the other places, because those planes didn't come back. So let's look at the cases that the Commission is losing and work out whether it's because it isn't in fact a cartel, maybe. It's not the problem of characterization. So the first point I want to make is, given where we are in cartel enforcement in this country, it is a luminously successful track record by the Commission. And it's not surprising to me that in the third decade you would start seeing a decline in hardcore cartel conduct. What does that mean? That means we might have to do more 4-1A cases as the Commission. So there used to be a practice, back when I prosecuted bicycles, right? You pled in the alternative. It's a 4-1B, alternatively a 4-1A. Now, to put it crudely, again, embracing my devil's advocate role here, the Commission seems allergic to doing effects-based analysis. They say, oh my God, we can't do an effects-based analysis, it's a 4-1B. What's so hard about an effects analysis? The Mergers Division does it all the time. The abuse cases that are brought, we do effects analysis all the time. Market inquiries are effects analyses all the time. It's not that hard. So perhaps, given where we are as a country in cartel enforcement, I would suggest that we need to reflect on whether we need to start looking at bringing more 4-1A cases. There are these more marginal questions. There are these arguable cases. The reason the track record of the Commission at the moment isn't looking as good as it did in the first generation of cases isn't because the judges are biased and against them. It might be because these are tough cases. So you win an I-way, but you lose an Aranda. You know, you win in the tribunal, you lose in the CAC. It's because these are very exquisitely balanced, complicated, nuanced questions. So if only it were as simple as picking up the agreement going, oh, it's competitors discussing price, it's price fixing. Unfortunately, the world's not that simple anymore, I don't think, given where we are in cartel enforcement in the country. So the second point I want to make that flows from that, and seizing the opportunity of the fifth commissioner's first day, and leveraging off the previous panel, which was a fascinating step back to look at the questions of institutional design. I want to make a point here to say the way the Commission approaches cartel enforcement seems quite siloed off from the other enforcement action. And we saw how Machale and his team used all of their skills in the COVID excessive pricing cases. They were redeployed into COVID excessive pricing cases and produced settlements that were effective interventions in timely fashion. They produced a raft of consent orders that the tribunal confirmed. So I want to raise a question and say, well, why shouldn't enforcement sit together in the Commission? You know, why shouldn't we have, obviously there will be people with experience from cartel cases, but it makes sense to me that the Commission is structured to have people focusing on mergers, focusing on market inquiries. Why isn't enforcement sitting together as a way of thinking? And that brings me to my final point, which is characterization isn't special, and it's not special in the Act, and it's not special in the law. What do I mean by that? Characterization is in section 4, 5, 8, and 9. When a client comes to see me and they describe an agreement or a transaction or a relationship, an arrangement that they're busy engaging in, what's the point of that consultation? We hash out the facts and then we have a debate. Is this a notifiable merger? Is this a section 5? Is it a section 4? Does it in fact engage other areas of law? Should you be bringing a breach of contract case rather? Should you be going to a different regulator? Is this a delictual claim? That's characterization. So when the Commission applies Section 5, Section 8, Section 9, the merger provisions, the Commission's characterizing all the time. So let's not single out Section 4 characterization. The Commission every day, depending on whichever department you're in the Commission, you're doing characterization. That's the deal. You know, the leniency application comes in, the merger notification comes in, the whatever it is. The debate that's being had is, where does this fit in the Act? How do these facts relate to the provisions of the Act? So the first point I want to make is it's not special to Section 4. It's not unique in the Act. And the second point is it's not unique in the law. So Endomeni and all the rest tell us context, text, purpose. That's how you interpret statutes and apply them to facts. It's exactly what we're asking people to do. So I would say this is an opportune time, both in the trajectory of cartel enforcement specifically, but also in the life of the Commission as an enforcement agency, which, let's be honest, has probably the best reputation and track record out of all of the economic regulators in the country. I think it's an opportune time to take a step back and have a reflection on where we are in this enforcement and where we want to put resources going forward. Because the challenges of big data, big tech, because of the concentration of the economy, abuse of dominant positions, some of the fascinating public interest debates that are happening in the merger space, seems to me that the learnings and the skills that the Commission has, that it's honed over the years in mergers, could be usefully used as a very effective continuation of its track record into those other areas. So I'm pretty sure I'm not going to get any cartel briefs, but I hope I've lived up to my task today, which is to be the devil's advocate and say characterization might not be the explanation for the jurisprudential track record lately.
Yeah, Commission Michelle is saying if you can't dance, don't bleep the floor. That these are Section 4(1)A cases or rule of reason cases that you have mischaracterized as cartel cases. Which brings us to the second question neatly and seamlessly, which is whether characterization is required as a sorting tool to sort out these Section 4(1)B hardcore cartel cases from the Section 4(1)A cases. What sort of analytical tool or framework can be deployed for the sorting function? Bill?
I think this is where an international perspective can be useful. Whether we're taking the framework under Article 101 under the Treaty of the Functioning of the European Union or Section 1 of the Sherman Act in the United States, both systems, one with a more specific statutory command that speaks about object offenses, the other with a common law developed framework that strongly resemble the list of prohibitions in 4B. In both instances, courts have developed, I think, some useful criteria that, to take Tim Vic's point, to anchor and focus what we're calling the characterization process. And again, I'm using that term simply to recognize that in the sense that Michelle was just saying, for an enforcement authority or court, you have to decide which label applies to observed behavior. My concern about characterization is it would depend a lot on the scenario we're talking about. The setting in which I would not open the door for exculpation is where, in a procurement context, for example, let's take three firms to compete with each other all the time. They have a tender, and they privately get together and decide who's going to win the tender, who's going to submit the low bid. I would hate for there in court to be an elaborate assessment about their competitive capability and an inquiry that begins to examine the likely effects of their collusion. What would the counterfactual be? And I'm assuming for the moment that that scenario is not at risk for purposes of enforcement here, but I would be worried if it was. That is, that the concern I would have is if the decisions involving the airport concessions, meatpacking, begin to open the door to raise questions about the effect of that kind of simple scenario, which in most jurisdictions gets condemned out of hand, in some jurisdictions sends you to prison. So what are the appropriate questions to ask to decide whether behavior is going to be put in the per se basket by reason of the statutory command or subject to a more elaborate inquiry? I think a key starting point is to ask, is the good pro-consumer, pro-purchaser benefit associated with the collaboration? And what's interesting, I think, in this foreign jurisprudence is that courts have identified a collection of arguments that are simply not recognized. It's not an argument to say, for example, that we weren't directly competing before. That argument gets zero recognition. The price we set is a reasonable price, no recognition. The petition is destructive because we can't survive in the business. That doesn't get any recognition. That is, there are a host of reasons often in characterization that courts have decided are not cognizable. And the jurisprudence is clear that if you make these kinds of arguments, you can save your breath. The argument that we take seriously is the argument that shows that the restriction in question was directly related to accomplishing a significant benefit for the buyer of the good or service. If we go to the airport concession example again, imagine that we have 3 smaller firms. None of them large scale of operations. None of them individually probably meet the tendering thresholds identified by the purchasing authority. And all 3 agree to combine for the purpose of making a single bid that combines all of their capabilities and resources, with the idea being that if they were not able to collaborate in that way, they couldn't bid at all. That has a real benefit for the purchaser. This is another bid that wouldn't take place otherwise. The firms individually were not capable of submitting a bid. That's the kind of argument that has a pro-purchaser, pro-consumer, social benefit that would not be associated with a simple decision of 3 rivals to decide, let's determine which of the 3 of us is going to win in the tendering process. So I think maybe this is what happens over time. That is, in the next case, in the next series of cases. No, the only way to clarify this is to continue to bring the cases, seek the clarification. But the question worth focusing on is, let's agree that in some form, explicit or implicit, we have to decide in what channel the behavior is going to be analyzed. Is that process going to be an elaborate inquiry that draws in a lot of evidence, or is it going to focus very rigorously on the question of whether or not the restriction that was imposed has real benefit to the purchaser? I guess one way of asking it is, if the parties regard restriction as being so benign, would they tell the buyer in advance that they were doing it? Would they reveal that this is what we're doing? I regard that as a rough test of whether or not the restriction in question is good simply because it raises the profits of the party, or good because it's in the interest of the purchaser. But I think the lesson to be drawn from the international experience is that this process of labeling, of sorting, has been subject to a fair amount of discipline, to the extent that courts have been fairly rigorous in identifying what kinds of arguments entitle you to a more elaborate inquiry, what kinds of arguments are going to be dismissed out of hand. It's meant that full cartel scenario I described for you before is never litigated, because the parties know they have no good justification to offer, and they accept plea agreements, and many cases in the U.S. they go to prison. It is only the scenarios in which there is a plausible argument about benefit to the buyer in which a larger inquiry is appropriate. And I think it would be good if the jurisprudence is going to emphasize the characterization phase, these kinds of qualifications, I think usefully would be built in over time.
Bill, if I heard you correctly, you seem to be conceding that there is a limited role for characterization in its proper sense as a sorting tool.
Yes, there's always going to be a threshold question in some cases about whether or not what I did is a market allocation. Sometimes that's going to be pristinely clear, and I don't even raise the point. That is because an amnesty applicant has made clear to authority what I know myself, which is I was just allocating bids, rotating bids, or it's unmistakable that the documents obtained, that folder that Don Reed, that Tembi was referring to before, spells out the prices we're going to charge. That I don't even make the argument at all. But in other cases, there might be ambiguity in that. And in that sense, I'm imagining again the very simple initial question that comes up as I look at a set of facts is the behavior I've observed here properly called a market allocation or horizontal price fixing? But in large body of cases that we usually put in the category of cartel agreements, there's no ambiguity there. That process of characterization happens in the blink of an eye. Because we know right away that that's the basket into which the beef goes. The European court case in Carte Bancaire, this is the Article 101 case, simply makes the point that sometimes the objects are immediately identifiable there. And the sorting process takes place almost instantaneously. So much so that you get settlements, plea agreements right away. But there are other instances in which there is more ambiguity about what happened. And it's in that instance in which a more elaborate sorting process might take place. I'm simply, and maybe the vocabulary here is what gets in the way. I'm simply saying that if you have legal command that attaches decisive effect to whether or not a collection of actions fits within a category of conduct, there's always going to be an initial process, sometimes very fast, sometimes more elaborate, in which we decide whether the behavior I engaged in fits in the category. To that extent, I would say characterization is inevitable, but sometimes it happens with the speed of light, and it doesn't have to be more elaborate than the speed of light. And the jurisprudence, certainly in the United States, increasingly in Europe, recognizes that the opportunity to offer a justification is very strictly conditioned by the type of justification you offer, and that there are a host of arguments made that are no longer recognized. And that means that because parties know you can't raise them, the process of characterization in cases moves very swiftly.
Thank you, Bill. I'm going to cross-examine Advocate Ngugai Toby now. Do you accept, Advocate Ngugai Toby, that there is a need for a sorting tool or the threshold question as Bill frames it? And if so, is characterization not supplying that sorting tool?
No, I agree. I mean, otherwise the entire analysis would make no sense. I think there are two things I want to say before I answer you directly. The one is that we must take seriously what Bill actually says about the US experience and how his analysis of the recent judgments by our Competition Appeal Court, in fact, are a departure from the American understanding of characterization. Yet, the anchor of South African characterization is US law. So that's salutary, what he's saying, and it's actually quite sobering listening to him. The second thing to take seriously in this conversation, again, it's not a controversial point because there is not, is the idea that characterization has had shifting explanations and shifting justifications, right? Sometimes it's been used to say that parties are not competitors. Sometimes it's been used in order to provide a redeeming feature of an agreement. And sometimes it's been used as a combination of the two, right? So the fact that you've got a legal doctrine that has no fixed anchor explains the frustration of the Commission about how characterization has progressively over time been used to blunt its ability to successfully prosecute. Now, this is not a question about whether they should be using 41A or 41B. The question is, how should they prove a case under 41B? Because the case that is before the tribunal or before the CAC in a given case is a 41B case. So what we know from these two preliminary remarks that I've made is that it seems that quite common ground that the impact of the introduction of the doctrine of characterization has been to blunt cartel prosecutions. Now, you are asking us about the necessity of a sorting tool. Bill calls this a threshold question, and that is correct. But no one has ever argued that there should be no threshold. But the question is, what is that threshold? In South Africa, we have an act that tells us the first thing you look for is whether these people are competitors. If they are not competitors, and that is a statutory threshold question, that's the end of the debate. There is no need to relabel that as characterization. The second thing you have to look for is whether there is an agreement. Right? That's the big debate in Aranda, that you cannot just infer the existence of the agreement, you have to prove it. That too is a threshold question, without which you are not in for 1B. And the third one is the agreement under one of the three categories? Now that too is a threshold question of fact. Once you have answered those three questions, it seems to me that is where the scope has been opened for an additional requirement to show that it has the character that is likely to impinge or restrict competition. But that is not in the Act. And this is not about choosing whether to apply the Constitutional Court, well, Supreme Court of Appeal judgments on the interpretation of contracts. It is a question of applying a statute to a set of economic relationships. So the threshold question is answered by the statute itself. If you are wrong on one, these are not competitors. You are wrong on two, there was no agreement. You are wrong on three, the nature of the agreement is not as to divide markets or agree on prices or collusively tender. That's the end of it. So the argument is that's the threshold question. And if you can answer that question positively, that's the end of the debate. Now, this is again not new. A proper analysis of the jurisprudence of the tribunal prior to ANZAC, and in fact, subsequent to ANZAC, because there was a point when the CAC became very upset with the tribunal, that it is not following its guidance on characterization. And then the tribunal tried to subsequently catch up with the application of the doctrine, right? So again, this exercise I'm talking about has been done by the tribunal. And there has now been this new thing that is in addition to a statutory analysis. And that's where the objection is to this idea of a characterization. It's not to tell the Commission that it's better if they prosecuted cases under 4.1A or 4.1B. The question is, what are the elements of 4.1B?
Yeah, Tembeka has formulated then the, let me not call it characterization, but the statutory analytical framework that then ought to serve as a sorting tool then for distinguishing or drawing a line of demarcation between per se and rule of reason. Of course, as a moderator, I don't want to get carried away and say that I agree. Isabel? The threshold question.
The threshold, well, I think that while it's true that characterization happens in many sections and it happens almost organically in most legal discussions, there is something distinctive about cartel conduct which the Act and the jurisprudence has recognized, and that's what information is available and when is it available, because you can have a client come to your office with facts and you can have a merger application providing you the information, or a leniency applicant who comes with information, and then it is quite a simple thing to characterize where do we put this. But often with cartels, you face the problem of a secrecy or a lack of information, lack of evidence, and you have to, I guess, interpret where the Act is leaning when it comes to that, who gets the benefit of that that tension? Is it to the benefit of the Commission because it, faces the problem? Is it to the benefit of the firms because they're the ones without the statutory power? And again, I think that's a policy question and a legislative question. And I was also interested in what Bill was saying about the real question at being, when it comes to a case, is there a benefit to the consumer ultimately or not? And I think that one of the questions that we're facing is when it's not a specific case, but the idea of a per se deterrence, where do you reach the line where there's a benefit to having a very strict limitation because you're able to have quite strong deterrence, and where do you have a problem of over-deterrence and in fact harm to the consumer by having too strict of per se rule? And again, that would be something for, I guess, economists to think about.
You are very tactful and very diplomatic, I must say. Mahal.
Yeah, you see, this debate of per se prohibition and rule of reason, I think it's going in the wrong direction now. You see, there's a view that we must take 4.1a cases, a rule of reasons, as opposed to taking 4.1b cases. So in other words, when we get a case, we must say we are investigating this case as a 4.1a. It's not a cartel. It's a 4.1a. So they want us to look at a different direction. So in fact, it's even getting crystallized that there's a call for enforcement to be matched. So they are saying cartels must join enforcement so that they can do a rule of reason analysis and stop policing cartels. You see, this is what is going on. So Doris, you've got to decline that invitation. It may be very tempting. I would advise you to decline it, because you see, when the Scorpions was effective, there was a call to disband them. It was disbanded. Then what happened? You are in a state capture. So you've got to be very careful about these calls. We can see them rearing their head. You can see this. Commissioner Wanagel, hardly a day of your work, your legacies they want to dismantle it. You establish the cartels division, now there's a call that it must be merged with enforcement so they can do a rule of reason, stop policing these cartels. Doris, I'm saying you must say no. It must never be, it must never be on your name. Whoever wants to do it, they must do it on their name, not yours. Yours is a no-no. So this is the thing we are dealing with. You see, this issue of characterization, rule of reason, wara, all these things, they are together. These things are together. The idea is to shut down cartels because they are effective in policing and prosecuting them, so that you can have an agency that is toothless, is not able to catch those crooks there and prosecute them. That is all. There's nothing like anything else. That's it.
Yeah, Michelle, I would like you to respond to my question. Not to Mahali. This is my question. I know as a senior counsel, you'll find a way of responding to Makgale, but this is my question nonetheless. Is there no risk here that a statutory analytical framework is now being substituted with a non-statutory analytical framework? And of course, that has all sorts of implications for the rule of law.
Short answer, not nearly as entertaining as my neighbor. No, it's not. 2 points why and where we need to go. The first is Section 4 in its entirety is policing cartel conduct, right? The fact that it's drafted into 41A and 41B is a feature of when it was drafted. We managed to leverage off the experience of the US and the EU and codify the hardcore, unlikely to have pro-competitive effects, unlikely to have redeeming features. Those are the 3 categories of conduct that we codified in 41B. Section 41A is a potent tool against collusion. Let's not pretend it's not. So the first point to understand is the codification of Section 4 still matters, right? The reason that it's split into the 2 categories is because we know there is a hardcore category of collusion that can never be defended. Everything else, we need to develop the law. That's what Bill's talking about when he's talking about how things are progressing, right? We just took advantage of the fact that the rule of reason per se distinction had been judge-made up until that point and codified where that development had got to by 1998. So we're always going to have debates. We're always going to have contested litigation because we have to still define where that boundary is in the more marginal cases. And so I want to make a related point, which is to say, we're straying into this territory of, that famous thing where the US Supreme Court was considering when something's pornographic. And the pithy line was, I know it when I see it. But if you know it when you see it, then you're exercising enormous power, right? And let me give you another platitude. With great power comes great responsibility. So because you can criminalize, fine with 10% of turnover, and cause reputational harm, all of it utterly deserved. Let's be clear, utterly deserved. Hardcore cartel members must pay the biggest penalties, and they should, their directors who knew what was going on should go to jail. No one is here looking for a soft approach to collusion. It is correctly described as the worst of the worst. What I'm talking about is responsible regulation of the marginal cases, where, unlike the description that the whole panel's been using, where it's a very quick sifting tool, it's a very quick answer to the threshold question, because you do know it when you see it. And that's why my colleagues who are based in Sandton consistently go to the Commission, go to Makgale and say, I need a marker. I need a leniency application. I need to settle with you because my client has contravened Section 41B, no questions asked. So when we are going to trial in front of the tribunal contesting a 41B case, it's because there are colleagues who are equally committed to upholding the competition law of this country, equally committed to making sure that people are held accountable where they need to be held accountable, but not prosecuted where they haven't contravened. Because that is an abuse of the enormous power that the Act creates. So, especially in the context where there can't be a costs finding against the Commission and the tribunal. So the luxury of testing cases for guidance means we have to do careful case selection for when we go to the tribunal, and that's why I do again repeat my call to consider reverting to what we used to do in the first generation of cases, where there was an alternative pleading. Or let's bring more Section 41A cases to test how far we can go on the conduct that may well be a restrictive horizontal practice, but also may be completely benign. And that's why the regs that the Minister gazetted for comment, exempting SMEs, are so interesting. because there's a recognition that collaboration matters in this economy, which is stagnant. And we need to also look at that policy context and framework. So I would make another final comment. I would love to see all of the passion of the Cartels Division directed at sorting out criminalization. Because criminalization hasn't been used yet because the way it's been drafted is a complete constitutional nightmare, right? That ability to correlate the constitutional provision that the NPA is the only prosecuting body and the way the criminalization provision is framed that seems to imagine the commission playing some role, it can totally be sorted out. Let's sort out criminalization and actually put someone behind bars like they do in the States. So rather than rejecting everything that came from the States, why don't we embrace that part? Because we haven't properly prosecuted any of these cartel members yet. So I would like to see a renewal. So Doris, since we're putting things on your to-do list uninvited, I would like to see the Commission re-engage with the NPA so that we can. I mean, we all have this frustration about where are the state capture prosecutions? What's going to happen with the Zondo Commission prosecutions? Are these people ever going to wear orange? I have the same question about cartel conduct. I have the same question about, Steinhoff. I have the same question about all sorts of other things. But, let's put someone behind bars for a cartel case. That gets you some more enforcement and, will continue to build on the Commission's track record for the last 25 years. Thanks, Marke.
Thank you. Mpumi is looking at me with her eyes.
I have a proposal, though. I have a proposal, perhaps, because this panel is lit. And I think everyone wants to hear from this panel. This has been one of the most elucidating conversations on the topic, and we don't really want to stop. So the proposal is, lunch is ready, and those who want to filter out may do so, if we can just have some compromise about the noise outside, and we'll continue with this panel perhaps for another 20 minutes, if that's all right. I know that there's questions and answers. I wonder if there's members of the crowd who want to pose questions to the panelists. I don't want to deprive you of that chance. So you can make your own choice. Your blood sugar or people in orange?
Mpumi, I'm afraid that
10 minutes.
That is a sort of a Hobson's choice that you are giving the audience to choose between their stomachs or listening to the debate. Yes. We were about to do that. If we can just get indications of anybody who would like to Advocate My Nature Commissioner. I forgot your name. Yes, there's a hand over there.
Yeah, thanks. I'm not asking because I've been on opposite sides with Tembeka. I actually love being on opposite sides with him. But I just want to understand, maybe from Bill, and what Tembeka described as the statutory framework, analytical framework, whether in his understanding and perhaps Bill's understanding, what you're describing is not in substance the same as what ANZAC actually said must be done. In other words, you look at the statute and you determine the ambit of the prohibition, then you look at the conduct and you ask the question whether it is the kind of conduct which the section strikes. It strikes me that you are defining the same thing in terms of substance, but we are differing first in terms of terminology, but also perhaps criticizing how the CAC has applied the characterization test over time. So if the CAC was applying the ANZAC test properly, which is derived from the US, without naming it, in my view, substantively, it will be doing what you said is the correct analytical framework. And perhaps you and Bill and the others could reflect on that. I've had Michelle on the other side in Africa as well. So, thank you.
Bill?
I think that's a great question to move the discussion further. Although I'd like to know first, when do I get lunch? Is it going to be delivered? secondary consideration. Maybe, how does this discussion go ahead? I had a supervisor who once put developments in 3 baskets: the good, the bad, and the don't overreact. And I wonder if a way ahead in this discussion is to take Tembeke's last observation combined with our colleague's comment from the audience and ask, is the terminology we've been using here, and maybe is the terminology that's been used by the judicial tribunals, maybe most suited to the problem we're trying to address? I think we would all agree that when you have a statute that has a set of prohibitions, there will always be a discussion about whether observed behavior fits within the prohibition. Whether we call that a threshold inquiry, whether we call it characterization, we have to decide whether the conditions for applying law have been met. And maybe there are a host of questions we can identify clearly as being threshold issues of eligibility for prosecution. Plurality agreement, the plurality requirement of Section 4 satisfied. Is it a single enterprise or wholly owned subsidiary issue? That is, all of these questions of whether the essential conditions for the application of the statute have been satisfied. Maybe we have a different label to that. And then to put in another basket, the question about whether conduct that has ambiguous features. And let me mention what I mentioned by the ambiguity. I'm not talking about those films from the licensing cartoon, which are useful for all of us to look at it. Here are the direct competitors sitting in a room talking about how they can reduce output and raise price. They are laughing at the enforcement authority. They do not have a good story to tell. The only question they were leaning on is what this agreement. They lost that decisively. So that's a clear scenario that we can put to one side. And as a footnote to that, I'd be worried if the further elaboration of the characterization jurisprudence casts a cloud over whether that's going to be forbidden. That I'd be worried about. I don't sense that that's happened yet. But I think the further question as part of our discussion, and maybe that's a workshop that the authority internally, maybe it's a fuller discussion that takes place with the larger community in the country, with the academic hubs in South Africa, with practitioners to go through concrete scenarios. But the third harder question is where there is a legitimate, plausible justification for the conduct, that is a justification that is true to the objective statute, where, to use my example involving collaboration of a number of small firms in order to bid, why would we put that in a different basket? In a sense, by agreeing to bid together, they've implicitly decided we're not going to bid individually, but individually would be futile. And let's even further imagine that they told the procurement authority this is what we're doing. Have they revealed the potentially suspicious conduct to the purchaser? Or have they kept it, preserved it covertly? But I think about structuring the conversation so that we properly identify the threshold questions, and I like the way Tembeke has identified that. We identify those as a distinct set of questions, but then we isolate the larger and harder issue about whether the behavior in question has positive attributes, whether it is worthy of full inquiry, because the restriction we have observed serves a valuable pro-consumer, pro-citizen economic purpose as well, and how we go about testing that. But I think, again, if I look at the jurisprudence outside of South Africa, if we look at the bottle called characterization, there's a warning label on the back that spells out how you apply it and how careful you have to be about what kinds of arguments you accept. being a basis for fuller inquiry?
Thanks, Bill. I thought the answer would be brief. That's why I was taking this. Tembi.
Bill is never brief.
I misunderstood. I thought not 5 minutes, but 50 minutes.
He's delaying our lunch. I just maybe a comment and the question is going to be very quick.
Oh yes, we understand.
All right.
I disagree completely.
Yeah, we can sort it. I think the question, it's an interesting debate, right, on the approach to the law. I just want to say that it's got huge implications for investigation. So I understand exactly what Michelle, you're suggesting, the alternative pleading. But actually, once you get into that, you have to do this deep effects analysis, and that means investments in economy. So it seems to me that with your approach, you have to concede at least that what it means is fewer cartels, because, you know, enforcement cases we have experience. We know that you can only take a few of those, and it's understandable why you would take a few of those. It's impossible to finish them quickly. It's also impossible not to spend a lot of money on them. You're always going to do that. So I'm saying that it's an investigation question. And with respect also, it's not correct to say that we do this all the time in mergers. We get over 400 mergers a year. The economic analysis is probably 1 page, right? In 85% of those cases, 90% of those cases. The real cases where we do a proper deep effects analysis constitutes, I can tell you, less than 5% of those cases. In fact, those tend to be the measures that gets to be prohibited. And if you look at our prohibition record, it's very, very low. So what it means is that it's a question Eleanor has raised before, is how much resources do you want to put in a developing country competition agency to do this complex analysis, which, by the way, Europe says is not necessary. You know, so that's the trade-off. It's not about whether it's wrong or right. It's about where is the policy, you know, because it's about resources. You know, how much do you want to invest in this deep analysis? And of course, accepting that, then you are going to have less enforcement, even if you make that choice that you are going to do that effects analysis. But that's a question. That's a comment. The question is, on criminalization, what are you suggesting needs to be done?
Sure. And I'm going to take 1 second. So I absolutely accept that the Commission would have to make a new resource allocation, right? It would have to prioritize and identify cases that are worth putting the additional time and energy into to do what a 4.1b would require. My proposal there would be to say, okay, so let's identify categories of conduct that are these marginal questions. So it might be looking at joint ventures. It might be looking at restraint clauses. It might be looking at, I can't think of another example, but, you know, sort of drawing from the case law. And you sort of go, okay, this is a common commercial practice, relatively common commercial practice. So a test case on that type of conduct would be useful precedent to, you know, to enrich and deepen the precedent that we've got on on cartel conduct. So yes, it would require the Commission to do an exercise of identifying a case that looks as if it might unlock a typology of that kind of conduct on a range of sectors in the economy, and let's test it and let's do that work and identify a good set of facts for a good 418A test case that could then, and I do think that enhances, deepens, strengthens cartel enforcement, because you start expanding the range of prohibited practices away from the hardcore that we all understand and comprehend, and come rushing off to the Commission on a leniency application for. So you would start expanding the terrain for cartel conduct if you picked good cases for common commercial features that the Commission is concerned about. But I accept that it means a lot more work has to be done. On criminalization, I think the Act probably needs to be amended again, right? The criminalization provision needs to be addressed, because the way that it's currently framed raises all these constitutional problems about whether you're undermining the NPA's independence as the sole prosecuting authority according to the Constitution. And then regulating that framework around the, if you cooperate in a cartel case, the Commission will argue for sort of mitigation, will argue for some kind of leniency in your criminal process. Those are procedural questions. Those are process questions. The NPA and the Commission can work those out. And it would take another legislative amendment to tailor that properly. And I don't know the detail, but my understanding is there is some kind of MOU or some working arrangement. You've had lots of engagements already with the NPA. I don't know what those are, obviously, but my point would be, let's operationalize something that's constitutionally compliant. Maybe it's a prosecutor seconded across to the Commission to do this work, same way people get seconded across to prosecute for SARS. Or specialist units that are now picking up the Zondo Commission recommendation cases. So there's a way to deploy NPA resources in companion with the skill and expertise of the Cartels Division at the Commission, and let's actually prosecute some people and put them in orange. Tembi, looking at you, I now see James Sarge is wearing an orange shirt, but that's just coincidence.
Yeah, there was a hand, Abraham. Next to Manda, there was a hand. Yes, yours will be the last one.
Thanks for a great discussion. In view of the sentiments expressed minus Michelle, I'm kind of curious to know, with related to what the former Commissioner has just said about deploying resources wisely, what can we expect the Commission to do in going forward? Because it feels a little bit that you don't like the CAG decisions. And so I'm kind of thinking about, when you look at facts and cases that fall squarely within Aranda, Tourvest, INJ, are you going to press ahead with a cartel angle in the hope of finding a different outcome? Or are you going to be influenced, albeit not liking those judgments, to say, okay, we know that if a relationship is primarily vertical, like the SAB case, the prism through which it should be looked at is vertical. So exclusive territoriality in a vertical relationship is not hardcore, and so you look at it through that and you look at the effects, versus if the premise of the relationship is horizontal, then we are looking at a market allocation case. What can we expect of the Commission going forward? Because it sounds like you just do not like where the world is right now.
I'm assuming that question is directed at Mahale, because you are looking at him. Mahale.
Thank you, Chair. Two things. One, if we don't win the appeal at the Concord to correct these things, if the Concord doesn't want to hear us, because now initially they said there are no reasonable prospect of success. Now they are beginning to give reasons. There's some reasons that they provided when they were refusing us access to leave to appeal. So if we don't win that, in fact, we don't get the leave to appeal and we win the case, so it means then the door is shut. Then we must make legislative reforms. We must change the law so that we are clear about this issue of characterization. And if we can't do that, then we must close down.
There is one. Yes, there's a question online, and then Eleanor. I'm just going to allow then Lebu, and then that's it.
This is a question from one of the online participants. Am I audible?
Your mic is not.
Thanks. This is a question from one of the online participants, and it's directed at Tembega and Machale. It says, does it really matter whether the courts are inconsistent in which element of 4.1b must be characterized? Is it not ultimately about the nature of the conduct and its impact of the market? Are we concerned with maintaining commission wins, or are we concerned with maintaining effective markets?
Tembega?
I mean, that question explains the problem. You know, that's precisely the problem, is that the asker of that question, whether it's a lawyer or what, I don't know, is concerned about impact. Right? That's exactly what we say is wrong. This is not an effects-based analysis. There are two problems with this. I mean, you've had, you know, my story for the last 3 years. I was sitting here with Dennis Davis. And I asked him, what is the statutory basis for it? And he says he couldn't find any, but it's there. You can't run this thing on the vibe of it. You've got to run it on the basis of a rigorous application of the Act. Now, so I think also Hamilton's point, you see, Hamilton, I think you're actually right about where do we go from here, is going back to a proper understanding of ANZAC. That actually ANZAC didn't say these things that have now started creeping into the jurisprudence. There are two other points from ANZAC, by the way, that are included in the jurisprudence but are not in ANZAC. One is ANZAC said some agreements, by their mere production, will be manifestly restrictive, and they will fall under 4.1b, under 1, 2, or 3. The law right now is that there is not a single agreement that on the face of it is an infringement. Second thing is, ANZAC said some agreements would have to go through a process of characterization, which includes economic analysis. The law right now is that each and every agreement must go through characterization. Each and every agreement must be subjected to economic analysis by economic experts, which is a vast departure from what ANZAC actually had in mind when it was drafted. And so that's why it matters that there is jurisprudential inconsistency, because it leads to less predictability. It makes it impossible for the Commission to know what are the allegations to be made, what kind of evidence should be led, because this thing is shifting all the time. So if we were then to go back to ANZAC, assuming that ANZAC is the standard, what exactly would we have to show? It seems, firstly, you would have to go through the threshold question, the statutory threshold questions of competitors' agreement, one of the three categories. The question is whether after that you have to do any other analysis. Your argument is you might have to do something more, which is the conduct of the nature that would, but that seems to be tautologous, because you've already undertaken it in identifying whether the agreement relates to one of the three items. But what characterization does is it asks two additional questions if you are characterizing the conduct as opposed to characterizing the relationship. It asks two additional questions. One is there a competitive restraint that's been removed by the agreement? Secondly, it's always blurring the line on effects. And that blurring of the line on effects sometimes takes the form of asking whether or not the agreement has any redeeming features. You see that in a case like Dawn. Two clauses in the agreement. One is your typical restraint, another is a non-compete. The Commission says once you have a typical restraint, the non-compete can only serve an illegitimate purpose. Then there is a full analysis that actually it can serve another legitimate purpose, and for that reason it's characterized as being non-collusive. Now it's in that area where it's about the removal of competitive restraints, and secondly, about whether or not there are any benefits, efficiency benefits, But they won't call them efficiency benefits. But what they're trying to do is to find whether or not the agreement has any redeeming features. And that's where the blurring of the line has been. Because, I mean, sometimes when you listen to these economists speak, what they are doing is they're actually conducting an effects analysis under the guise of looking at whether the agreement has redeeming features or not. So it's those two that I've been arguing should be excluded from the analysis, either by the pure application of Section 4.1b as it is, or perhaps as you, I think, are suggesting, and you are going to be my opponent soon if we get set down. But if what you've said is what you're going to say at the Constitutional Court, then you and I will be saying the same thing. Your client will probably lose and not like you. Yes. No, Hamilton is actually in a good position here because he is both for and against the commission on the same point. So I don't know where his loyalties lie. Well, I know where his loyalties lie. His loyalties lie with the commission. He is... he is literally sleeping with the commission. So I think that if we are I think that if your point about ANZAC is that you can separate the statutory analysis and then introduce something else, I still want to push back on that, Hamilton, and say, what is the something else that you're going to put? Or you're not substituting?
You're doing the same thing. You're just calling it something different.
No, then we are completely together on that.
Professor Fox?
Thank you very much. So I wonder whether there is a missing middle that might be productive to think about. And this is it, that supposing that 4.1b is only for hardcore cartels, which would be pursued criminally, and there are other rather simple rules that you think, and it's right, that companies should not do, that would be civilly enforced, not criminally, and it would be developed under 4.1a. For example, and this is Karen and Beef and INJ, a rule that says you may not agree to discontinue manufacturing for Karen, and for INJ, you may not agree to never go. Let's see. Karen says it won't continue manufacturing, and maybe INJ says. Let's leave it there. So Karen says it may never agree with the distributor that I will not manufacture. So that kind of simple rule, which in the United States it gets into a quick look category, but it would be civilly enforced. And is there that opportunity to put these marginal cases that may not be hardcore criminal cases in that category?
So, Mr. Majenge, I'm so sorry to usurp you, but we do have a member of the panel who actually has to go. So I will allow, with your discretion, to determine which one panelist may respond to the comment. And then I must also apologize to Songezo because this is so much harder in real life. Thank you.
Michelle?
Last word. I think I agree with Eleanor's suggestion and, to the question about what to expect, nature of conduct, et cetera, I think, from where we started this panel to where we ended it, I think we know a couple of things. We know it's harder than it looks. We know it's going to take a lot of work. And we know that if we don't assume bad intentions, right? Santon mustn't assume the Commission's anti-business. Commission mustn't assume business is always colluding. Let's focus on getting the bad guys. And I think and then I would say precedent is binding. So let's move on to some new and exciting topics and debates, and let's put Commission resources into those, including, once again, sorting out criminalization for cartelists. Thanks, Pake.
Yeah, thank you. Thank you very much. Can we please give a round of applause to our panelists?
And to me, that's it. Thank you very much.
That was so well done. I must also apologize to Bill. I'm so sorry that I missed your virtual introduction on that one. We've got lunch now. And originally, I thought we were going to come back at 1:45. That leaves you 10 minutes. That's not possible. So what we're going to do is we're going to aim for 2:00. I know that there's lines and the rest, but we'll keep you up to date. We've got digital after lunch. Please feel free to, continue the conversations through the break. Thank you all for being so engaged. This was fantastic.
Also going to get time after this with Alexi because you need to work closer with his centre. We had a bit of a chat during COVID, but it was just too frantic. I mean, we were just fighting fires. But I mean, where that chat was useful is the common focus on pharmaceutical. And that's us trying to get some research. We've got quite a lot of strategic work on pharmaceutical. Obviously, the food chain is back in focus. That's where it would be good to get a little more time.
In a vote of confidence about South Africa's long-term prospects, New York-based food and beverages giant PepsiCo has made an offer to buy Pioneer Food Group, which makes Fesco breads and Series juices, in a deal worth over 25 billion rand.
The Competition Amendment Act came into force in July 2019. Barely 2 months later, a Simba Pioneer merger was notified to the Commission. So this is really the first time we had to, as the Commission, consider the implications of the new amendments, particularly Section 12A3C and Section 12A3E of the Act. So this was really the first time we're looking at this case through the prism of the amended Act, and it turned out to be a seminal case in respect of those amendments. This case provided us with an opportunity to learn a lot about how to give effect to the promotion of a greater spread of ownership. So there was a fund created which ensured that there was skills transferred to youth, small businesses and firms owned by HDPs, teaching them farming and other general business skills. There was also funds set aside to ensure that small farmers can access markets. Insofar as workers were concerned, we had to consider how they can meaningfully participate in the economy. And again, here we eventually reached consensus with the parties whereby they set up a certain percentage of the shareholding in the target firm, which was to be held in a workers' trust on behalf of the workers. And this actually equated to a value of 1.6 billion, and dividends would flow to workers from day one. So this set the template for later cases, whereby when we involve workers and worker participation, we expect that there must be no encumbrances to that shareholding and dividends must flow from day one. This case really provided a template from which we could take these amendments forward. And there were a lot of learnings. For example, we learned how to craft meaningful employee share ownership schemes that are truly transformative in the sense that they provide workers with board representation. They are unencumbered in the sense that workers can start enjoying the fruit of those dividends from day one. Some questions remain unanswered, such as, in which entity should workers participate in? Should it be an entity that is domiciled in South Africa? Can it be elsewhere? And these will obviously be further crystallized through the development of the jurisprudence. And I think we're looking forward to the conference where maybe some other views can be heard from labor, business, the legal fraternity, as to what their thinking is about how we can give meaning to these amendments.
The guidelines introduce measures for increasing consumer choice in terms of the service providers they can use to repair their motor vehicles, and also for the products that they can buy in the automotive aftermarket. With the implementation of the guidelines, consumers can choose to have their motor vehicles repaired by a service provider of their choice, whether an approved service provider or an independent service provider, such as a panel beater, service centre or approved dealer. They can also choose to fit original or non-original spare parts in their vehicles without voiding their warranty. They can also choose to purchase service plans, maintenance plans and other value-added products at the point of sale when they buy a motor vehicle, or they can choose not to do so. With our engagements with industry stakeholders in the sector, we pay particular attention to introducing measures that would increase participation by small businesses and disadvantaged groups. With the implementation of the guidelines, it can increase more opportunities for small businesses to service, maintain and repair motor vehicles that are covered by a warranty. It also increases their access to original spare parts that are sold by car manufacturers. and also allows them more opportunity to become approved dealers and approved repairers on the panels of car manufacturers and insurance companies, as well as increasing their access to training by car manufacturers and also the technical information that they need in order to repair in-warranty vehicles. There is still more work to be done. The Commission is currently monitoring the steps that are being taken by the industry in order to implement the guidelines. We are also engaging with industry bodies and associations that have supported the guidelines and are promoting compliance. And towards the end of the year, we intend to introduce a survey for the industry stakeholders to answer, which will allow us to assess the level of compliance with the guidelines by the industry.
There we are. Welcome back, everyone. Well, not everyone at this stage.
I think if we give 2 minutes just to herd people in.
Yeah, it's a bit thin. It's a bit thin.
Abram, maybe Salma, can we just herd people in? We just herd people in. I think they're coming in now, yeah.
And while they come in, I'm just going to outline that I need to inhabit the spirit of Songezo now. No jokes, no games anymore, unfortunately, as much as I love games, and ad-libs, and having fun with you guys. But while we let our crowd come in, I'm just going to ask for your patience in that there may be some questions that you want to ask that we may not be able to get to. And of course, the purpose of today is just to raise the debates, not to conclude, not to exhaust, but just to raise the debates. So I think there's still a couple more. James, how are you feeling? Do you want some more? Should we wait a little bit longer? Okay, couple more minutes. So at least I get, 30 more seconds of my dazzling personality for you. Yeah. All right. So one of the updates to the program we've had to make, unfortunately, in light of how, explosive our last discussion was, is we actually have taken out the competition hourglass on the preliminary OPMI report. My apologies for that. I'm so sorry. I know. I'm clearly a people pleaser. I just want to help everyone, but it's not possible.
Oops. On that note, I should state that we have statutory limits to the length of an inquiry. We're on schedule. I'm not putting you or Songezo in charge of an inquiry in future, because we'll be going to the minister for an extension, I'm sure.
100%, James. Okay, on that note, I will hand over to you, James. Thank you so much.
Thanks, Mpumi, and thanks for everyone. I know we have a short lunch, and I welcome everyone back. So we're back on digital markets, but digital markets has been at most conferences probably for the last 4 or 5 years, and some of the themes I think are a bit repetitive. So what I've asked the panel today, and I'll go through who we've got here, is we've got a nice selection of people from different countries, but we've now all started to act on digital markets. Every jurisdiction is doing something. And whereas in the beginning we were maybe theorizing what is important, how we should approach things, countries have adopted different approaches. They've prioritized differently about what they want to tackle, and they're starting to gain experience as to whether there is success or not in dealing with these markets. We've also seen, in response to that increased enforcement, at least big tech fighting back, as we would expect. And there may be questions around how we also respond to that.
So we're lucky today to be joined by Andrei Tseganov, the Deputy Head of the Federal Anti-Monopoly Service of Russia. We then have Helen Keane-Redpath from BRG, an economics consultancy based in Cape Town. We have Daryl Dingley from Weber Wenzel. So both Helen and Daryl are local, but have some, I think, global clients as well. We've got Yogesh Kumar Dubey from the CCI, the Competition Commission of India, and we should have online Pierre Horner from UNCTAD. I don't know if Pierre is with us yet. There we go. Welcome, Pierre. So maybe, Andre, to start with yourself, and I know you've got a presentation I think the team can just put up, but I think what's interesting around Faz's approach is you've adopted a mixture of soft law and hard enforcement. And as I said, I think this is interesting because every authority is taking a slightly different approach. And so if you can talk us through your approach, why you chose it, and where it's working.
Thank you so much. Ladies and gentlemen, it's glad to see all of you after the lunch. I'm happy that you are with us. I'm very glad to be a part of discussion on one of the most serious and challenging aspects of competition law development and competition law enforcement, the digital markets. And I want to focus on the FAS experience in this area, but from my point of view and from point of view of my colleagues, it could be useful not only for Russian market participants, but internationally. Next slide, please. Since 2005, the FAS of Russia has been actively exercising control in digital market, both in ex ante and ex post format. And our goals is to reduce or to eliminate the barriers to enter the market, increase the degree of the freedom of the consumers, promote non-discriminatory and equal treatment and equal access to key capacities of digital platforms and ecosystems, as well as to form transparent rules and environment for the development of the digital market in condition of close to fair competition. At the same time, there is a very serious problem, and you know that any governmental intervention couldn't chill the innovation and investment in this sector, so the policy should be effectively balanced. Next slide, please. And our goal is to provide effective conditions for the development of competition in digital market. And I think that it's important to note that in Russia, the national IT companies have grown and have taken a significant share on the market, almost in all IT sectors, and successfully compete with the international giants. Based on the specific characteristics of digital market, we define for ourselves the set of priorities for development of this market, and you can see this here on this slide. And the question is, what is more important? Hard law enforcement or policy that foster innovations and let the participants of digital market to work freely and to develop without any limits? So once more, the balance we need. Next slide, please. Yes, of course, we have a very active enforcement, but effective enforcement means not only biggest fines in the history of Russian competition authorities, and that will be imposed by the FAS and paid. This is very important. Paid by the violators of the competition law. And here there are two last cases of our enforcement, and I think that these cases reflect one more serious feature of Russian competition system: the equal treatment, the neutrality, because Google is a well-known international company, Yandex is the biggest Russian IT company, and both of these companies are clients of the Federal Anti-Monopoly Service. If they make some violations of competition law. Next slide, please. And we know that the digital markets are characterized by high network effects and high velocity. It's very important, and that's why the time it takes to eliminate the violation of competition law is often critical for the markets. And in many cases, it takes not months, but years from identifying the problems with competition and to correct the violation, and including the time for possible litigation. It will be 3, 4, maybe 5 years. In some European countries, we can see that it's no less than 10 years of the total process. And therefore, we strive to ensure that antitrust requirements are met with a reasonable time frame and with the best possible effect. And in modern circumstances, we see two most optimal and effective ways in ensuring competition in digital markets. It's legislative development and adjustment to the modern circumstances, and the promotion and stimulation of self-regulation of IT markets, and to find the balance between the prevention of the restrictions of competition and promotion of innovation and development of digital market is very important. So next slide, please. Here is main features of our new legislation, so-called fifth anti-monopoly package, devoted to and reflecting the specificities of digital market in Russian Federation. It includes some material changes in the law and some procedural changes also, because we think it's very important to make the process faster. Next slide, please. But both competition authority of the Russian Federation and participants of digital markets of our country understand that development in a competitive environment is the best way of development. That's why we strive to implement the specific mechanisms of self-regulation of the digital markets without hard regulatory interventions. Together with business, in the framework of the FAS IT Advisory Council that include the representatives of some other regulators, consumers of IT services and IT companies themselves, we developed so-called principles of interaction of the digital market participants. These principles are very simple: reasonable openness, neutrality, ensuring the autonomy of users during interaction with the platform, avoiding ambiguous formulation, you know that it's a problem, of the rules of digital platforms, and ensuring the set of rights of platform users, including specific rights to considering the appeals, right to complain, right to get complete answers for their questions. Next service. Developing these principles of digital market participants cooperation, just in June of this year, the largest participants of this market, including marketplaces and IT sellers of goods, signed another document, the standards of interaction of the market participants, both with each other and with consumers and providers as well. And the implementation of these standards into practice, I hope, will help to avoid most of the issues related to unfair interaction of marketplaces with their counterparts, including suppliers and citizens of the Russian Federation. This document provides the disclosure of information about services, volume of commissions for transactions, packaging requirements, as well as compliance with the terms of the offer and responses to sellers' requests, resolution of some disputes by a specially organized commission and non-discrimination of persons which are not affiliated with the digital platform and marketplaces. Next slide, please. Next slide, I think, yes. And why I tell about Russian experience? Because from my point of view, it's important internationally. Because for any country of the world, it's clear that the participants of the market, the digital dominant companies are implemented the same market policies and make the same violations of competition rules in all parts of the world where they are present. And we review the actions of digital giants that are committed either with global or regional boundaries and in the same way. At the same time, competition authority can protect competition only within their powers. And in the usually it's within the territory of the state or the territory of the regional group of countries. And from our point of view, unfortunately, this is not the most effective way to respond to the practice of digital giants. And from our point of view, the most effective solution would be to form common goals and perspective of the development of competition on national and global markets, and ensure that their achievements will be the tool that regulators have, sharing experience, sharing the best practices, and exchange the information and make some decision jointly if the legislation led to do it. And in this situation, the perspectives of international cooperation are extremely important. And we have some experience in cooperation with other competition authorities in digital cases, especially with our counterparts from BRICS countries, not only in the way of exchange the information about legislation, so on and so forth, but to consultations in the form of consultation on real cases of violation of competition rules. Moreover, the Federal Anti-Monopoly Service with our BRICS counterparts within the specially organized BRICS Working Group on the Research of Competition Issues in Digital Market. Sorry for this long, long name. 3 years ago, prepared the report on anti-monopoly regulation of digital markets in the BRICS countries. And following this report, now we are in the process of preparation a set of guidelines on anti-monopoly regulation in digital market, and I hope that it will be useful not only for BRICS countries but internationally from the global perspective. And we believe that such steps in enhancing international cooperation can help us to organize a soft but effective system for sharing data on investigations, measures taken to ensure competition and result achieved in order to ensure competitive development in the best way. Thank you so much.
Thank you so much, Andre, and I'm sure Pierre will pick up the theme of cooperation, and I think your vision for sharing data may be ambitious, but Pierre will let us know. I've got to just warn the audience that we might start to shed panel members through this process, as Helen needs to catch a flight at 20 to 5 and Daryl has a meeting at 3:30. But Helen, you work with clients locally, local tech companies and maybe some global ones. But we heard from Andre that at least in Russia, some of the local ones are now sizable participants in the market. That may or may not be the case in South Africa. I mean, do you think there's reason to distinguish the two? Because a lot of the global debates, to be fair, are focused on GAFA firms. And when we go there, at least with our digital inquiry, we say it's not really about GAFA firms, it's about local. And in that framework, there's a lot of activity now in the tech industry. Moving on regulations or stronger enforcement, do you think that could hamper domestic innovation as opposed to global?
Sure, thanks. Thanks so much for having me as well. So I think perhaps I would suggest to take a step back and ask, where do consumers turn to, just to first understand the scope of the market, to sound like a typical economist. But understanding, where do consumers switch to? Do they switch to international firms? I think so. Just starting at the basics there. And of course, in digital markets, this is likely to be more prominent compared to other traditional markets where you may not be able to transact so easily or engage so easily across borders. So definitely, I wouldn't be able to give you an outright answer about how often do local firms compete with global firms, how insulated are our local firms, or how protected are they already. That's a very product-specific, service-specific, firm-specific question. But I think everyone is aware of the fact that we have many fantastic local tech and digital firms, also many brilliant platforms, and we should be extremely proud of this. It's definitely, on my observation, not the case in many developed countries. And Prince and I were talking about it this morning. It's for many reasons. We have many supporting factors, good logistics, good payment systems. I mean, there are many reasons why we have such a well-performing market in this sense. So I think that's just to start with, what are we talking about when we think about local firms, and are they already constrained by global firms? Should we be trying harder to protect the local firms? As a side note, I should also mention, as you said, I also do work with some global firms, and I say this because for me, it's not just about boxing firms into local versus global. One should also be aware of the fact that many global firms that operate in a very specific line of service are very worried about, and I believe them most of the time, they are very worried about other global firms that have the depth and the breadth to be able to move into another market, to so-called envelop them fairly quickly. So local versus global, but also being aware that there are other concerns also with global firms. In South Africa, we also see global firms taking market share from each other very quickly. Anecdotally, in my own personal experience, I see so many people using Bolt instead of Uber now. I see the competition for streaming services. I'm purposely trying to stay away from the inquiry. The competition in streaming services, every month people are switching to a different streaming service. So I also mention this because I wonder if the issue is not so much about whether global firms might be weakening the competition or the presence of local tech or digital firms, but rather that South Africa is simply witnessing what we are seeing everywhere, where the global firms themselves are taking share from each other. Then to your question of should we, I think generally you're implying, should we be treating local firms differently to when we think about global firms? Should we be perhaps a little bit more relaxed about the regulation on them? I would approach this in the same way that I would any other competition matter. As I started off, understanding the market in question, understanding the positions of the firms that we're talking about, and understanding all the critical factors, barriers to entry, scale economies, network effects. I mean, a huge amount of work needs to go into that. And then understanding what is the problem here. In the case of a market inquiry, a feature of a market, or in other cases, an anti-competitive practice. So, of course, not regulation for the sake of regulation, but understanding what the problem is. And then critically, and I think this is probably something I feel strongly about as an economist, is thinking through and trying to find whatever evidence you can to think through the effects of what might be proposed. So whether you're regulating a global firm or a local firm, thinking through those effects. To pin this down to like maybe a concrete example, going back to what I said just now, if we regulate global firms with the intention of stimulating more local firms, is that likely to transpire? Similarly, if we regulate or remedy something on a local firm, is that likely to simulate further competition, further entrance from coming into the market? So I think that's most to that question, James. I know you wanted me to speak about mergers as well. I'm not sure if you want to touch on that a bit later or now.
Well, maybe as you may be most pressed for time, have 2 minutes. You know, we're used in the inquiry giving very short extensions. Yeah. So 2 minutes you have.
Okay. No, I'll be here to the end, not to worry. So the other point in passing that James said perhaps I can touch on is whether merger control, particularly with regard to tech and digital firms, hinders innovation. I'm sure the Commission has done brilliant studies on this, and of course there is not one conclusive answer on this. I think the best way for me to answer is to share from my own experience how I would approach a merger so as not to perhaps make an error in judgment. That is to say, you know, as firms come to me and say, we see horizontal competition, we see price effects here, we really strongly advise against this. There are obviously many other things that you need to consider, innovation being one of them. Often it may be dressed up under potential competition, under efficiencies, other things, but you need to also consider innovation. And I think the way in which I would unpack this when I was, thinking about this question is to just understand a few basics. So firstly, I would set aside the merger entirely and ask what in this industry drives innovation. For the reason that often one thinks that the merger is sitting in front of you, and like everything hinges on this merger, innovation happening or not happening, and often it's not. There's, might be many factors such as capital or IP law or putting certain people and resources together. Many other things drive innovation beyond mergers. So just understanding the broader context. And then understanding the rationale for the transaction. A little while ago, I dealt with, I won't mention any specifics, a merger where it was a combination of two very high-tech firms. These were players, say, position 2 and 3, where the firm number 1 was streaks ahead of the rest of the market, and 4 and 5 were also considering a merger at the same time. And putting the two firms together, their two technologies together, although there was some horizontal overlap, also these totally different technologies, putting them together would allow for an entirely new product offering that has never, like quite literally never been seen before. So understanding this whole bigger picture, I think, is really critical to ensure that, as an economist, I don't make an error in judgment advising, that this is going to be a very problematic merger and perhaps missing a bigger story that is there. One thing I should also mention on rationale is on global transactions, which are quite prominent in, of course, this space. Liberty and I wrote a paper, and another colleague wrote a paper a while back. It was called Playing Golf with One Hand, and it was all about how clumsy or smooth a merger review process might be, depending on whether you understand the global context, such that, say, a structural remedy in one country, South Africa in that case, might detract from the bigger picture of efficiencies, and maybe other conditions might be better, even more so if there isn't a suitable buyer, then licensing, pricing, etc. might be a bit better. And although that was dealing with efficiencies, I think similar might be said about innovation, understanding the global picture, understanding South Africa. Last point I'll make, 5 seconds.
You're out of time, but all right.
Last point is, I think something that's very overlooked is the people aspect of mergers as well. I know this is a tiny paragraph in most reports, but often entrepreneurs start businesses, they want to move on, they want to hand it over to someone who's capable, they don't want to sit with a big firm, and so naturally there would be many transactions around them, and the product or service would fare better in the hands of others. Same with family businesses. Often people see that they've taken it as far as it's going to go. So I think these are my thoughts on how I would check to make sure I'm not advising against a transaction that may be innovation enhancing.
Yeah, and it is complex, and I can understand why Michali doesn't want us economists involved in his area. Daryl, you represent GovChat. You brought an interim order. You brought the complaint to the Commission. It's now been referred to the tribunal. But it has been a long road. I can't recall when it started. So moving from the economics to the law, I mean, again, we have started to work in digital markets, but what do you see as working at the Commission and what's not working?
Thanks, James. I think maybe I just want to start off by just highlighting a couple of points in introductory comments. I think the first one is that I think there's a number of shared understandings which have developed over time. When I talk about shared understandings, what I mean by that is, we know about the fact that the web has spurned all these new industries and new businesses. We are aware of disruptive innovation. I think we're also aware of the benefits of data, but also the challenges around data. We are aware of markets where there are zero-priced products as well. So we're aware of some of these challenges, but at the same time, we know that it's revolutionized the way we live. It's how we do business now and how countries are run. We acknowledge that there are all these benefits. So I just want to sort of start off with that, and then to say that I think that South Africa is in a very unique position in the sense that we have sharp tools in the toolbox. I think that we have very modern competition law. We are able to, for example, look at creeping mergers. We look at partial shareholding structures, cross-directorship issues. The authorities have the ability to issue guidelines and practitioners' notes and to prioritize sectors and to start market inquiries. So we're in a very unique position. And, together with these shared understandings, I think that we're very well placed to look at competition matters as they relate to digital markets. But there are some problems, and as James has highlighted, timing is one of those key issues. So I thought that what I should touch on really is, in fact, two cases. I know James only mentioned the one, but I actually want to touch on two matters. One is the GovChat matter, and the other one actually is in relation to the PSS, which is an organization that represents all of the major news publishers in the country. So the first one, just to give some background and context to that matter. So GovChat, in July 2020, I'll start there, Facebook, now Meta, decided that it was going to, and expressed an intention to offboard GovChat and hashtag Let's Talk, which is a small tech startup that connects government and its citizens in respect of a wide range of service delivery issues. It does so through the use of the WhatsApp Business API, which is an interface. And Facebook, at the same time, has also imposed a whole sort of wide-ranging use of and enforced these what we call exclusionary terms and conditions that regulate the access to that WhatsApp API in many respects, particularly in respect of access to data. Now, those terms and conditions effectively shield Facebook from potential competition, such as that presented by GovChat, and the data which it harvests to produce these products and these services. But GovChat uses this API really to gain insight in real time in relation to these digital issues, and obviously offboarding would cause considerable consumer harm and also impact upon innovation. So this matter we initially launched interim proceedings towards the end of 2020, and we were granted when I say we, my client was obviously granted an interim interdict, which then ran for 6 months and was then extended for a further 6 months, and then the matter was referred and has been referred now to the tribunal for prosecution in March of this year. But you can see from that timeline that it's a very long one. And there are a number of problems with this, of course. You only have interim protection for so long. And it's obviously very costly to bring these kinds of proceedings. The other problem is, of course, dependency. So, when you are a small software vendor, you are dependent on the platform for your business. And, of course, during interim proceedings, to some extent, the status quo has to be maintained. So you can't develop new functionality, new products that you can bring to the market. So you are almost fighting in the market now with one hand tied behind your back. So if I look at that and then I say to myself, well, what, in light of international cooperation and in light of these common understandings around these markets, how could we improve the situation? I think that what's important about this case is that it actually mirrors very much US antitrust cases that have also called out Facebook's treatment of developers. The company there has been accused of allowing producers of software to use, for example, Facebook's data to develop their own apps and to connect them to its services, which benefit Facebook, one, because more people can join the platform, and it benefits from that. But then also it gets a good insight into the application itself and its popularity. And then what they've done is that's what the US authorities call, to unlawfully buy or bury, where they initially try to buy those businesses, alternatively to try and shut them down and remove them from the platform, which is really very similar to the situation in South Africa, where you have GovChat, that very innovative, developed a fantastic product, generated a lot of interest in that product, and then was threatened with offboarding and had to deal with these very difficult terms and conditions. So I think that if there was greater cooperation, perhaps preemptively between authorities, prioritization of these kinds of cases, perhaps that would have assisted someone like GovChat and helped to alleviate some of these lengthy time questions. I suppose the second matter which I wanted to briefly touch on was the PSS matter. And this involves, again, Google and Facebook, and also has an international flavor to it. So PSS, as I said, is an organization that represents the major news publishers. And I should also add that some of the smaller news organizations have also joined in this matter. And what they did is they took advantage of the marketing inquiry to make representations to the panel, and those representations are in the public domain and available on the Commission's website. But through that process, they were able to express a view that their revenue streams are declining significantly, and this is really inhibiting their ability to transition from the old sort of publishing world into the new digital world. It's very important that they use these platforms as a distribution mechanism, but they are hindered in that they are threatened by the ability to compete on the merits, because as you know, some of these platforms are also vertically integrating, and they are struggling to generate revenue and access to data, because these platforms are the gatekeepers to that data, and that data is important for them to engage with their consumers and also potentially revenue generating. So they've made their case known, and now the interesting thing about this matter is that what they've proposed, and this is again also in the public domain, is a new set of legislation to deal with these problems, to deal with the imbalance in market power between the publishers and the platform. And this is not too dissimilar to what's happened overseas, where in Australia, the Australian authorities have come out with a news media bargaining code, and this has actually compelled Google and Facebook through Meta to pay a reported $200 million in the first year alone. And now Canada, their authorities have followed a very similar law and very similar process for media companies to be rewarded basically for their work. So in South Africa, the proposal is again a sort of negotiated to arbitrate kind of model, very similar. And I suppose through this kind of process, one circumvents the problem of initiating complaints and the lengthy process that follows investigations. There's also all these learned experiences overseas and the possibility to engage with the Canadian and the Australian authorities, for example, and to emulate what's been done there, which could alleviate these problems in respect of this sector or this part of the greater or broader digital market.
Thanks, Daryl. And maybe just as we're probably going to lose you soon, or at least before we get back to you, in just 2 minutes, I mean, what is the solution? Because we see Apple appealing rulings globally, which are going to delay. As you said, interim relief is not satisfactory. Is there a solution?
Yeah, I mean, I think the solution possibly is legislation. So legislation that deals with these problems. But of course, at the heart of it, we mustn't forget that we want markets to innovate. So there needs to be legislation that's properly thought through. I also think that we should try and deal with these problems early on. So there needs to be sort of proactive investigations. And I think the South African Commission has got it right in that regard. I mean, that you are tracking foreign cases. You are proactive in your investigations. You are mapping the digital landscape, for example. So I think what needs to happen is greater sort of proactive investigations, dealing with these problems perhaps before they even arise, and then careful consideration given to legislation.
Thanks, Darren. We'll pick up the global aspect, I think, with Pierre as well, and it was also raised by Andre. But I suppose one aspect that comes through with GovChat and the publishers is these cases have been proved elsewhere. We're all going through the same process, and that does seem a bit inefficient. Yogesh, India maybe we hear a lot about the unicorns, the Indian tech industry booming. Obviously, the GAFA firms are also active in India, all of them. And so, again, I just wanted to get your perspective on where your focus has been. Has it been on the big GAFA firms and the typical complaints that we're seeing in many jurisdictions globally, or has there been a domestic flavor as well? But also whether your toolkit is working. And I understand the CCI may be looking for some amendments and changes organizationally, so maybe you can just talk us through that perspective, why you've come to that situation.
Thanks. So, as my previous speakers have already spoken many points, we all understand that digital markets are fundamentally, in certain aspects, they are fundamentally different than traditional markets. The kind of network effects, the kind of tipping, the fast-paced tipping that we see in these markets have not been seen ever before. And of course, GAFA or these global firms, they are pretty big and almost in all of the countries they are available. They are in the business, including in India, in a big way. And about unicorns that you have pointed out, of course, in India there is a very, very thriving startup system, and lots of unicorns, almost 100 unicorns have come by now. And some of them, even after being very new, they are pretty active in mergers and acquisitions. So because they get, because of their market, their business models and fast acquisition of large consumer base, they get a lot of funding, foreign funding, equity funding, etc. And to survive and to again increase their market value further, they acquire a lot of more related market firms. So like just for example, there is this one very big online coaching and studies firm. So that's called Byju's in India. And they acquired the biggest offline coaching firm there. And when you exactly see the markets, relevant markets for both of them, you can say, actually they claimed, and you can also find that it's, even if you combine both of them, market share is not very high, but actually they claim that they are in different markets. They are in online and offline. So that way there is no concern at all. You cannot even raise concern. So that's happening, and Commission is very lively to that. We are having an eye on the markets. And then regarding these amendments, so there is new competition amendment bill in the Parliament right now. It has been presented and it is being discussed by a parliamentary committee of multiple departments and multiple expertise. So some of the main amendments which may have good significant impact on these digital markets is one is for mergers and acquisition screening. Till now we were having just assets and turnover criteria. Now we are going also to have this deal value criteria. So what we saw in some of digital markets earlier, though the assets are almost, because there is almost nil physical assets, very less physical assets with the digital firms given their online business model, and the zero price models, they are not charging you anything, so even turnovers are very less. So many of them, big mergers, they just did not come to the Commission. They were not required to be filed. Like just for example, you know Facebook acquired WhatsApp and Instagram, or Google acquired YouTube, and that was not reviewed by the authorities at that time because of the size, did not qualify for the review. So now we are going to have this deal value criteria, because even after less turnover and assets, many times these deal values are very high, in billions of dollars, because of the business model and fast increasing consumer base. So prospective revenue and business potential is very high. So that's why these deal values are very high. So it was thought that we will have this criteria. Earlier, it was also thought that we should have a power of reviewing all the mergers, whatever we feel may have an impact on markets. But then that can be little bit arbitrary, and there can be a little bit uncertainty in the market. So objective criteria as a first step, this has been thought. Then Commission is also in the process of setting up digital markets units. So basically there will be some dedicated resources for the digital markets because of the flurry of cases and the complexity of the problems in these markets and the speed at which we will need to intervene, otherwise already the whole market scenario will change. And then Commission rarely gives an interim order, but in one of the digital cases, it gave an interim order. So it was an OTAs, online travel agencies case, and the dominant player, there was complaint against dominant player that they have entered into an exclusive agreement with with a vertical player who were listed on their platform and removing all other players. So, and they said, there are other OTAs in the market and you can go and list yourself there. Why do you want to just come to us? And then the case was filed. Finally, Commission, looking at the the scenario of the market, Commission gave an interim order that till the final hearing, you have to list them. And after, in the final, if we find that, okay, fine, you are not kind of essentially for their survival and you are not dominant or something, then after you can take your call, but if, till that time you have to list them. So interim was not only for status quo at that time, at this time, but status quo before they ousted those smaller platforms, smaller players from their market platform. And then competition law in isolation, again, of course, we other speakers have spoken about international cooperation. At the same time, within all countries, many sectors and industries have these digital markets are overlapping across, and the regulation is not only by competition law. So, in India, there has been discussion about e-commerce rules, FDI policy, and talks about data privacy laws, so personal data protection also. Some of the some of the solutions which are required, which are thought to be required, are interoperability and data portability. So the data, earlier the platforms were saying that these are, we are getting, you agree when you list on our platform, like when you make a Facebook profile, just for example, or anything, you agree to share all your data with us, and it's our exclusive this thing. But now the users are being given little bit more control over their data profile, and they can kind of, the thinking is, there is no explicit order till now. The thinking is that there should be a provision so that they can even switch from platforms with all their earlier data. So that way, interoperability may increase, and frictions of these markets or entry barriers for new players may reduce little bit. So of course, these markets are pretty complex, and there is no easy solutions, but a multi-pronged strategy as well as international cooperation are very necessary.
No, thank you. And I think you've raised an interesting point about internal cooperation or national cooperation. And maybe just a quick follow-up question. I mean, that coordination around other policies and even laws, is that centralized in any way, or is it agencies that are just cooperating with each other?
Yeah, that's a very good question. So it is not centralized, at least in formal way till now. But there are provisions, explicit provision in competition law that allows us to deliberate and to interact with other agencies, as well as there is another provision in our law only, competition law, that other agencies can make us formal reference if in their sector if they feel there is a competition issue. So like with electricity sector, with telecom regulator, and with many other regulators, we have been interacting. And even Commission was called for the national, for their views for the national e-commerce policy. So and now we are getting more and more references. That's what I have seen. So whatever laws, regulations, or policies are coming which may have an impact on competition and digital markets, they are being referred to CCI more and more.
Well, and that may be the value of a digital markets unit in coordinating that. Pierre, I don't know if you are still online with us. I think you've heard most panelists have raised, in fact, cooperation and global cooperation as well. And I suppose what we have seen is agencies are talking to each other. Some are sharing their experience, but not necessarily their confidential information. And it may seem a bit unsatisfactory at the moment that we're all fighting the same cases again and again. So maybe just from UNCTAD's perspective, because you do try and at least facilitate cooperation, have done so on cross-border cartels, maybe you can just give us a perspective on where cooperation is, where it's going, and what it could do.
Thank you. Can you hear me?
We can.
Excellent. Unfortunately, I won't be able to be connected more than 3:30, which is your local time as well. I unfortunately have another meeting, but I've been following all the discussions. And let me go directly to your question, James, on cross-border cartels and how the work of UNCTAD through its working group has been developed so far. I think the emphasis here is to be more pragmatical than any other thing. And we have been working a lot with the member states on different, of assessing throughout the regions the incidents and different instances through which competition authorities are facing challenges. So what are the challenges that we have faced so far during the cases that have been, let's say, shared by the member states? We actually said that recently at the IGE in Geneva last July, and to summarize, we talked about different areas. For example, when we talk about deepening the discussions on the practicalities, we still need to go back to the basics sometimes. And what are the basics, you know? And some of the multi-cartel jurisdictional activities by competition authorities, like the residence of the multinational companies and how to notify representatives from multinational companies was one of the cases that was provided by the member states in the discussions of the working group. And in here, we saw that in some instances, competition authorities will have the assistance of their Ministry of Foreign Affairs. In some other instances, it will not be so straightforward. So there are specific practicalities when it comes to this particular matter. You have seen also how to increase the informal cooperation, but not on the basis of general cooperation. So I think that we need to move from cooperation to coordination, to alignment of strategies. And that's something that we continue working in UNCTAD when we discuss about cartels and when we discuss about how to dismantle international cartels. But one area that has to be perhaps developed a bit further is the impact of regional cross-border cartels and how these areas can be prompted by robust regional competition policy that could be in place. We have seen the instance of some Latin American countries that have understood that problem after investigating the same cartel in different national jurisdictions and even having different outcomes to the same practice by the same multinational companies operating throughout that region. So this is an area where we need to look at it more in detail. And also, of course, the cartel cases that we saw, we saw that even in cases where competition authorities have, let's say, some trust in sharing information to the other competition authority, sometimes legal constraints can actually be a big problem to share information, even if it's intel or agency information that competition authorities would have. So this is an area where we have another instrument in UNCTAD, which is called the Guiding Policies and Procedures, which was initiated in 2018 by member states like the Russian Federation, who is now there. I can see my dear friend Andrei connected, in that room. And of course, we managed to agree on some basic principles of international cooperation. It seems to us, and that perhaps could be a personal position from that particular matter, that up to date, only 2 cases have been triggered at this GPP, as we call it in UNCTAD. How to improve advocacy, how to improve the awareness and raise the awareness of this instrument when there is a lack of international cooperation agreement between competition authorities and let alone between the countries that would like to cooperate. Therefore, this is a mandate that we have received for our member states to continue working together with key member states willing to share their experiences, but also to share their own problems. And that is something that, as you, and I heard it also throughout the discussions today and yesterday, that the issue of cross-border cartels, sometimes in jurisdictions where there is a very low competition culture, would be a very far away topic. But you have also seen that in some jurisdictions, prosecuting an international cartel can actually be easier than prosecuting a national cartel because of the local conditions and some of the constraints that a competition authority would face when it comes to local conditions and local circumstances of the market itself. So UNCTAD, through the working group on cross-border cartels, has to continue working on cases, has to continue working on specific studies of sectors in which we think that cross-border cartels are taking place. And of course, particularly during the pandemic, we can even identify some of the critical areas of the pandemic in areas related to food, and also even on the pharma sector. But this is an area that requires more studies, more research, particularly on undertaking regional studies on markets that are of cross-border nature. Therefore, this is something that we would like to pursue in this next months. Now, talking about digital markets itself, I would like to share the other instrument that UNCTAD is promoting as part of this technical assistance, which is the area of best recommended practices for digital platforms. I know the time is very limited to share a full-fledged presentation, but I will send that presentation to the organizers, maybe for the audience to look at it. I think one area that it's important to have as a takeaway message from this particular, we call it the RDP, Recommended Practices for Digital Platforms. This document, which was, by the way, launched on the 1st of June this year, and also discussed in some of the conferences throughout the world, this is a document that provides some guidance, concrete guidance to member states in order to look at what are the specific commitments, principles in the digital markets, particularly the behavioral part of digital platforms that are affecting local micro and small medium enterprises. This document it's already available online, and if there is a time to look at it in more details, I will be happy to present this document at length. Thank you very much, James.
Thank you very much, Pierre, and good luck with your next meeting. We have just 10 minutes, and so I'd just like to ask a couple of select questions. And Andre, I just want to ask, I mean, on soft law, they're not limits to serious limits to soft law, because I haven't got a sense that you've got the global companies signed up, and one almost has to dilute the principles in order to get the sign up. And I think we saw that even with some of the EU regulations on transparency initially was heavily watered down. So what role are you seeing that soft law can really play from a hard offense perspective?
Actually, we can use a wide toolkit of different instruments of soft regulation. For instance, we in Russia use a practice of so-called warning. What does it mean? It means that without the starting of deep investigation of the process of making decision of violation of competition law and then the process of litigation, we just warn the market participants. Yes, here, here, and here you do with some traces of violation of competition law. If you want to correct your behavior, yes, please, you can do it. If you don't want to do it, yes, the all force of competition authority will be opposite you. Another way, it's a specific self-regulation. We use it in advertising market, in retail trade market. So it's a dispute resolution system. But if in the process of self-regulative business dispute resolution, it's impossible to find a decision. It's possibility to turn this case to the competition authority and look at this situation in accordance with all rules of competition law. So it means that, yes, it's very simple to tell, yes, there are a lot of problems in the self-regulation. Yes, but the most part of these problems can be solved from my point of view.
Thank you, Andre. Daryl, can I just grab you for 2 minutes? As I'm not a lawyer, I'll propose probably ridiculous things. But is there not a case, if it's the same companies guilty of the same offense in another jurisdiction with a similar law, that we can't have a fast-track tribunal or investigative process? And there may be limits on what we can pull out of the other jurisdiction. Maybe Pierre can solve that for us. But is that not something we can do, and is there not a parallel to in a sense, international cartels where we rely exactly on convictions elsewhere to process?
Yeah, I think it's a very good suggestion, but I still think though that everything has to be evidence-based, and you still need to give parties the opportunity to meet the case that's presented, to them. So I still believe that we need to follow legal process. But I think for me what's really important is, and that's what I was trying to, I suppose, get at initially, is that I think that there needs to be the tracking of these cases and then cooperation between the authorities. And I'll give you an example. So, many of these cases are extremely complex, and it takes ages to get to grips, to understand the ecosystem, the extent of the ecosystem, the players, how the charges and commissions are working. Is often a blurring of the lines between products and services. Now, so all of those learnings from these international cases, if there was some way of funneling all of that to South Africa, that would expedite the process. So you wouldn't have to go through that whole process all over again. And of course, another important factor to consider is the sort of jurisdictional reach that authorities have. To get information and to understand, again, the ecosystem. If there was international cooperation, funneling all that information to South Africa, I think it would make it easier for parties to be prosecuted. But I still firmly believe that there needs to be an evidence-based approach. The law needs to be followed. Parties need to be given an opportunity to make representations and meet the case.
And I think as the last session expressed their frustrations with economists, maybe the economists can express our frustrations with the law at times. Yogesh, one thing we've thought about, and we issued draft guidelines on merger notification based on deal value, was almost, I think this has been identified as an issue, and it gets us in the room, but are we really equipped to assess these sort of transactions and the forward-looking, and are the courts ready to assess them? So we put in there, we get the mergers, but what do we do with them?
Okay, so are the courts ready? So regarding that, I think it has always been an evolving process. Before digital markets, there were some other markets. So, and courts are like hardcore law persons, and there is a lot of economics in this. So, I think courts will be ready. As per our experience shows, we are really hopeful about that. If we can really justify our analysis, so there should not be a problem. What was the other question? Sorry.
No, I think that was the main question, and maybe I mean to pass it on to you, Helen, as well as an economist. I mean, can we really make these predictions? And even if the economist can, is the court willing to accept it?
Particularly in respect of any like mergers or cases across
Yes,
the board?
so nascent mergers where they haven't developed necessarily the revenue streams, but the value and potential is clearly there, and the purchaser sees that, and it may be a killer acquisition type, it may be a strengthening of a portfolio type merger, but are we equipped to really make those predictions? Because I think we focused on getting them notified. I'm worried when we get them notified, are we ready?
Yeah, I wish I had one single answer. It's very difficult. Even if we look back at transactions that were prohibited for that reason, potential competition, and then you look at what happened thereafter, did the other firm move in and they didn't, that does not necessarily tell you that the decision was correct or not. So it is a very difficult thing. Of course, if we're talking about potential competition, all the facts, the legal, strategic documents go a long way to determining, is this firm definitely going to enter? But then I would say the bulk of the work as an economist would be on effects. Is this firm being in the market going to have a competitive effect? We don't simply want an additional headcount of firm, we want competitive effects. Just thinking about, are we equipped? I mean, given the broader discussion, I'm often working on mergers where they're being notified in multiple countries, and in South Africa too, and we often don't have sight of the international documents for a big part of our work, which is inefficient, of course. So definitely, if in future there could be some learnings of, tracking these cases and some learnings whilst not breaching confidentiality, I think that would go a long way, although I completely agree with Daryl that it has to be evidence-based in the jurisdiction that you're talking about. And then last word I would say on this, since you used the word equipped, I would say we need more than economists and lawyers in this space for sure. I mean, especially if we're talking about these digital markets, there are a range of other skills that I hope would find this profession attractive, because we need them. Definitely if we want to, really step up our game in terms of how we deal with these cases and transactions.
All right, Daryl wants to add for 1 minute, Daryl, because I'm on strict conditions.
Yeah, so I just wanted to add something to, once you get these transactions notified, I mean, I think the consideration is often key, because, and who's making the acquisition, because the consideration is very high. Obviously, there is some recognition of future value. And so the firm that's acquiring it perhaps has already identified synergies, conglomerate effects, and perhaps through the strategic documents and unpacking that value, you will be able to assist in trying to understand whether this is a transaction that should be approved or not. And that would hopefully avoid this kind of false positive and negative situation.
Thank you, and we'll end there. I think maybe on that note, I think the inequity in the global system is such that certainly when we require notification, we don't get the documents that either EU or US gets. And there may be a question of evidence-based when no evidence is provided. Maybe the presumption should be in our favor. But I'd like to get a round of applause for a panel that's come in under time. Let me just emphasize that.
Thank you for that leadership, James. And on that note, we're going to give you 10 minutes for tea. And we are back at 10 to 4. Thank you very much. We're resuming with Yanis Llanos straight afterwards. Thank you.
To investigate anti-competitive conduct, to evaluate mergers and acquisitions, and finally, to assess exemption applications. We investigate many cases in these areas, but today we'll focus on just a few exciting cases that have had a big impact on the market over the years. For instance, Busi, an analyst in the Mergers and Acquisitions Division, will tell us all about the Cashbuild and Buco merger. Analytical, the Commission's first in-house financial expert, will take us behind the scenes of the all-important PCR case that saw COVID testing prices come down. Besides investigations, we'll hear about other market interventions, like the work the Commission has done in the school uniforms industry and the guidelines the Commission facilitated in the automotive aftermarket. So, let me not waste any more time. Over to the analysts.
One, two. 1, 2.
So in September 2016, the Commission received notice of a large merger in which Mediclinic South Africa intended to purchase an independent hospital group called Matlosana Medical Health Services, or MMHS. Mediclinic SA owns around 50 or so hospitals in South Africa, one of which is located in Potchefstroom. Now, both of these towns are in the Northwest Province. MMH operates 2 multidisciplinary hospitals in Klerksdorp, Wilmed Park Hospital and Sunningdale Hospital. There are, in total, in that region, about 3 municipalities next to each other. There are about 5 hospitals in the 3 adjacent municipalities. And so, post-merger, Mediclinic South Africa would own 3 of the 5 hospitals in those 3 municipalities. In light of this, the Commission recommended that the merger be prohibited, as it was more likely than not to lead to a substantial lessening of competition in the relevant market, resulting in a significant increase in the tariffs for acute hospital care for both insured and uninsured patients. I think when we first got the merger filing, I think it became apparent quite quickly that there was more to this merger than met the eye. I think we suspected that it was likely to be harmful for competition, given, the extensive body of research that was conducted in relation to the industry. But there was this pressure to almost evaluate it through a more narrow lens without consideration of the broader context of the healthcare market as a whole and the right to healthcare as enshrined in the Constitution. The healthcare market inquiry, as well as other research pieces and investigations in the healthcare market, have consistently found high levels of concentration and concomitant adverse competition outcomes in hospital markets. The CAC's decision to overturn the tribunal's ruling prohibiting the merger can be viewed as a sort of an offshoot of this approach, traditional approach to competition policy, which is why the Commission sought clarity from the Constitutional Court by seeking leave to appeal the CAC's decision. Indeed, the broader context of the healthcare market and the right to healthcare was a key feature of the Commission's application for leave to appeal. At the start of this process, a key consideration for the team in understanding the effects of the merger was the broader context of the healthcare market and the economy and the provision of health services. However, the primacy of this approach would not have been ratified by the Constitutional Court if the CAC had not overturned the tribunal's decision to prohibit the merger. The decision by the ConCourt has provided much-needed clarity on the correct approach to establishing the overall impact of mergers and conduct generally, competition-related conduct, for the Commission and the courts in making their determination. The constitutional right to healthcare specifically has been identified as a key consideration when approaching matters in the sector. Indeed, a relevant factor in the Commission's referral regarding potential abuse of dominance by Roche relates to the constitutional right to healthcare.
The Commission's advocacy work relating to service provider panels in the banking industry actually began with the engagements between the Commission and the banking sector in 2018 and 2020, where the Commission had identified competition concerns with the bank's conveyancing practices. And those engagements led to the country's largest banks offering undertakings or commitments to revise their practices. And that enabled competition in the procurement of legal services by the banks, and the banks gave undertakings which meant that they would refrain from locking in law firms on their panels and open up opportunities for smaller and HDI law firms. The Commission has recently issued a practice note in February 2022. The practice note sets out key principles for promoting competition and inclusivity in supplier panels of banks and insurers. And this came after the Commission consulted the industry in a closed workshop With the practice note, the Commission intends to encourage reforms of practices and adoption of key competition principles by banks and insurers, which would ensure that when they appoint service providers for all of their panels, they adhere to these principles. And it's important to note that the banking industry and insurers actually procure these services not only for their consumption, but also on behalf of their customers. So these interventions came about due to complaints received and investigated by the Commission, which first revealed there was a prevalence of exclusionary conveyancing practices in the banking sector. For example, the terms agreed between banks and law firms for conveyancing work prevented law firms from taking on instructions against the banks in instances where they have concluded service level agreements with the banks. But also the Commission had received complaints which had revealed that there are concerns relating to the unfair appointment of work to service providers and that the allocation of work was actually not fair and inclusive. So from these complaints, the Commission then found that certain aspects of these supplier panels raised competition concerns to the detriment of consumers, and these issues related to long-term exclusive agreements, as well as barriers which prevented the entry and participation of SMEs and companies owned by historically disadvantaged individuals. The practice note in particular is actually very key because it sets out principles that banks and insurers need to adopt in order to reform their practices in relation to the use of supplier panels. And in particular, the practice note seeks to promote principles on the allocation of contract opportunities, which should be done in a manner that increases consumer choice, the inclusion of SMEs, HDIs, and market competition. So in terms of impact, we are already seeing the insurance industry align its practices and approach with those principles. For example, the South African Insurance Association welcomed the publication of the Commission's practice note, and it has in fact adopted these principles into its treating suppliers fairly framework, which has to be adhered to by all of its association members, which includes insurers and some banks.
Testing. 10 minutes flies by, hey? It's like you just go, pelil. So we don't have that many people in the room yet. And I'm going to just signal to some of my co-organizers about when they believe I can start. I did say 10 minutes. And I think we've taken 15 now. You get a car, you get a car, you get a car. Everybody gets a car. Oh, quick, quick.
Thank you for inviting me to participate virtually at this annual conference on competition policy and law, which is convened by the South African Competition Authority. First, let me congratulate the authority, the Competition Authority of South Africa, over the last few decades for having made significant strides in implementing a workable competition policy framework, one that has very strong jurisprudence, that takes account of South Africa's development objectives, and of course, that ensures market operationalization efficiently. the African Continental Free Trade Area has a very strong interest in competition policy and law. You may be aware that as part of the legal architecture of the AFCFTA, there is an inclusion of a protocol on competition. We have started negotiating the protocol. In fact, the negotiations are at an advanced stage, and I believe that in due course, those negotiations will be concluded. It is very important to build a competition authority and a competition policy framework for the entire African continent, because we want to enable Africa to respond to very difficult challenges which South Africa and countries such as Egypt have already responded to through their own competition policy laws and legal frameworks. These include cross-border cartels, questions around competition, questions around consumer protection, which are very important aspects of what we want to address in a framework for competition for the African continent. The AFCFTA has been ratified now, as we speak, by 44 countries. We expect that by the end of the year, almost 50 countries will be state parties to the agreement establishing the AFCFTA. It's a significant development. We are at the cusp of leveraging a market of 1.3 billion people with a combined GDP of 3.4 trillion United States dollars to make sure that the African continent in years to come is globally competitive, has industrial capacity, and has competitiveness within country and within region. Of course, we recognize implementation of the AFCFTA is not going to be an easy task, nor will it be a task that takes place overnight. We as Africans will have to be disciplined, decade after decade of implementation of the AFCFTA, including, of course, the protocol on competition policy and law. But I'm very encouraged by the very, very good progress that we have made in a short space of time. In less than 2 years, as I've just mentioned, we have 44 countries that have ratified the agreement establishing the AFCFTA. These countries have committed to reducing and eliminating barriers to intra-Africa trade, to intra-Africa investment, and to ensuring that in areas such as inclusion and development, ensuring that the AFCFTA is equally responsive to that challenge. In this regard, we are negotiating the protocol on women and youth in trade because we believe that young entrepreneurs and women, small medium enterprises that are led by women, are actually significant contributors to Africa's overall GDP and create over 450 million jobs in the small and medium enterprise sector. Therefore, the AFCFTA must be responsive to their needs. Once again, I wish you very good deliberations. I hope to be able to join you in person next time. All the best and good luck.
Five, 1, 2, 3, 4, 5. All right, I'm going to ask those in the room with us if I can have your attention. If I can have your attention, please. We are resuming. There we are. If I can have your attention, please. Just checking if those who are inside the room are with me. Do I have you? Thank you. Hello. Next up, we're going to hear from my personal idol, Yanis Lianos, who is the head of the Hellenic Competition Authority, and he will be speaking to us about digital in his context. Thank you all.
All right, so thank you very much, and thank you very much to Tembi and to Commissioner Tsepe for their invitation today to present you the regulatory framework in Greece, but more generally in the EU. In order to prepare this presentation, I had to do some homework because the EU has been adopting a number of regulatory texts for different things the last few months. So it has been a very intense regulatory moment for the EU. And from my perspective, it was also very interesting to put everything together and see actually how the emerging regulatory framework and system in the EU is actually framing the debate about digital platforms. So we can actually move to, we can start the presentation probably, and we can move to the first slide. So the next one, please. All right, so if you can just push another button as well, because I mean there's an extra thing in the slides. No, okay. So what is really driving the regulation of digital ecosystems in the EU? It's basically big tech dominance, and of course, you know, we have been discussing a lot the last 2 days about the digital platforms and the fact that they have been marked by phenomenal growth. Of course, we have in terms of market capitalization, the 10 largest corporations in the world. I mean, most of them are actually big tech platforms, and big tech has become much bigger in the COVID-19 era. And obviously, we have seen a tremendous increase of power. And this has, to a certain extent, led to a triggering moment for regulation. Back in 2016-17, the EU has commissioned a report about the competition law and policy in the digital era. And during the same period of time, there has been a lot of discussion as well in the US, the Stigler Committee report. In the BRICS, of course, we had the BRICS report in 2019, because there has been a lot of collective thinking about the way to move ahead with this phenomenon of the big tech dominance. Can we move to the next slide, please? And I would say one of the most important issues that led to these changes, to these regulatory changes, is the fact that we realize that, well, you know, big tech is competing not only markets, but more broadly in ecosystems. So we had this concept of ecosystem that became more and more important in the way we conceptualize competitive interactions in the digital sector, in the digital economy. And of course, you know, a number of economists, they have been discussing about this concept back in the 1980s. These were more people that were doing business studies rather than industrial organization. But I think their conceptualization of ecosystem, which is the idea that you have a group of interacting firms that basically depend on each other's activities, there's an important complementarity in the way actually they organize their different activities, and these activities are aligned towards presenting a value project to the consumer. So in a way, we have these kind of groups of independent firms. It's very different from the classic supply chain, which is vertically integrated, and these firms are basically cooperating and competing at the same time. And so we have these new concepts of inter-ecosystem competition and intra-ecosystem competition. So inter-ecosystem competition, the competition between ecosystems, or intra-ecosystem competition, the competition within a specific ecosystem about who is going to get over the most important part of the surplus value produced by this ecosystem. That became extremely important for policy. And of course, you know, the two concepts that I think are really important there and to a certain extent characterize the new emerging EU regulatory framework is contestability. So in case more inter-ecosystem competition, and at the same time fairness in a way of making sure that the various parts of the ecosystem, they get basically the surplus value that they deserve in terms of their investments and contribution to the ecosystem. And I think these two concepts of contestability and fairness are extremely important to understand the EU regulatory framework. If we can move to the next slide. Yes, sorry. No, the previous one, sorry. So you have been quicker than me. The other two concepts which are very important, I think, which do not appear that much in the text of the regulatory framework, but I think will be extremely important in the implementation of the new regulatory framework, is a concept of ecosystem business model. I mean, each of these ecosystems have very different business models. I mean, here you have an example of the business model of Apple, Google, and Facebook, very different business models. So the question mark is, can we apply basically unified framework to all ecosystems, or should we actually distinguish between the various ecosystems and develop some form of codes of conduct that could be somehow specific to the business model of that ecosystem? I would say the second approach is more or less the one that I think the UK is moving to. So a kind of a more specific approach to the business models of the ecosystem. The EU actually decided not to take into account in the framework, the regulatory framework, the concept of business model. But of course, so you have unified rules applied to all ecosystems. But of course, you know, there's a question about how in the implementation of the new regulatory framework, the business model actually will be taken into account. Next slide. And of course, you know, the same could be said for the ecosystem architecture, because each of these ecosystems has an orchestrator, a company that's basically creating the rules of the system, deciding who does what and who gets what. And each of these ecosystems is based on a specific architecture, okay? And I think this is also something that we need to have take into account, of course, when we think about applying competition rules or other regulatory rules in the context of ecosystems. So these concepts are there. They're not explicitly taken into account by the European regulatory framework, but they have been, I think they will inspire the implementation of that regulatory framework. Next slide, please. And of course, one of the most important issues that we had to deal with, and this is somehow the essence of the new regulatory framework, is the understanding that the traditional competition rules could not deal with the different dimensions of power in a complex economy. So it's not really a hazard that basically the first text, the first reports that were commissioned about the future of competition on the digital sector somehow focus on these new concepts of power that have been emerging, this idea of intermediation power, or the idea of strategic market status, or the idea of pouvoir structurant, and these are somehow concepts that have been put forward in the various reports. The first one in the German report, the German Ministry of Economics report, the second one, the Furman report, which was basically commissioned by the UK government, and the third one is the French Telecommunication Authority. And of course, all these different reports somehow were saying that, well, you know, the classic concept of market power is probably too narrow. And we need to develop a little bit different, multidimensional concept of power. And of course, you know, thinking about multidimensionally about power in economic relations is really a challenge. And of course, what is I think is interesting is to think about this ontology of power that we need to take into account. And of course, in the right-hand side of the right column, I have some basically suggestions about an ontology of power just to show that there are many different dimensions of power we can take into account. And this is part of a publication of mine. So next slide, please. So in a way, this is kind of an introduction to the regulatory framework. Of course, the most important regulatory framework in the EU, apart from competition law rules, is the Digital Markets Act. And the Digital Markets Act basically is a regulatory text that aims contestability and fairness. So they actually applied a number of core platform services, and it applies only to firms that are considered, to ecosystems that are considered as designated gatekeepers. And and I will actually explain how we can define a gatekeeper, what is the concept of power that is actually sitting behind the concept of gatekeeper. And the text is fairly simple in a way that it sets some do's and don'ts. So in Articles 5 to 7, I mean, most of the don'ts relate to self-preferencing, interoperability, enveloping, tying strategies. There is some future-proofing, which comes through the flexibility offered by market investigations that are possible to expand, basically, the application of the framework. And interestingly, there are rules concerning the relationship between this Digital Markets Act framework and the National Competition Law framework, because basically this text is without prejudice to the application of Articles 101, 102, or a national equivalence. So in a way, you're going to have a possibility where you can actually have the application of both national law as well as probably DMA. And this is something that, of course, creates concerns with regards to the bis in idem type of rules. And in a way also, there's a very recent case law of the European Court, the B-Post, which said some certain different perception about the bis in idem rule than what actually we had in the past. So it does not concern the digital sector, it concerns basically the telecom sector. But I think it's quite interesting to think with this particular case law with regards to the way actually the two regimes will apply. Now, national competition laws, of course, can interfere when, against unilateral behavior, against, of course, non-gatekeepers, or going and imposing further obligations to gatekeepers that the ones that are in the Digital Markets Act. Next slide, please. About the scope, I mean, I'm not going to go through. I mean, these are the core platform services and some examples that can be covered by the Digital Markets Act. There's been a lot of discussion about including as well connected smart TV or web browsers and virtual assistants. Finally, virtual assistants were included in the scope of the DMA. So these are basically the core platform services to which the DMA will apply. Next slide, please. And in terms of enforcement architecture, I mean, there has been a lot of debate about who is going to enforce the DMA, but at the end of the story, the Commission will be the formal enforcer of the DMA, basically a combination of DG Comp and DG Connect. But member states, the national competition authorities, will also play an important role in the DMA enforcement because they can initiate non-compliance investigations against designated gatekeepers if, of course, the member state in question has provided these powers to their national competition authority. They can participate in market investigations and other investigations at the request of the Commission, and they can request the Commission to open market investigations and submit supporting evidence. And what is interesting here is that the European Competition Network will become a very important player in the context of the DMA enforcement, somehow guaranteeing that there is an interplay between the Digital Markets Act and the application of national competition law rules. Next slide, please. So important thing is, of course, to see who is a gatekeeper, how a gatekeeper is designated. So what is interesting here is that there's no reference to the concept of ecosystem or even the concept of market. It's basically very much a kind of blunt, somehow, development of a power threshold. So you have actually, first, the idea that it should have a significant impact. So the annual turnover at the EEA should be at least 6.5 billion, or a market capitalization of at least 65 billion in the last financial year. It actually has to be an important getaway, so you have thresholds for the active end users, 45 million monthly active end users. A core platform should have also at least 10,000 yearly active business users. And of course, these thresholds should be met each of the last 3 financial years. Next slide, please. So this is a little bit the Digital Markets Act, but actually I would say this is part of a broader puzzle in a way of a French-style regulatory garden, actually, that the EU has created the last few years. And it's interesting to think here that before basically the 2016-17 kind of thinking about the digital economy and the regulation of the digital economy, we mainly had competition law that was applied with problems, of course, because it was taking a lot of time for decisions to be adopted. Then we have the EU General Data Protection Regulation and the e-Privacy Directive. And what is interesting is, starting in 2020, and in particular in February 2020, we have a strategy that has been put forward by the EU for data and AI, and this, following slide please, has led to development of a number of regulatory texts. Now, some of them are basically creating a sort of risk regulation, like, for instance, the Artificial Intelligence Act, that is basically going to be implemented in 2022. Some of them are somehow imposing rules concerning the use of the public sector data, and the idea is there to enhance contestability by enabling actually the use of public sector data in order to somehow develop the ecosystem, the digital ecosystem in the EU. It's interesting also that we have concepts like that of data altruism. What is exactly being a data altruist? It's basically to accept to provide your data for free for good causes. And I think this is also there in order to develop the data pools and the data sharing to a certain extent. That is important for the development of the digital economy. Next slide, please. We have a very important text, which is the Data Act. Now, the Data Act actually doesn't apply to the small and medium undertakings, but actually it's a very important one because it can apply to anything else than a gatekeeper. So any company, any firm that is in a situation of unequal bargaining power and imposes unfair contractual terms to other firms, we can actually have the application of this Data Act. So this Data Act also has important provisions concerning interoperability. Actually, it enables the European Commission to take delegated acts and to specify essential requirements regarding interoperability or even open interoperability specifications at the European level. So in a way, it's an extremely important tool in order to develop interoperability of different services. It actually limits the application of the database directive, which creates a sui generis right. The EU actually, there's a property right on data. I mean, data actually, you can have a property right on data through this data protection directive. And this actually text enables the narrowing down a little bit of the data protection directive in case it is important to share this data with a third party, of course, with the consent of the user. Sometimes the user would like for his data to be transferred to another entity, and of course, the data holder will have to do it according to the Data Act. Next slide, please. Then we have the specific vertical, let's say, data access rules. In particular, there's a very interesting now proposal for the European health data space. And this is also part of the 2020 Commission data strategy. And there is actually to ensure, provisions to ensure the interoperability of certain health-related data sets. And to create the infrastructure to share basically these health-related data sets with the creation of the My Health at EU, which is designed to provide the infrastructure to facilitate cross-border exchange of electronic health data with a mandatory certification system and also with specific rules concerning the secondary use of electronic health data for research, innovation, policy making, patient safety, with also provisions about the fee calculation, because of course this will be done with some compensation, of course, for the data users. I mean, we can still add also the old PSD2, the Payment System Directive, which also has specific provisions for the sharing of data with regards to the payment service providers. So all these texts are regulatory texts, but they're about basically competition principles of providing access to data in order to facilitate contestability in these digital markets. Next slide, please. And of course, we can include the Digital Services Act, which also provides basically specific rules concerning bans on advertising for minors, content regulation, and transparency requirements for online advertising, which I think are extremely important. Final thing, and I will actually just show the slide on this one. The next slide, please. We have two other texts, the Network Information Systems Directive 2021 proposal, which is more about cybersecurity, and the 2021 Directive on Resilience of Critical Entities, that is basically about ensuring the resilience of some of the physical infrastructure, and of course that includes as well digital infrastructure. Now, next slide, please. So we have really a very complicated and complex regulatory framework with the interplay between these rules is not clear yet. The enforcers of these rules, as you have remarked in the slides, I was mentioning the various possible enforcers, but the system is not completely set yet, so we'll see actually how this will interact with competition law, which still stays at the background. And of course, I mentioned here EU as well as national competition law. Now, of course, when we think about EU competition law, this reform, one of the first issues that have come up is, should we actually revise our market definition notice and possibly move to take into account different concepts like that of ecosystem? And in the new market definition notice, which is not yet public, but there is actually a section on ecosystems, which is quite interesting. So without that being, of course, moving towards a full-fledged analysis of the ecosystem, it is something that is actually mentioned in the Commission's new market definition notice. Next slide, please. And of course, we have the choice of various regulatory and ex-ante regulatory as well as ex-post competition law frameworks to choose from in order to deal with this phenomenon of power of digital platforms. So, of course, we haven't moved towards a sort of utility-like approach to regulating the digital platforms. Of course, there are many problems with conceptualizing digital platforms as utilities, okay? But we have actually specific rules concerning transparency, and this is the regulation 2019-1150, which deals with contractual relations, but doesn't deal with the so-called uncontract situation, where you have somehow APIs or technical requirements that impose certain things to the members of the ecosystem. Then we have actually, if you think about it more broadly, taking into account the national level, we have new and old competition tools. We have market investigation references that could be used in some jurisdictions in the EU. Well, the UK is not anymore part of the EU, but we have a market investigation reference tool in Greece, for instance. There is another one in Romania and other actually member states. We have actually rules concerning the interplay of merger regulation with the DMA concerning mergers, in particular in the context of killing acquisitions. So this is basically a requirement at the DMA, Article 12, for the digital platforms to notify to the Commission any merger that they do, and at the same time, the possibility through Article 22 of the European Union Merger Regulation for actually the member states to send mergers that will not necessarily fit into the EU thresholds to the Commission in order to assess, in particular, that could be possibly killer acquisition mergers. And we have, for instance, the Grail Lumina case, which is a classic example which this Article 22 has been used. Of course, we have the Digital Markets Act, as I said before, as well as the various other texts that I referred to. Next slide, please. To this, of course, at the EU level, we need to add the possibilities that we have at the national level. We have actually some member states that have been using their own competition rules creatively. Germany, for instance, German Bundeskartellamt in the Facebook case. We have actually concepts like that of abuse of economic dependence that exist in some member states, and these have been used in order to deal with situations where the company doesn't have market power in the traditional sense, but you're focusing on the economic dependence that exists between the ecosystem orchestrator and the ecosystem members. And this was the example of Apple in Germany. I mean, the case in France, for instance, the French abuse of economic dependence law. We have new provisions which concern the situation of ecosystems, like Article 19A of the German Competition Act, which led to a number of investigations concerning big tech platforms the last couple of years. And we have also a number of other suggestions. In Greece, we had a proposal, next slide, about introducing a specific provision in our law concerning ecosystems, abuse of ecosystem power. This has been discussed thoroughly at the public consultation. Unfortunately, Parliament did not adopt this specific article, waiting to see, of course, about what's happening with the European framework. But I think this could be an example of provisions that could be very much focusing on ecosystems and assessing the problems that might be created in this context by abusive practices of ecosystem orchestrators. Next slide, please. So this is a little bit the article of the... next slide, please. The next one? No? Yes, this one. So this is basically parts of the article. So this is the end of my presentation, just to say that we have basically a very complex regulatory framework operating ex ante with competition law as well, both at the EU level and national level. It's not clear yet because all these texts are to be adopted or have been just adopted to see how these interactions will work in practice. I think it will be very important also to think of the institutional framework that will be set in order to develop cooperation between the various enforcers. And I think it's very important also to see who is going to be involved. I mean, when you look to the DMA, for instance, of course, the competition authorities have an important say, but we have also possibility for the Data Protection Agency, the sector-specific regulators to be part of the conversation. So it's an interesting idea, this development of this regulatory network, this broader regulatory network, which will have the responsibility to implement the new EU framework for the digital economy. Thank you very much for your attention.
Thank you so much. That was rapid fire. Yeah, it was rapid fire. However, there were so many, such key insights. I won't say more because I know we're running short on time. So the next plenary is our last plenary. As I explained to you earlier, we're no longer going to hear from James on the online market inquiry because of time. So I'd like to welcome on the panelists for our next plenary. This is going to be facilitated by Mr. Advocate Maneche. We have as panelists Lebogang Mabidikane, who's a member of the Association of Competition Practitioners, Tabara Paramur, who you all know from the Competition Commission in the Mergers Department, Narayas Moloto from NACTU, Liberty Mngube, a Competition Tribunal member, Tony Enkerecht from COSATU, Langa Madonko from Summit Africa. The topic for discussion here is the role of competition regulation in promoting inclusivity for employees and firms, unpacking Section 12A3C and Section 12A3E of the Act. I look forward to hearing from you. One correction. Ms. Mabidikane is actually here as a partner from Bowman's. She won't be representing the association in this capacity here today. Thank you.
Yeah. Is it on? Yeah. Good afternoon. Thanks very much for inviting me to moderate this session. As already explained, the topic for discussion in this panel is the role of competition policy in promoting inclusivity for employees and firms. And the focus is on the amendments introducing 12 capital A3C and 12A3E. Just to remind you what those provisions say is that when the competition authorities, the tribunal and the commission determine whether a measure can or cannot be justified on public interest grounds, the commission or the tribunal must consider the effect that the measure will have, C, the ability of small and medium businesses or firms controlled or owned by historically disadvantaged persons to effectively enter into, participate in, or expand within the market. And E, the promotion of a greater spread of ownership, in particular to increase the levels of ownership by historically disadvantaged persons and workers in the market. So we hope to get from the panelists practical experiences with initiatives to achieve inclusive participation, the challenges, what the amendments are aimed to achieve, their scope, and availability of suitable buyers, of funding, and any challenges that might be faced in implementing the provisions. The panelists I start from the left is Mr. Narias Moloto. He's General Secretary of the Trade Union NACTU, and Professor Liberty Mncube. He's a Professor of Economics at WETS and part-time member of the Competition Tribunal. And next to him is Mr. Langa Madonko. He is co-founder and principal at Summit Africa, a niche alternative investment house focusing on social impact investments with a superior risk-adjusted return. And then you had Ms. Leboham Mabidikane, is a practicing attorney in competition law and partner at Bowman's. And next to her is Ms. Tamara Paramur. She's Divisional Manager, Mergers and Acquisitions at the Competition Commission. And just next to me is Tony Ehrenreich, Deputy Parliamentary Officer of COSATU. Most would know him as a trade unionist. Just to set the scene, I'll ask Narias if he can give us, from a trade union perspective and perhaps from a worker perspective, experiences on transformation initiatives to promote ownership and participation, and what the experiences have been with those, and what the expectations from the worker perspective are with the amendments.
Hello. Yeah, thank you very much. I think this amendment, the provision, offers a great opportunity and is a very positive development particularly in the Commission, because it deals with the transformation. Earlier on, we have heard that there's a lot of complaints about whether we are transforming or transforming enough. Now, in the country, over a period of time, starting I think a decade or and a half ago, initiatives were taken, and there's been a number of transformation charters in a number of sectors, economic sectors, aimed at transforming the economy and to participate in the economy. Stakeholders took part in these initiatives of transformation charters to try to transform, and as a result, through the led by the TDI, a lot of progress was made with delayed in various sectors. You know what happening in the banks, what's happening in all other sectors. Stakeholders or companies and firms, employers, associations are engaged in that discussions. And that's where the whole issue of the scorecards come from in various sectors and so on. But at the Commission, I think there was nothing. And this is the first intervention by the Commission to try to ensure that justice workers will at least begin to come with something that they did not have. But ESOPs, the inclusion, particularly the 3C, E, offers that opportunity to the workers. Seeks to broaden the ownership rather than firms comes and take everything for themselves, go away. Now, how do we begin to transform South Africa at a corporate level through this initiative. So we think it's great initiative. Also looking into the small and emerging medium firms that were there, most of them disappearing, not long, struggling. Now the Commission, by bringing about the 2 legislative interventions, sections, they will facilitate. We believe that is positive, and it will be in line with what is currently happening in the country along transformation. Now for that, as workers and as labor representative of workers, we welcome this intervention. We believe it will then enhance and enable almost all the sectors, particularly those who will be coming from outside, try to merge and try to take over. These considerations is a very, very important intervention. You remember that in the past, during merger and acquisitions, in the whole thick documents, the only relevant section of labor will be 2 or 3 pages. You only feel where there's fear that there will be loss of jobs, there will be retrenchments, there will be undermining of the agreements and so on and so forth. From there, the rest was just led to the business partners. And it had nothing to do with the ownership and the transformation. Now, therefore, these 2 interventions, we believe, are important, critical, and the Commission will now also be in line, able to check in line with all what is happening with regard to transformation charters. Thank you.
Yes, thank you. And Liberty, perhaps as an economist, and he's gone back to perhaps the failures of initiatives in various industries with charters to transform. Do you have reflections on that and perhaps about questions of inequality that might be relevant to those failures and what we can expect with the amendments?
Thank you. I think thank you for the opportunity to participate. I think I know the tribunal is co-hosting, but I feel like I'm an outsider because I wear 2 hats. So I will comment as a vets professor, and everything you hear from me is academic, so it doesn't represent anything that the tribunal is thinking. Even if it doesn't make sense, just assume it's academic. But this is a topic which is quite interesting for me because there are 2 parts to it. The first part is around participation, and the second part is about broadening ownership. And on both parts, I think there is an avenue is created around a quiet transformation of our society. Because we hear many people talk about transformation of our society, but it tends to be loud and noisy. But the competition or the major regime vehicle offers a quiet transformation of society. And for me, that is important in and of itself. But it's also important because here is a clear path to societal change. And I think we should embrace it. So to state the obvious, and I think any talk about these 2 provisions must start with the obvious. The obvious is an inequality challenge. An inequality challenge that is entrenching, an inequality challenge that is undermining the social solidarity within our society. But it's also threatening trust in institutions, threatening instability, whether social or economic. So if those are the brutal facts, and you've got these amendments that focus on participation and they focus on inclusion, and then you recall, in May this year, the CEO of Sibanye got paid 300 million rands. Although part of it was in earnings and the other part was in share, it was share income. But 28 million is quite a lot compared to what the workers were fighting for. So if that reflects our society, and a person accepts that capital income, wage income are the most unequal parts of the income distribution, then you get provisions like this in merger control, which are solely aimed at responding to that inequality challenge. There is hope, and the hope for me is it comes down to a simple equation that workers must have a share in the ownership as well. There is one part that I'm much more interested in, which is ESOPs, because I think those offer for, if one were to reflect and say, in the past 20 or so years, the BE side has not, there are people who complain about it, there are people who feel that it has only benefited a few, yet the worker side seems to be expansive. And it offers not just the easy benefits that one may think of, but there are other benefits too. So I've spoken about inequality, but there are other benefits that I would like just to mention briefly. So if you think about it, we have a society where worker commitment can be enhanced by, and if you are part of the ownership, if you are part of the profit share, that enhances worker commitment, it enhances worker engagement, it even enhances worker well-being. But it's not just about that. Even absenteeism from work, reduces because workers have a share. They have a share in the firms that they work in. Productivity increases. You also have, you're dealing with the issue of joblessness at the core, because now you can have faster employment, faster sales growth, and so on. So for me, those are the clear benefits of the two provisions in terms of the amendments relating to participation and also relating to the point around broadening the scope of ownership to focus squarely on capital income, but also to focus on access to capital earnings. So I think we are on the right path, a path that offers a quiet transformation of our society, a path that I think should be televised. So I encourage lawyers to go out there and talk more about this path, the potential that worker ownership has on transforming our society and moving the equation from these things being seen as incidental byproducts to real change in society.
Thanks, Liberty, and thanks, Narias. And I'd like to move to Tamara. And in light of what the Narias raised as the previous failures or bottlenecks in transformation using charters and the like, and the expectation that these provisions are a good step, and perhaps we start moving to address problems around ownership and participation, and what Liberty has said about inequality and the provisions also being positive in that direction. Could you just take us through the provisions, give us a sense of the purpose that they were intended to achieve, and perhaps in doing that, tell us a bit about what the developing approach is within the Commission about these provisions. Do you see the provisions as placing an obligation on competition authorities to think about making the world a better place, irrespective of the effect of a measure that comes before the authorities on ownership and participation? Yes, if you can just enlighten us on that from the Commission's perspective.
Thank you, Advocate, and thanks for the opportunity to speak on this. So I think these amendments were born out of exactly the kind of reflection that Prof. and Narias have put forward now. And even yesterday, Pam reminded us to think back to 1990 and think about how much has changed and how much has stayed the same. And in the same way, I think I always, before I have to speak, I go back to the preamble and think about what the Act enjoins us to do. And it specifically says that this act it asks of us to open the economy to greater participation by more South Africans. And it also talks about a competitive economy, not for its own sake, but a competitive economy that focuses on development. So it is there's no doubt that this is about a transformative competition law. And I think, as the CAC has said in Walmart, in fact, that the credibility of our law rests on responding to the specific concerns in South Africa. So my reading of these amendments is that this question of the continuing credibility of the law comes up against the lack of transformation in the economy and the continued concentration. And the amendments therefore seek to proactively address these concerns, including about a lack of ownership by Black people of productive assets and the economy more broadly. This is explicitly mentioned in the explanatory memorandum that accompanied the amendments. I think the legislature is very clear about why this was introduced, and the DTIC expounded on this in their statement for jobs and industrial development. So I don't think that that it's accidental that these amendments talk about the promotion of a greater spread of ownership. It really is a call to action. So what does this mean? Well, I think we must pay attention to the fact that the framing of Section 12A3E, which talks to the promotion of a greater spread of ownership, is very different to the other public interest provisions. It speaks to the promotion, and I'll keep saying this word. And by contrast, the other public interest provisions assess the effect of can the merger be justified or not, and consider employment, And in fact, in the purpose of the Act, there was an opportunity at the time that the amendments were drafted to incorporate the words in the purpose. So Section 2 actually says the promotion of employment. So in order to promote employment. So there was an opportunity, I think, to incorporate that even into the other public interest provisions. And the textual difference then, I think, for this section about a greater spread of ownership is deliberate and does impose a positive obligation on all merger parties to take positive steps to increase this greater spread of ownership. So yes, it would apply in situations where merger has a neutral effect on HDP and worker ownership. I'm sure we'll debate this. But that, I take this from reading, I think, both the intention behind and the words that were chosen. If this was not the case, so if it was not the case that this is about promoting, then I think it would place an undue and unfair limitation on firms that are majority owned by HDPs or have some HDP shareholding, because it would result then in a dual regulatory approach where you only enforce the provision in the cases where there's a dilution and not in the case where firms that have failed to transform in 2022 continue, along that path. I also think it's unclear, if you don't interpret it as a positive obligation, how we would ever achieve that purpose of promoting transformation broadly, which clearly was the intent behind these amendments. I think I'll end off with a small point. I think 12A3C is probably going to be the ugly cousin, or I don't know what the phrase is, of worker ownership in the discussion. But James made the point yesterday that public interest provisions are also actually about competition. And I think 12A3C makes that explicit. So it doesn't just talk about the ability of small and HDP-owned firms to become competitive, which was the previous wording. It talks about entry. It talks about expansion. So it really goes to the heart of that dynamism that is required for a more competitive economy. And I think in that way, I know that Walmart said that we mustn't make the world a better place, but maybe we are on a different time scale trying to make the world a better place through exactly this kind of intervention.
Thank you, Tamara. I think it would be appropriate to get Lebogang to give us perhaps a private practitioner's perspective to this, that you have a measure that is, whose effect is neutral on ownership and participation, but that nevertheless there is an positive obligation not to leave the measure, assuming that the neutrality is at 5% or 10% HDP ownership. There's an obligation to think about promoting participation and black ownership. What's your reading of the provisions? And here, not just limited to that point, just generally from your perspective.
Yeah. No, thank you very much, Hamilton. So I just want to start by emphasizing that these are very complex issues, and I don't think that the Commission or the practitioners have entirely wrapped their heads around these issues. They're quite complex and at times quite emotional, actually, because just listening to what Liberty was saying, they are bread and butter issues. So, just hear my comments in that context, that it's certainly not, a lack of appreciation of the importance of these issues. But I think there's something to be said, before I go to the interpretation of the law, I think there is something to be said about, especially in response to a question that Tamara posed in her opening remarks. She says, if you're not going to take the interpretation that the amendments pose a positive obligation on merging parties to make the world a better place, then how else would you achieve these imperatives? And I think therein lies part of the problem, because the role of competition regulation, in my view, should never be taken or rather considered in a vacuum, right? There's other pieces of legislation. There's other sector-specific, for example, pieces of legislation that deal with the exact same issues. So I think it would be incorrect to suggest that competition regulation is the only tool that can achieve these imperatives, and in any event that should, because I don't think that's how the system is designed, and hence the existence of other pieces of legislation, which is albeit sector-specific sometimes, that deal with these issues. I mean, if you look at a sector like mining, we know that in order to get a mining license, there are some thresholds that parties must adhere to in terms of shareholding, in terms of black participation, worker participation, and community trust participation. So certainly it seems to me that there needs to be some sort of harmonization between the way competition regulation is enforced in respect of these issues, and one can never ignore the more broader ecosystem of legislation that is meant to achieve the same result. And of course, this touches on a few other things, such as the fact that, what typically happens is that in a merger, in trying to achieve these imperatives, then whether or not in fact the merger is a public interest neutral, the Commission would seek to impose conditions. We know that conditions or conditional approvals and conditions monitoring is resource intensive. So when you think about how competition regulation speaks to sector-specific regulation, then the question really comes about, is there real impact? So what is the impact of competition regulation in this aspect? Classic example, in a lot of mining transactions, by the time the transaction gets to the Competition Commission, there's already a SENS announcement out there that actually says, we are the acquirer and we are going to issue 5% shares to an ESOP, 5% to a local community trust, and 5% to a black industrialist, for argument's sake, right? So in that context, the question is, does the imposition of conditions by competition regulators actually achieve anything? Does it make an impact? Because it seems to me that the other piece of legislation would have done that already. So when we think about the impact of competition regulation, and I know for a fact that the Commission does these quarterly reports and these annual reports where you look at the number of conditional approvals, what has been the impact in numbers in respect of public interest. And the question is there real impact where the transaction was in any event going to come with those conditions? And does this not, in fact, place a burden on the Commission to try and monitor conditions that they would have otherwise not necessarily have had to impose? And that's just a question, So that's the first thing on the role. The second thing on the role of competition regulation is that, in my view, this role should not be pursued at the expense of those it seeks to protect. And I think Tamara may have mentioned this actually. I like to think about it practically. So if we're going to take the interpretation which says that you can't have a public interest neutral transaction, then how do you deal with a transaction where the acquirer is majority black owned? How do you deal with a transaction where there's already an ESOP? Are you going to ask for a bigger stake for the ESOP? Are you going to ask for there to be an added BE condition so that there's an increase in the BE ownership of that acquirer, notwithstanding that it may very well be a majority black owned, because it's not always the case that it would be 100%, right? So maybe it is at 70%. So what exactly does that mean? And so just coming specifically to the issue of, maybe in conclusion, just to say that it does seem to me that we kind of need a clearer indication of how competition authorities will look at harmonizing this intervention, this impact of competition regulation with what already exists in the market, so that we don't have a situation where different regulators are asking the same parties for different things on the same transaction, which can actually be quite counterproductive. And just speaking on the issue of the actual interpretation of the law. So, I mean, I've heard what Tamara is saying about a reasonable reading of the legislation is that every merger that comes through the door must have a positive impact on public interest. I must say I personally disagree with that interpretation of the legislations, but I would like to focus more on the way, on the fact that the problems or the challenges or the questions that interpretation raises. And the first thing is that, and before I even go into the challenges, I think there's something to be said about how we got here, because I think since the amendments came, we've been uncertain, at least I've been uncertain about what the position of the Commission is. What has been quite a pleasure is understanding that the Minister's office is quite clear. I've asked the question directly, and I've had letters written to me where the Minister's office is saying, no, our official position is that the merger has to have a positive impact on HDP ownership and worker participation. But certainly that has not been the position of the Commission, and it's at least helpful to hear what Tamara is saying could very well be the official position of the Commission. And I think one of the challenges with this type of interpretation is that, you move further and further away from traditionally accepted principles of competition law, right? So the concept of imposing remedies on a transaction has always followed a credible theory of harm. So the question would be, what does the transaction do? What is the direct impact of the transaction that is, and I mean, presumably this would be adverse impact. And how then do you address the adverse impact of that transaction? And therefore, you would impose remedies. But it looks to me now that you would be imposing remedies on something that may not necessarily need remedying, unless you take a very, I'll call it conservative interpretation of the law, which is what Tamara has just spoken to. The second question one would need to think about is the practical implications of this interpretation. So there's a question around substantiality. So what are the scenarios that would warrant the competition authority's intervention? Are we going to have guidelines which say a drop of 5% is something to worry about or not? Or is this going to be case specific? In which case then the issue of uncertainty is perpetuated, because as we speak now, it's a little bit difficult for practitioners to advise clients because the situation hasn't really been clarified. And of course, what I mentioned earlier, if there's already an ESOP, if there's already black ownership, what does that mean? What will the remedy be addressing? There's also two other issues. The issue of discrimination, and I've heard this a lot in business, where some parties are saying, isn't this some sort of discrimination in the sense that and in a way that could potentially also discourage, and this is just a view from industry that I've heard, right? May not necessarily be my personal view, but I've heard this argument that says, well, are you not discouraging investment or major activity by taking on an interpretation that every transaction has to have a positive impact? And what I mean by that, is it that now parties are being punished for having a merger before the regulators? What do we make of the rest of the parties who are sitting and they're not engaging in these transactions? How do you get them to comply? And this, in my mind, touches squarely with the first point I made about the fact that you can't rely on competition regulation as if it's the only tool to achieve these, or as if it applies in a vacuum without taking into consideration the other pieces of legislation. And I think the last point that I want to make is that there could also be an argument made around saying this type of interpretation interferes with deal structuring, the parties' right to structure their own deal in the way that they would want to. And this has been quite interesting for me because you would recall a few tribunal decisions from a few years ago. I mean, the Shell TEPCO transaction specifically, where the tribunal said that, in pursuing these imperatives, competition regulators should not impose conditions that would result in the transaction being something completely different from what the parties intended it to be. Now, the counter-argument that I've heard again, and unofficially, but this came up in the context of the Burger King discussions. The counter-argument to that was that the Commission's view was that, cases like Shell TEPCO have been superseded by the amendments. And in my view, I don't agree with that, because the principle hasn't changed. The principle has always been, how do we aid participation or promotion, or however you phrase it. So for me, the principle is the same, and in my mind, the case law, it cannot be said that the case law has been superseded just because we are taking a certain type of interpretation. There must be something to be said about the fact that parties should still have the ability to structure transactions in a manner that they feel comfortable, and in a manner in which they have actually done their projections, because all of this costs money. So every time there's a conditional approval, parties would have thought about it, and there's money to be spent. So to what end then do we have this interpretation, and really, how far does it go, essentially? Thanks.
Thank you. I think the debate is well framed between the approach that Tamara advanced and the approach you advanced. Tony, listening to all of your co-panelists who've gone before you, do you see the amendments as meeting Labour's ambitions, or are there points or areas of concern that you'd like to raise? I mean, you've had the two lawyers, you had the debating the interpretation that might have an impact on whether you achieve what the amendments are intended to achieve, and you had Liberty, the economist, highlighting questions of inequality and hoping that this can address those issues, and Naria's sketching the Labour's views also about what these amendments may be able to achieve, which hasn't been achieved by the charters in the various industries. What's your impression from Labour's and Labour's ambitions and areas of concern and so on?
Thank you very much, Chair, and thank you very much for giving us the opportunity to be part of this discussion. I suppose the question about what are the objectives that we are attempting to achieve is the fundamental question for us as workers in this country, because that starts to get a sense of common purpose amongst us as to what it is that we have communicated to our society is the better world we want to build. So the Competition Commission as an institution, as an agency of the state, must work towards achieving those constitutional values that we've enshrined in the Constitution. And so that becomes the clarion call of what it is that we must do. There's always going to be different views on that. Businesses always want to make more profits. And of course, workers should always demand higher wages, given the low levels of wages in South Africa. But there's also the public good that should be looked at. And it's the question of public policy that we should take into account when we look at what is happening at the Commission. Our concern as workers is that all of the points being raised is absolutely essential. And we come to this discussion because as workers, we are players in the economy. We have a material interest in how the economy is structured, how it unfolds, and how it benefits our society. So we want to engage in where that philosophy is shaped and where the implementation is driven from. But when we step back for a moment and we look at what has public policy achieved for us in the 20-odd years of democracy, it must be the clearest indication that there must be a bit of a concern about public policy and how effective and fast it is moving. Because the levels of unemployment moved from around 16% in '94 to around 40% now, if you look at the expanded definition. The levels of inequality, given the Gini coefficient, is worse now than what it was under apartheid. So if that tells us anything, it tells us that our public policy, what we've done this far, what the players in the economy has voluntarily, in some instances, brought to the table to make sure that we achieve those constitutional values that we spoke about, what we can conclude is that we have not achieved that and we have not moved fast enough to get closer to that point. Why is the speed of moving closer to that point a question that must occupy our minds? Well, we've seen in the June protest in Natal and Gauteng earlier this year that this country is on a knife edge, and if we continue in the way that we have been, then we're going to run the risk of not only having a failed state, but having a society at war with each other. And so what the institutions gives us an opportunity to do is to take the conflict that inherently exists in the society, and in particular in ours, because of apartheid and the fault lines that have come about, it gives us an opportunity to have a rational discussion about that and put in place a rules-based system. But what must that rules-based system achieve? It must move us to the greater good. If all the rules-based system does is to get fancy lawyers to come and sit at the commission and defend the interest of old businesses, well, then we're not going to get anywhere very quickly. Now, what has the old apartheid economy looked like? And sometimes I think we forget to frame our discussion mindful of what had happened in the past and mindful of the legacy we want to undo. And I make that point because I don't think that there's equal weight to the points of view about what must be done and how do we respond to that. Because the apartheid economy had kept out small black suppliers, had placed huge impediments on investments in the economy generally, never mind the disadvantages for foreign direct investment. We've seen through the cartel and collusion cases how many sectors of the economy are riddled with corruption. So clearly under apartheid, the system that had benefited only a few of our society and impoverished the rest of our communities had brought about that result because the rules favored that. And our responsibility now is to change the rules to make sure that we have better outcomes. And while we may have some differences on exactly what the terminology is going to be, we shouldn't move away from the fact that we do want to achieve the same objectives, because we know that it's only by building a better country that's more equal and more fair that there'll be sustainable development and sustainable opportunities for all of us. Anything else would just be a shortcut to let the horrors of apartheid be joined by the horrors of a democratic society. Those who stole under apartheid now be joined by those who steal in the democracy. So this public policy, I agree entirely, can't be viewed on its own, but must be viewed in the context of what we're doing on a range of fronts. So in the Competition Commission, I think they should be commended for the incredible work that's been done, both in respect of the collusion cases, which obviously without a reservation, we all would condemn as the worst atrocities to our country. Take the bread cartel. That had taken money out of the poorest people in our country's mouths by those companies coming together and colluding. So what we've got to find a way to do is to make sure that we respond to that very differently, and that's what we think that we are trying to do with these two public interest provisions. We completely are in support of them. We're in support of the Competition Commission and its objectives, and we want to make sure that as Labour, where we're not often as active in the engagements around the hearings, that we play a much more active role, and that we demonstrate our agency as players who have a big concern about both how the economy unfolds and who the beneficiaries of that are. So my colleagues have spoken to what exactly those public interest provisions are. My focus for today will be mainly on what does that mean for workers? How do workers come into companies and how do they have a share of companies? Well, what we've seen after 1994 in the attempt of many businesses to gain greater legitimacy is to take on BEE partners. But those BEE partners was essentially politically connected people that had added very little to that company over its history, and the workers were largely excluded. There were some areas where there were employee share ownership schemes. Some of it was not too bad, but in the main, it seemed like a con game because workers had not actually benefited out of it, and many BEE beneficiaries, black businessmen that came in as partners for those companies, had also not had the kind of advantages that they'd hoped for. So there clearly is a need for us to look at things very differently. And so in the employee share ownership scheme, we want to make sure that in mergers and in other opportunities that is promoted to a greater extent so that the ownership of the economy is more democratized, that everybody has a stake in it, and its viability for the future is virtually guaranteed. And so all of the mergers that have been done, and we've looked at some of them, we think there's about 100,000 workers who benefited out of some of the merger provisions that gives them equity in those companies. Many of those have been listed here, and they are on the record. We think as unions, we want to play an active role in making sure that the benefits that come out of those agreements, that they actually get to the beneficiaries. And so I want to make two or 3 points, Chair, that we think can go a long way towards contributing to that. The first one is that in many of them, workers now have shares and they have part ownership in the company. But that clearly is not enough if workers have no role in the decision-making. So it's important to look at the role of workers on boards of companies, being involved in the decision-making and where the company's ultimate direction is going to go. And so that becomes a crucial additional area of legislation that's got to be put in place. We've got to make sure that on the questions related to the state providing support in respect of funding, that is a huge assistance to workers. Because it's pointless taking a loan or the company forwarding you funding that you have to pay over a period and you never actually see the benefits. And that's the frustration in many of these schemes, that workers on paper are beneficiaries, but they never actually benefit out of that in rands and cents. And so that then just becomes an elaborate con game, and we've got to do that differently. So how do we do that differently? Well, you can't do things differently without a cost. And the businesses who benefited under apartheid, they're going to have to pick up the tab for that cost. Because as a society, they're the ones who occupy their positions today exactly because of the advantages they had under apartheid, and that means that they have an obligation now to make some investment in this new country that we want to build with a new value system. But the government has a role to play, so make some funding available, make sure the tax provisions are favorable for companies who actually move towards promoting ESOPs, and so that's the way in which we can make sure that these public interest provisions provisions that they actually impact on the lives of people. My final point, Chair, goes to the question of the Competition Commission, the ministry it falls under, and what it is that needs to be done. Now, I started by saying that the indicators around poverty and inequality is nearly worse, are clearly worse than what they were in 1994. So if anything, all of the ministries, all of the political leaders and public servants must be working towards advancing that with a lot more energy and fervor than we see at the moment. So I've heard that there's criticism of this department for overreach. If anything, we have a government that's underreaching, that's not making sure that it's going out there, participating in the economy and the society and bringing us closer to the promises that we made our people in the Freedom Charter and that's enshrined in the Constitution. That's what we said we're going to do. To now want to opt out of it because it may have financial implications and some cost implications, we think will draw the whole compact that South Africa has on how we're going to rebuild the country into question. So I think that we've all got to come together and accept that these public interest provisions are moving in the right direction. We've got to implement them more speedily. It must send a signal to other ministries to make sure that they're more interventionist, that we see the kind of results coming out of their departments and their sectors of the economy that responds to the challenges of our people. But in essence, Chair, we completely support the provisions and we'd like to see them implemented in a lot more areas. Thank you very much.
Thanks, Tony. Langa, you picked up the issue of cost, and so there's a funding issue. I'll come to you, but before I get to you on that, and Tony's quite clear that to change our society, beneficiaries of apartheid must accept that there is a cost to that, to the process of transformation and opening up. But Tony also spoke to some design principles around what workers expect in, for instance, share ownership schemes that involve workers. And before I go to Langa, I just want to go back to you, Tamara, and ask whether there are in the Commission settled principles around how you would promote participation of HDPs, and broadening the spread of ownership. Since it's been 3 years since the amendments came into effect, one would expect that there has been thinking within the Commission and you've got some kind of settled ideas and maybe question marks here and there, but can you give us a sense of that?
Okay, I will do that, but I think since I have a monopoly on the mic, I can't resist responding to Lebo on a few things. But firstly, I must clarify that I'm definitely not a lawyer. So maybe that.
Don't worry, lots of non-lawyers make better sense to what things should be.
Yeah, I don't know if I was promoted or demoted by you when you said you thought I was a lawyer, but I mean, firstly on TEPCO, I think in addition to it having been surpassed by events, you know, the law has changed, and as I said, I think we must read the text for what it is. It's useful to think about what Shell TEPCO was. So TEPCO, the target firm in that transaction, had fuel stations operating in a market that we know is dominated by oil majors. So I think, and also it had fuel stations in areas that were generally low income. So this was an entity that was not performing well. I think that's very different to if we think about the entities in recent cases, even if I may say Burger King, for example, where there was value in the business. So this was an exit of a firm that was essentially struggling financially. And I think the Commission does consider these on a case-by-case basis. I can mention several cases where if black people are exiting, realizing some premium on a loss-making firm, or you know, we would consider those. It's not a. I think it's obvious, you know, that one would take those into account, but we must read TEPCO for what it was. And I think what the tribunal, in fact, maybe if Dave was here, he could speak to us about it, but what he said was empowerment is not furthered by obliging firms controlled by black people to continue to exist on a life support machine. So that's I think that is a different case. So that's that, I think, on TEPCO. I totally do agree, though, with Lebo that we must work more closely with other regulators and that we do need to take other legislation into account. when we think about what the obligations on us are in the promotion of ownership, we do look at charters, etc. So yes, I agree there, but it doesn't mean that we shouldn't act. I think the data market inquiry showed quite critically what can be done by the competition authority. I know I myself, my 1 gigabyte data bundle dropped from 149 to 85 Rand overnight. You know, and that was a commission intervention in a sector that does have a sector regulator. So I think it's about all of us doing more rather than some of us staying in our lane. All right, and the final thing I wanted to say, I think around the, you know, is there a credible theory of harm in a lack of investment, etc. I think the one thing that does discourage merger activity and foreign investment in South Africa is the absolute lack of aggregate demand and growth. So as the economists yesterday spoke about, there's a bigger problem around economic growth. So I don't think really it is about the public interest provisions. Okay, so let me quickly go through the principles. But just to say that we have developed our thinking. We, of course, are in the process of reviewing the previous guidelines on public interest. But there are a few issues that we've come to consider as generally accepted design principles for the promotion of a greater spread of ownership, and particularly for ESOPs. So one, it is still a holistic test. All of public interest is considered. Sometimes when there is a dilution on ownership, we would look at whether there are commitments around promoting new suppliers, training, etc., or some other job creation commitments. So one, it's a holistic test. It's looked at in the round. On ESOPs, the way we frame it is that there must be no direct cost to workers. And that basically means that they mustn't, they shouldn't have to take money out of their pockets to pay for the shares. But there have been several cases where we've made provision for some vendor financing on preferential terms. We prefer that these ESOPs are evergreen and that all current and future workers are included. Generally, there is some discussion with the unions around permanent workers and who qualifies as a permanent worker. There is sometimes a time in job commitment, probably around 18 months to 2 years, for qualifying to enter into the ESOP. And then there must be balanced governance. And I think this does go to the point that Comrade Tony made around an influence in decision making. So if the ESOP is a trust, workers and the firm must have equal trustees, and then the final trustee must be appointed by agreement. So that's the kind of the minimum level. And then we do want to see some benefit, financial benefit to workers from day one. So generally in the repayment of the vendor financing, there would be a split of around 40-60, or in some cases it has moved to 50-50, but generally around 40-60, 40% flowing to workers from day one. I'll quickly just say what the principles are for participation by small and HDP firms. Generally, we look to conditions that have a value chain link, because there is a greater chance of sustainable entry if there's a link into the value chain of the firm. In the funding mechanism, we have to think through the incentives or disincentives to invest. So in a grant, for example, there might be an incentive by a firm to invest less than what is required because they don't capture all of the benefits. That is addressed better in a loan or in an equity stake. But at the same time, we want to make sure that whoever you invest in has the ability to seek other customers. So there mustn't be some kind of exclusive arrangement linked to the loans. But grants generally are preferred. And then there's also recently what has happened is that many of these funds outlast the reporting period, shall I say. So there are funds that are recapitalized. So sometimes this balance between grants and loans is accepted because the repayment then allows the fund to operate in perpetuity. So yes, that's it. That's basically where we are on ESOPs and participation. But what I do think has been valuable, and I have had great engagements, I think, with unions around this, is that our enforcement of this provision has sparked a conversation about what works. So it was really useful for me to listen to the submissions from Comrade Tony, because we are constantly trying to figure out how to make this work in the best way possible for the stakeholders involved.
Thank you, thank you. And now, Langa, no cost to workers and hopefully benefits, financial benefits from day one. Is that viable?
Wait, can you hear me? But okay. Okay. Just for conformity, let me start by saying jurisprudence, because otherwise I won't get to say a single legal word. Yeah. You, senior counsel, I heard it from you, so. Yeah. So I think by way of beginning, maybe let me say this. South Africa, as the Honorable Doctor has said, is very unequal. And we see the glaring gaps, and I actually at some point wished I was the CEO of Sibanye, but apparently I applied too late. And we see those gaping things. And then with that reality comes the reality also that South Africa is one of the places where you have the toughest environment for capital formation. If you set up and you say you want to start a private equity fund in South Africa and you are black on average, if you are brilliant as a fund in terms of marketing and in terms of also understanding the needs of the investors, it will take you at least 4 years to raise a fund of at least 800 million. So with that as a background, it means that these people who are raising private equity funds are supposedly some of the finest investment minds that the country has, and therefore it's much easier for them to sell the story to the investors or for them to aggregate this capital. Then the second reality about the South African environment is that in South Africa, in earnest, there does not exist a single DFI. PIC is not a DFI, it's an asset manager managing funds on behalf of pensioners who must realize a return. IDC fails at being a DFI at the fact that it must self-capitalize. And once you have to self-capitalize, then the developmental angle somewhat affects your sustenance. I can keep going with all the others. DBSA has to raise money offshore in terms of also issuing board issuances and raising money from EIB, and therefore has a return mandate that is not always developmental. The third aspect that we also then have to remember is that we do want to get to a point where we've got broader participation, but we are doing that in an environment where we don't have as much developmental assets as we should have, and we actually have struggles of capital formation amongst black entities. So with that having been said, let me start by saying, in case I have any transactions that are currently at the Commission, that I fully support the direction that the Commission is going, and that we should be using the tools at our disposal to encourage the broader participation. But immediately when we say at no cost to workers, that's fine. We don't want the workers to be taking a cent from their pockets, because ultimately the capital that is actually being used in all these scenarios actually belongs to the workers, because the majority of the funds being invested into all these businesses come from pensions. So they should not have to pay twice. Fully accept that principle. However, from a mathematical perspective, I think here, I hope I'm the only one who understands Excel. If we were to look at it at the perspective of saying the vendor financing is permissible, but the vendor finance needs to be at a 40-60 ratio, effectively what you're saying is, from a mathematical perspective, you're saying to me, I'm going to give you 100 rands. And that 100 rands immediately from day one, from the 50 rands, whatever comes as uplift in value is for you. But from the other 50 rands, I must service the full value plus the interest payable on the 100 rands. Mathematically speaking, I think if you did the calculation, assuming that the South African economy continues to grow at a rate of about 3%, assuming that investors are able to deliver a return of about 8%, and assuming that prime is where it is now, and I were to say I'm going to loan the money on a vendor basis to the employees at prime, and the economy is growing at where it's growing and everything is perfect. To service the 100 rands against 50 rands worth of dividend is a 25-year process. Effectively, what happens in that instance is that what was meant to be empowering means that for 25 years, the ultimate return that's going to come to the employees and the members of the trust is going to be the dividend distribution against 50%. So let me tell you what starts to happen in that environment. The other thing that starts to happen in that environment, and this is an unintended consequence, but this is how capitalism works, is that because we realize that there's this 25-year payback period in which one has to pay back against a 50% arrangement, one starts to then say, the proportion that I'm willing to allocate to the ESOPs needs to be small enough that it's not a significant drag on the shareholder profile. You start seeing the ESOPs dropping from 10% to 5% because you don't want the liability attributable to your employers to be that big on your balance sheet, because effectively you must guarantee the repayment against your ability to distribute dividend. However, I do propose that there are alternatives that exist, and I think the Competition Commission should actually look at banks, because what exists within the Financial Services Transformation Council is an instrument for the creation of black business growth funds. And those black business growth funds, I think the only impediment is that the criteria around which they are implemented uses the same credit rating and scoring patterns that exist for funding me, and I'm supposedly a sophisticated investor. In this instance, if I as a private equity fund am going in and I say I can afford to put in the capital that is required for the equity, the instrument that the Competition Commission should have, and this is a suggestion, is one that compels or encourages or promotes the banks to invest alongside for the enablement of the share schemes as well as the black industrialist programs. Because effectively what then happens is that a significant proportion of the risk that exists in the inherent transactions is taken up by the equity investor. And the equity investor is incentivized to ensure that there's a consistent stream of dividends. It would actually yield greater results if you said against the bank portion, as the transaction is being structured, can you structure in a dividend guarantee? We'd be more than happy to do that because it does help with us achieving a competition commission or tribunal imperative. But it also means that we're not trying to use workers' capital to enable workers to the detriment of workers, if that makes sense. And then I think the second aspect that one always has to consider when you are considering the financing of these transactions is that the other unintended consequence of high watermarks in terms of the vendor financing is that sectors like, say, the manufacture of, let me give you a random example, of X-ray machines, the margins in that space are at about 60% on the equipment. In the automotive space, the margins on some of the equipment is as low as 8%. Effectively, what will happen is that myself as a transactor, knowing that I have to vendor finance at that level, I will immediately start to slant in the investment of the entire economy towards high margin spaces. So spaces like the automotive sector will stall in terms of the level of investment that goes into that. Primary agriculture is likely to also stall. We will start to see a greater level of investment into non-product based parts of the economy. We will invest in business process outsourcing centers instead of bakeries. And that will have an unintended consequence that eventually what will start to happen is we'll have to once again go to a model where we're importing all those things because you cannot channel local or international investment into those spaces. And it's just, I again want to reiterate that I think the direction that we're trying to take is positive. It's the right thing to do. But we need to be always having an open and honest conversation that also understands that the legislation must exist in an environment where it is an enabler. It is an enabler for us as people who are able to bring the capital together, as an enabler for the people who are historically disadvantaged persons that it is looking to protect. And then lastly, it must also act as an enabler for attracting capital from beyond our own corridors. And I think as a parting shot, I think generally the way business works is, and this analogy always sometimes gets me into trouble, is it is probably easier to do business in the DRC when they're at war than to do business in South Africa, because you are certain that there will be gunshots in the DRC. And in South Africa, it's the opacity of the different angles of legislation. It's, for example, sitting here, I run a financial services company along with my partners. I have to take into account every time I do a transaction, the Financial Services Transformation Council. I have to then take into account the BEE Commission. Then I have to take into account the Companies Act and the impending amendments that are coming there. Then I have to take into account the Competition Commission. Lebohang charges me at a rate of 16,000 rands per minute and also charges me for biscuits and tea. And we have to, in order for it to be, there to be incentive for us to change the way we're building our business models. Because currently we're incentivized to produce return on a financial basis because of the impediment of how the capital is raised, but also because we know the impending costs of actually executing a single transaction, taking into account the environment that we work in. I think I'll end there. I think they said they'll only ask me one question.
Thanks. Thank you. I think we have under 10 minutes, and I just wanted to, with your leave, maybe take one or two questions and then give you each a minute to round or to close. There is a question over there and over there. And there was a hand over there. Or has it gone down?
Thanks very much. Thank you for the opportunity. Hello? Hello, 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 hello. Hello, 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 hello. Can you hear me?
One. Can I use this?
Thank you. Thanks very much. Thank you for the lively discussion. Something that appears to be quite evident, and yeah, I'm coming up for the Commission. I cannot but do that. But it appears that the Commission is actually taking quite an open view whenever parties come to them with whatever evidence, whether it's qualitative or quantitative, to argue why a particular obligation is perhaps just too much. It's not me. So I just want to say that there appears to be a lot of common sense from the Comcom's side. And I also get the impression from the cases that the Commission also provides pushback to the Minister. So sometimes there will be requests coming from the DTIC. The Commission will look at the facts and they will say, this is not necessary in this particular context. So I just want to commend them for that, that they're taking a view that is based on evidence, that is based on qualitative or quantitative information that the parties brought to them, saying we cannot go this far. There is consideration for that. And thank you also for bringing that independence to that decision as well. It's just a comment. Thanks.
Thank you. Is there another question? There's a question from Tembeka.
I think Nyoko's hand was up before mine. So.
Yeah, it looks like it was an old hand, but now that you've resuscitated it, resuscitated it.
I've got a question. It's a new question. So I think you're right, Mwako, when you say perhaps there's some debate framed around what the two were saying, you know. What I wanted to understand, and I closed my computer, was there doesn't seem to me to be an interpretation of legislation when it comes to the balancing exercise. You were quite concerned that merging parties orchestrate their affairs in a manner that they are entitled to, and they spend money, etc. And there seems to be this, this was not your word but mine, inconvenience, which is in section 12 cap A3, about what these merging parties ought to take into account, or at least what the Commission ought to take into account in approving a merger or otherwise. Where does that balancing act lie for you, for your argument?
Thanks, Lebo. You can use mine.
Yeah, thank you. I'm not sure if I understand the question, but I'll try. I mean, what I was simply saying is that the way in which the balancing, so if you talk about the balancing act as per the Metropolitan case, for instance, the way that has worked in my view is that it operated in any event in an environment where there wasn't an interpretation that every merger has to have a positive positive impact on public interest. So in that context, what would happen is that on the facts, the transaction would have a negative impact. So the balancing would really be around, if there is this negative impact on this particular pillar of public interest, in addressing that negative impact, what sort of remedies would be imposed or should be imposed? And in imposing them, then the regulator would have to look at whether or not, in fact, a certain condition was sufficient, and balance that also with the impact of that transaction on the different other pillars of public interest. So I think that's the context in which I may have used the word balancing exercise, I think. Yeah.
Okay, let's take Nukai Tobi, and that will be and then we can come back to the panel to close up.
Thank you, Chair. What was I going to ask? Yes, no, sorry. I've remembered. It was like, you know what, my hand was up there and I forgot. I think it's Tony and Narias who piqued my interest in this. I mean, I suppose also Liberty's sort of optimism about these new provisions. I just want to ask, because, you know, my experience in this sector, which isn't vast, admittedly, but I usually see the unions coming in, trying to rustle a deal with the merging parties to secure employment. And then once that condition is included, that's it. They've got no further role to play in the merger. They don't even police the enforcement of that condition, and most of that work is then left to the Commission. So firstly, at the merger hearing itself, the work of protecting the workers is left to the Commission and not to the unions. And then post the merger, that work too is still left to the Commission. But it seems from what you and Narias were saying, there's some further work that you can do, not only in sort of protecting workers at shop floor, in other words, at wage level, but also in looking at conditions, the conditions of employment, but also looking at broader transformation questions about the sector and about broad-based BEE. But those interventions are not being made by workers. And in your case, you've got the right to be there. You don't have to apply specially to intervene. You're entitled to be at the hearing. Now, if we are to take seriously what Dennis was saying this morning about the constraints in the competitions field of pursuing the public interest, it seems that the correct starting point might be to ask the unions to do more in making the arguments that go, firstly, protecting the workers, but also go beyond in actually trying to find out what is the transformative potential of Section 12 and how can we strategically use it and expand the reach of the public interest provision. But that doesn't seem to be happening, so I wonder what the reasons are for that. Personally, I would like to get a brief from the unions, from COSATU or from NACTU, to argue before the tribunal that it's not about the workers, it's about broader transformation, that the measures are constraining or are not enabling. But I've never seen that happening at all, and most of that work is done by the Commission, and it has no supporters. And often, actually, it's aggressively opposed by the merging parties. So why are you not doing that? Why are you not coming to me to give me a brief? The other thing, Tamara, I was also very interested in what you were saying, actually, when you said that it's not enough that a measure should not produce negative outcomes. It must also enhance the elements in Section 12. So I want to know specifically in employment, for instance, is the argument that the Commission will say, and I'm not saying that's wrong, I'll support it if that's what you say, but I think I just wanted to commit about where exactly you stand. Are you saying, for instance, we're not just going to check whether a measure is going to result in job losses, but we are going to check whether it will increase employment or it will increase the conditions, make them better? And that's not making the world better. I mean, I think that kind of dismissive responses to progressive arguments is tired in a country as unequal as South Africa. But if that's what the Commission is saying, then you should make that explicit so that we can support it. And don't feel the sense that, you know, what is the industry going to say? So what? The statute is there.
Yes.
Thank you.
So let's take the unions first. Perhaps Liberty might have something to say as well, and then Tamara, and then we'll take very brief closing remarks.
Okay, thank you. Yeah,
and also be brief, just
sure.
Less than a minute.
All right, okay. Now we the unions really do make follow-ups. Unfortunately, after the merger and securing the favorable conditions, that interventions by the unions, the federations are not directly involved. It's become the trade unions. Now, in the practice, in the day-to-day, is the Labor Relations Act. We find trade union is fighting with that employer. Where are they going? If there are dispute, they go to CCMA. They take a different route. Normally, they are not coming back to the commission. I think that's the reason why you may not see them coming. But also, I think you are right. In the tribunal, federations are not invited. You find that they are invited, they notify a trade union directly affected. That's why, and there's a capacity issue in that particular space as well.
Tony, if you could avoid responding to that particular question, but to the second question about limiting yourself to employment issues only.
Thank you very much, and thank you very much for the question. I think we must take responsibility as the labor movement, and whether it's at the federations or the affiliates or the actual unions, we're not doing enough. And so there's got to be an active program, I think, of capacity building around how we use this legislation to advance all of the objectives that you've outlined. So it's not only about wages, it's not only about jobs, it's about the broader transformation issues, and it's about ensuring that we use all angles of the law to transform the society to what our ambitions are. And so we're committed to doing that. And I think with all of the federations, we must do more and work with the Commission to make sure that they assist us in developing the capacity so that people are more actively involved in that. On your offer to do some pro bono cases for that, on behalf of Labour, I accept, and we'll be in contact with you soon.
Yes. Tamara, on where do you stand? Are you on the fence? Or
Yeah, this can probably be my closing remarks as well, to say. Sorry. Okay. So I wasn't quite going as far, I think, as what you were hearing. Although what I must say is that there is scope, I think, in reading the purpose of the Act to require a positive obligation even on employment. So to say a merger must create. There is scope to read it. Not in the public interest provisions, but in the purpose. I was saying something somewhat smaller, which pains me to admit to. But I was saying when looking at the public interest provisions, the one on the promotion of ownership is different. It does, that one says promote, therefore it is a positive obligation. But if for some reason it's not possible or parties provide a compelling reason, as what he said, we'll listen, but then provide other public interest commitments to make up for the fact that you're not responding to the positive obligation on ownership. So there you might give a positive employment commitment, you might establish a fund to promote entry and participation by firms, etc. So I guess it's net positive, but the net positive arises from the promotion of a greater spread of ownership. So.
Yes. And Liberty, you were challenged on your enthusiasm about the potential of these amendments.
So I must make one other declaration. So I joined Doris and the others in a team that was meant to draft the amendments. So the optimism comes from there. So it's a baby that I have to see grow, and a baby that I'll see grow sitting in the tribunal nowadays. I think that's a nice opportunity. But I think I did say that we have particular brutal facts, which is inequality, and I think, Tembega, we agree on the inequality challenge. Owners and executives, you know, they earn many multiples more than your ordinary worker. So in that context, this is the only, if you're thinking of broad public policy, all other public policies come with costs. So you may talk, you know, the popular ones now are, you know, a grant, the 300 rands to everyone. Those opposed will raise a lot of cost issues around it being a tax and funding and so on. What this major regime offers, unlike many other areas of public policy, is something that is almost like a free lunch. I am tempted to say that because I wanted to say a free lunch, but it's almost a free lunch. It doesn't come with the same costs, notwithstanding what Clevo spoke about in terms of just small change issues. But it has a bigger societal impact in terms of transformation. So that is where the optimism comes in. Can I respond to Langa and Tamara? Because I thought...
Yes, you can respond, and maybe just take the opportunity to make your closing remark.
Okay. So
that we don't have...
Langa raised interesting points around funding, but sort of challenged me in a way that I had not prior to coming to and sitting here. So I don't feel like we've reached a steady state in the design of ESOPs. I think we are very far. What I do acknowledge, though, is there is an off-the-shelf solution, which is what the Commission is advocating, which is what Tamara was speaking about, something that is an employee-based trust type thing. And it seems to be what has been flying if you look at those conditions that have involved ESOPs. So in that world where, you know, people complain around complexity, there is at least an off-the-shelf. But I, like you, Langa, also have questions around design. So one of my key questions is, you know, how many people should benefit? Are we designing the benefits, you know, issue quite well? Take an instance where, you know, the amount is fixed, say, let's say 8%, the amount of shareholding that workers can earn. But there are so many workers that individually, you know, they're not getting much out of it. So those are design issues. I'm also sometimes even worried about, you know, someone who resigns and doesn't get much, but was told, you know, they were a co-owner of this firm, meaningless in practice, meaningful in paper. Optimist goes around, you know, platforms saying something is being delivered, but actually nothing is being delivered. Then to the debate that Lebo and Tamara had, which I found very interesting, and Tamara, I had not thought about that debate quite in the way that you put it. So the net positive obligation, I think it's one that I'm going to take forward after today. But I do wonder, and I'm not sure where this guidance comes in. So, you know, I said here, I had this thing at the back of my head that if I was looking at a transaction, I would look at public interest from a setting that said no one of those 5 takes precedence, but what the person needs to do is to weigh all of them in aggregate. In a world where you're saying, no, but you know, the others are not as strong as promotion of a greater spread of ownership, how does one think about that? Do I still have to balance my 5 factors, or do I just, you know, so I saw you push the boundary on Burger King, and I see you pushing the boundary again but I hope this time it will be argued with Temberger as your counsel.
Yes, thank you. Lebo, brief closing remarks and then...
Yeah.
Yes.
Thank you. So there's no time to go into Shell TEPCO.
No, there isn't actually. We are living on borrowed time.
No, there isn't. So I won't try to do that. What I wanted to say is that when I started speaking, I said that we haven't seen an official position from the Commission on this approach to this day, right? So this is the world we found ourselves in. And I think what concerned me in some of Tamara's remarks is, the use of language like, obviously we'll take this issue into account. It's only obvious to the Commission, not to the practitioners. It puts us in a very difficult position. What clients want when they come to us is really three things. One, assurance that there's integrity in the process. Two, that the process can be predicted to some reasonable level. Right? And three, that there is transparency. But we can't even advise on that when all of us are having different experiences with the Commission on similar issues. But even more so when certain clients are actually better than most, where they've actually already said, no, we're going to have an ESOP, we're going to do this. So they've already said that. But at least in my experience, in a recent transaction, what we found was that the Commission wasn't really made us work harder than we had to in a situation where you actually had a client that was responsible, because essentially the Commission says, these are the design principles. You accept the design principles. And then they say to you, when you want to implement, you must bring us the paperwork first. So bring the SPV so that we can satisfy ourselves that it's what it's supposed to be. And we said, okay, we'll do that. And then we said, okay, if the Commission doesn't come back to us within 60 days to say whether or not the Commission agrees on this issue, then we are entitled to implement. And it was very difficult to get the Commission to get to that position where they said, okay. So the question is, isn't part of the issues around design principles and furthering these imperatives also the responsibility on the Commission to actually work with parties where parties have actually done the work, or they've shown good faith at least?
All right.
Yeah.
I think Darius and Tony, you've kind of had your closing. Langa, you said you were happy with the one question. Do you want a brief closing?
Yeah, if I can say one thing in closing, I think ultimately speaking on behalf of financiers everywhere, we wish to do the right thing. We definitely want to come to a place, or at least some of us, to a place where we can make society better. We see the direct benefits that come from employee participation in ownership. We see the benefits that come from diversity on our boards. We see the benefits that come from legislation like this. I would also like to put it out there that to a significant extent, we are finding, as black-owned private equity funds in the list, a better environment for us to be able to transact because of the public benefit clauses that have been introduced by the Competition Commission. Because ultimately now when we're having conversations with the companies we're investing in, we're able not only when they want to rebut the good story that this is, to say, okay, ignore that, this is legislation. And then my parting shot will be, the former commissioner, there's a job for you managing our submissions if you want it.
Thank you. And thanks very much to the panel for this session. And back to you, MC. Thanks very much.
Thank you all very, very much. While they take their parting photograph on the panel, I'm going to take this opportunity to actually make my own comment, if you don't mind. But I think is something that, and perhaps I align myself with Liberty because he is my boss, is this idea that we could be robbing Peter to pay Paul, and still not getting to the core issue, which is to actually deal with white monopoly capital and to deal with a redistribution. So I really value that input very, very much. Please do feel free to stand and take your photograph so that I have an excuse to make my ad-libs. Also, this is the last you'll hear from me on this podium. So I want to thank you all for pretty much making my dreams come true. It has been an absolute pleasure to be able to deal with such complex issues that are important to us all in a way that is collegial, familial even. You know, it really did feel like a reunion, this conference. And in a way that is rooted in the same fundamental principles. I think what Langa said right at the end was exactly the thrust that we have here, which is we're all coming from the same basis of wanting to make South Africa a better place. On that note, you should be aware that there will be cocktails in the networking session. I was informed, I need to let you know, there will be cocktails alongside the networking. So I do hope you join us. And for the final word of today, we will be hearing from the chairperson of the Competition Tribunal. Please, round of applause in welcoming Ms. Mondo Mazwai.
So good afternoon once again, ladies and gentlemen. We have very quickly come to the end of an exciting 2 days where we were reflecting on the usual annual conference, but this one had a different element and angle to it because we were also reflecting on the 9 years of Thembi's leadership and the success that the Commission has had in that period. Thembi did say earlier today that if there were any glitches in the conference today, it's on Doris. So Doris, congratulations for a very successful first day on the job. But having said that, I think we also will remember from the panel this morning that spoke about the importance of building state institutions that are high performing, that one of the success tools is to build for the future. And so that's exactly what Thembi Nkosi did. And so Thembi also deserves a very warm round of applause for a successful conference. Yesterday, the minister set the scene with a detailed opening address about the state of the economy and the role competition policy can play as an instrument to facilitate growth and inclusivity. Of course, that is not the only instrument, and other instruments must complement competition policy. The expanded provisions of the Competition Act under the new amendments aim to address the levels of concentration and economic exclusion that remains almost 25 years since the Competition Act came into force. The panel yesterday, on which Elena was, reinforced that South Africa is not alone in addressing public interest goals in competition legislation. So while jurisdictions may differ on their approaches on these societal goals, whether you take a narrow or wide view of consumer welfare, whether you include equality and sustainability, there is global consensus that competition regulation is not business as usual. So market concentration, digital markets, food scarcity, and global supply chains are on the agenda of every competition authority. All these have been precipitated to some extent by COVID-19. And the work of the competition authorities in the next year will be to attempt to address these challenges. I don't want to raise some of the debates and the discourse that were had in the various sessions, in the plenaries, in the engagements, in the corridors, throughout the past 2 days. But it is my sincere hope that when we meet again next year, we will have answers to some of the burning questions that were asked, particularly Makhale's question, what is this? What is this? And on the issue of greater participation, which is an important issue, and participation through ESOPs or through other means such as BE transactions in mergers, that is something that by the time we get together again next year, we hope to have had enough lessons learned. There has been a call to have some guidelines from the Commission, and so what I can assure you is that, of course, for us as the tribunal, we will listen to the debates and the discourse in due course when the matters come to us. And our role will be to interpret the law in a clear, consistent, transparent, and predictable way so that we can achieve competitive and inclusive markets. So I want to take the opportunity again to thank Thembi for his selfless dedication to the competition authorities and the legacy he has built for the institution. I take the opportunity once again to congratulate Doris, and the conversation with Dennis this morning, even though I know Doris as a friend, I had goosebumps listening to the engagement. It was fascinating, and I hope we have all gained insights into who Doris is and the wealth of experience she brings to the position. All this speaks to the seamless transition we can expect in the Commission as Doris takes the lead from today. The success of the amendments in achieving the ambitious but necessary goals in the Competition Act and the extensive work done by the Commission is directly linked to the resourcing of the tribunal and the courts. Amending the Act and expanding the scope and mandate of the competition authorities without concomitant funding and investing in critical human capital runs the risk of undoing the gains of the amendments and the Act in general. So in a letter from the Cathedral of Milan, author Bill Shaw speaks of lessons we can learn from building temples. He wrote this while looking at the cathedral, and he was inspired not only because of the sheer size of the cathedral, built over a 500-year period, but by the unseen work of building every aspect of it. The quarrying and the transporting of marble hundreds of miles on ox carts, the painstaking chiseling by sculptors, stone cutters, carpenters. What we can learn from this are the values of patience, hard work, altruism, selflessness, and community, and importantly, the knowledge that we are contributing to a goal greater than ourselves. A lot of work goes into building and advancing every aspect of the competition agencies in South Africa to serve our people so that all have an opportunity to participate in the economy, to have access to the quality and variety of goods they desire, as well as competitive prices and product choices, whilst promoting the public interest. So I take this opportunity to encourage the people in this room to follow on Doris's lead and put their hands up to serve on the tribunal, in any of the competition agencies, for the greater good of the system and the durability of it, the sustainability of it. So there is indeed much thought to be gained from this conference as we rethink competition policy in the context of the new economic climate. So with that said, I just want to then wish all the contributors to the conference my sincere gratitude, and I express this on behalf also of the outgoing commissioner and the incoming commissioner. So I will not mention people by name because I don't want to single out anyone and leave anyone out. So to the international speakers who have traveled from far away, we thank you and we hope you have a safe journey back home. To the facilitators of the plenaries, thank you for a job well done. To the panelists, thank you. The staff of the tribunal that has been providing support in the background, the staff of the commission that has been running with the planning and logistics of the conference, and program directors, Mpumi and Songesa get a mention. Everyone else doesn't get a name. A mention because you both navigated the program with energy and enthusiasm, and we thank you very much for that. To everyone else, thank you for your attendance and travel back safely. Mpumi announced that there will be drinks afterwards, so we hope to see you there. Thank you very much. That closes the conference.